tuwe na zile mitambo za masikio.
Watatuletea. Wanaleta.
Sawa sawa. Walipotengeneza kuweka jamu zile microwave. Sawa sawa.
Yeah.
Can you hear me?
We are on channel 5 for the session.
Ndio kuitwa.
Atanas. Niletee hiyo.
So we wait for like 2 minutes before we start. My name is Dr. Nazaris Kirama. I'll be moderating the session, and my fellow Daniel Turan will be moderating online, and Atanas will be our rapporteur. And I would like to take this opportunity to welcome all of you to this very important session. And this session is happening for the first time during the lifetime of the Internet Governance Forum. It is the first time that we're going to have this, and we hope that next year it is going to be bigger and
Full of judges.
and the years after that. If you can put on the presentation, please.
Just a
Just a moment. So like say at the beginning, my name is Naza Ryusik Nicholas Kirama, aka Naza Nicholas. That is my digital identity name. And today I'm going to be your pilot, and I have my co-pilot, Mr. Duran from Italy. And today we are going to have a session on judges on human rights online. And the overview of the session at this time when we live in the age of artificial intelligence, the digital age actually presents challenges that requires safeguards on human rights online. And when you are talking about things like privacy, freedom of expression, and digital inclusions are some key issues that need to be taken into account. So our session will focus on actually ways in which we can empower judges to address digital rights, and also we will explore some legal frameworks for inclusion. Like you see at the beginning, I said the judiciary, since the formation of the Internet Governance Forum in 2005, the judiciary has not been engaged in this space. I don't know if it is because of that notion of independence of the judiciary, but the judiciary, as one of the 4 branches of government, needs to be included in this space so they can not only learn but also engage properly in the debates for how the internet should be governed. So our attempt as a Tanzania Internet Governance Forum is to engage judges, and we have had 2 initiatives that are aiming for that. So you can see in the IGF multi-stakeholder model, we are bringing the judiciary to be part of yes. Just a moment. So what we are expecting, decision objectives like will be you can hear me?
Fine. It's interrupting. Interrupting in between.
Can you hear me now? Okay. The aim of session operation for the Can you hear me? Okay. If you can hear me, it's fine. So the aim of this session is to make sure that we engage as many stakeholders for collaboration and to protect digital rights online. And the objectives is to adapt legal systems to safeguard privacy and freedom of expression, address cross-border enforcement challenges, foster inclusive policy for marginalized communities, and build the judicial capacity in internet governance. So these are the kind of objectives that we are going to attempt to address through our esteemed panels. And the expected outcomes, we believe that with all these insights from the speakers, we will be able to address the legal systems better and also engage in terms of privacy and freedom of expression. Judicial collaboration is one of the expected outcome in terms of roadmap for cross-border cooperation in enforcing digital rights consistently and fairly. Inclusivity in digital policies, that these are the kind of recommendations that we expect in terms of inclusive laws addressing marginalized and disabled communities to prevent digital exclusion. And finally, the final expected outcome, identification of tools and strategies to enhance judicial engagement in internet governance. I would like to take this opportunity to thank all of our session makers, including Honorable Dr. Judge Eliamani Laltaika for the input, myself, Rachel Magege, who is joining us from online, Daniel Tura from Italy, who is our online moderator, Atanas Bazihire, who is on-site rapporteur, is around here, Dr. Martin Koyabe, who is our cybersecurity expert, sorry for the typo, and Pamela Chogo, who is a lecturer and a rapporteur online. We are also very glad today and to introduce to you the new baby in town, the Judiciary Global School on Internet Governance, which has been registered by the Dynamic Coalitions of School on Internet Governance. This basically is a platform for judges to learn about internet governance, and it is an initiative of Tanzania IGF, ISOP Tanzania chapter, and the Organization for Digital Africa. And we thank Dr. Iliamani, Honorable Judge from the High Court of Tanzania, for his enormous input and counsel on this initiative. So in the years ahead, we expect to continue to train judges from various jurisdictions around the world. And we look forward to engage in this critical branch of government in the IG space. And we thank all of them for the opportunity that we have created to engage judges in this space. Now, I would like to take this opportunity to introduce our speakers. The speakers will have like 1 minute to introduce themselves. You can say your name, your expertise, and the organization you come from, and then from there we will continue. Welcome to the session, ladies and gentlemen, and I look forward to your interaction. We'll have a Q&A session, and we look forward to receiving your questions, and we hope and believe that what we have in front of you are speakers who are very capable of answering and interacting with these questions. Thank you. We start with Umar from Pakistan, Advocate Umar from Pakistan.
Hello. Thank you so much, moderator of this session. This is Advocate Umarhan Utmanzai, basically belong to Peshawar, Pakistan, practicing law at the Peshawar High Court. Along with that, I'm running a civil society organization with the name Citizen Rights and Advocacy Forum CRAP, which basically targeted the awareness for the sensitization of the citizen rights, digital rights, and privacy protection is one of our objective. Sensitizing the local community that accesses to the internet, free and fair internet is your right. Along with that, how can we protect them? How can we sensitize them in terms of the cyberbullying, especially the women which are very vulnerable in Pakistan? So this is what we are doing. Along with that, I'm taking the cyber cases in Pakistan. And so this is what we are doing in Pakistan. Thank you.
Dr. Koyabe.
Yeah, thank you very much, Naz. And first of all, let me take this opportunity on behalf of the Global Forum on Cyber Expertise, where I work and consult for, to really thank the organizers and Judge for actually pushing. And this idea, remember, we talked about it in Kigali at some point, but I'm really glad to see it here. So my name is Dr. Martin Koyabe. My real area of functionality is cybersecurity. I've worked in Africa extensively in a number of countries, specifically looking at strategy development, looking at digital transformation programs, but more importantly, building the ICT sector within the continent. We'll talk more within this session, and I'm really pleased to see some of you here today. Thank you.
Thank you very much, facilitator. My name is Eliamani Isayal Altaika. I'm a judge of the High Court of Tanzania and an adjunct faculty member of the Nelson Mandela African Institute of Science and Technology, where I taught for at least 10 years cybersecurity law, bioethics, and the other law-related courses to scientists. And it's true that I am like we will discuss, I very much believe that without engaging judges, while building the digital economy, we will be shooting ourselves in the leg, because if you have very good policies, very good laws, and you bring a case before a judge, and that judge cannot even tell what a mouse is from another device, then you are just doing nothing. So I believe that judges are a fulcrum of any attempt to protect rights, be it digital or physical. And it is therefore my firm belief that in the next few years, we will have a lot of judges interested in these things, and that is better for humanity. I have a dream.
Thank you so much, Judge, and for always being there for us. I know we have had a lot to work on in terms of making the dream that Dr. Koyabe was talking about. In Kigali, it was just a dream, but now it is a reality. And we hope to continue to borrow your wisdom, Dr. Koyabe, in terms of engaging the judges into the internet governance space. Now, I will start with questions to our able speakers. I will start with you, Honorable Eliamani. Could you tell us why you have been advocating for inclusion of the judiciary in the IGF? I mean, why is it important?
Yeah. Thank you very much. Hello?
Yeah, can hear you.
Yeah, thank you very much. Like I said, this is really something very close to my heart, and it has a personal story. After my PhD, I was employed by the Nelson Mandela African Institution of Science and Technology. It is one in a network of Nelson Mandela institutions across the continent. Our elder Mandela had a dream of making Africa a hub of skills and knowledge and capabilities in STEM, science, technology, engineering, and mathematics. So he engaged with funders and donors from across the world, and through IMF and World Bank, they wrote a concept note of establishing the MIT of Africa. And they said, okay, we really cannot have one single MIT for the whole of Africa, because language barriers, there are countries which are Arabic, others are French, others are English, others are Portuguese. We also cannot have one MIT for the whole continent, because education systems differ. At the end, they decided to establish 4 institutions. And I'm very glad that through diplomacy and efforts of the government of Tanzania by then, through President Jakaya Mrisho Kikwete, who before that was Minister of Foreign Affairs, one of those prestigious institutions was established in my hometown of Arusha. And as soon as I finished my PhD, I got into this institution, and I was tasked with preparing curriculum and the course outlines to teach cyber security law, intellectual property, bioethics, and every other law that is required by scientists. It was during reading materials available in the cases that I discovered that there was a huge knowledge gap between judges or lawyers on one hand and the scientists. So from there, I became a link to try and bridge the gap. And I conducted many seminars with the Law Society and also with the judges to try and alert them on fundamental issues related to ICT. So now I didn't know that I will become a judge by then. But 5 years, 6 years later, I was appointed by the president to become a judge of the High Court in 2021. And my friend Nazar Kirama, doctor here, used to work with me for Tanzania IGF before he became a judge. So one day he came very humbly and tried to ask me whether after being a judge I would still come to IGF. And he was almost trembling. So I just gave him a hug and said, please sit down. It's okay. I'm still the same Eliamani. Don't worry. And we traveled with him to Kigali, where Dr. Koyabe is saying. And throughout that trip, I was saying, I need to have judges inclusive because I'm the only one who is getting this knowledge. And luckily, we traveled to Kyoto. And during the closing ceremony of the last year's IGF, I was given a platform to during the closing ceremony. And after Prime Minister Suzuki, I took the stage and I made a joke. I said, there are about 9,000 people here, but I'm the only judge. What happens? I really pray that next year we have more judges. And I'm very glad that the IGF Secretariat took this very seriously, and they wrote me an email back in Tanzania and said, we have started. Your colleague, Dr. Kirama Nazar, has brought a proposition, but also today at 12, you will see now another session established by IGF, which will compare the ethics of judges and the use of artificial intelligence. Because some judges are afraid of coming here because they think artificial intelligence is eroding their ethical values. So we have a session today to answer, does use of AI make you a better judge or a worse judge? And we will have a very open discussion to make sure that judges all over the world gain confidence in coming with us. I will stop for now because I have so many stories to tell.
Thank you so much, Judge Loltaika. And I think you are one of the judges that I could dare say that you're a judge down to earth. We have Advocate Rachel Magege trying to join us online, and as soon as she joins us, we will have her introduce herself to you guys, and we continue with Advocate Uma from from Pakistan. Advocate Uma, I know you have been in the space of your lawyering for several years. And do you think judges need to learn new tools of statutory interpretation to accommodate human rights in the digital space?
Yeah, Nazar, you know that the digital world is growing rapidly, and not just law, every field is going to adopt it. So I believe that being in the field of legal paternity from the last 3 years, it is very mandatory for the judges as well to adopt the new tools just to face those to trial and deal with the cases related to cybercrime and other issues. Because in the traditional system of law, you cannot have such opportunities to trial cases related to hate speech, freedom of expression. So there are issues like we have seen the IGF Secretariat has established the the Charter of Human Rights and Principle for the Internet, which has been delivered through the UDHR 1948, which is important. So I think those who rights we have been available to the citizens, to the humans under the UDHR now have been came through the Charter of the Human Rights and Principle for the Internet. So I believe that being a judge, you have to be aware of the tools of those things which are not developing. The way the internet has developed, the way the AI, no, not just internet, no, the AI and the coming in there, we will have furthermore things in the era. So I believe that for the judge, it is very important to adopt herself with the tools which are going to help the citizen in the field of law. And for the judges who are going to deliver the justice, the more important is one of the important stakeholders. The way the Judge High Court Tanzania has mentioned it in a very brilliant way, that why he has always in the it has always in an interest to work on the digital rights. So I believe that in the coming year or in the nowadays, it is very important for the judges to adopt with the technology, with the new tools to interpret the laws. And I believe that the traditional, the old laws do not answer and address the issues which are currently in the system of the digital world.
Thank you, Advocate Umar. And I think that is very important for judges to be able to keep abreast with the emerging technologies and the tools that they need to deliver justice on time. Because we know justice delayed is justice denied. And, technology and technological tools have this capacity to be able to shorten the time with which the justice can be delivered. Now we have Madam Advocate Rachel Magege. Can you hear us?
Yes. Good morning. I can hear you loud and clear. Can you hear me?
Thank you. Yes, we can hear you, Rachel. Thank you so much
Thank
for
you.
joining us online. And if we can take 1 minute to introduce yourself and your institution. And if you can answer this question after that, the advocate, can gender-based violence be exacerbated online? That will be your question after your introduction.
All right.
Welcome. Yes.
Thank you so much, and good morning to everyone. I am Rachel Magege. I am a Tanzanian citizen, and I am a lawyer. My areas of practice are in data protection, data governance more generally, and I am very, very honored to be a part of this panel and a part of this conversation. I sit on the board of directors under the Tanzania Privacy Professionals Association. We have an association of privacy and data protection experts in the country. And so I'm really glad to be having this conversation. So Mr. Nazarius, on your question about gender-based violence and the digital and online platform, absolutely, gender-based violence can be further moved and amplified and can become even much greater because of all of these different digital and online platforms. It is very important for people to know that many times what happens in the physical is what is going to move and happen even in the online and digital spaces. Likewise, what happens in the online spaces with people who do not even know each other, with regards to perpetuating harassment and bullying to specific genders also can move into the physical. So I'm usually very sensitive about this topic with the many clients and the many people that we talk to, but even in the judiciary sector, because already if you're looking at, for example, the physical space where with different backgrounds, with different relationships and different structures like that, if it's already happening in the physical and you have an institution that wants to introduce artificial intelligence or other different technologies, that same mindset is still going to happen even in the online and digital platforms. So it's very important to make sure that in as much as people are working towards understanding and learning these emerging technologies, they also need to understand and learn more about themselves and about the biases that they carry, which can transfer even into the digital and online space. That's a very brief response I can give for now. I'm happy to answer more questions as they come. Thank you.
Thank you very much, Advocate Rachel, for your contribution. And indeed, I was, tickled by what Honorable Judge said at the beginning, that it is very important for the judiciary to be engaged in terms of all these issues. Because the cases about either internet or internet related issues will always end up in courts. So the good umpire would always be the one that knows the issues, and this is what we are trying to achieve in terms of engagement of the judiciary in the IG internet governance space. Honorable Judge, how can the government make sure that privacy laws keep up with the fast changing technology? Because now we have artificial intelligence, we have all these blockchains, and there is a resistance against or for. How can these governments from across various jurisdictions keep up with the fast changing technology?
Much, facilitator. One of the issues that are important for the judiciaries to do is to breathe life to legislation. When a law is enacted, be it at international level or at national level, it is a document which is more or less formless. The definitions are vague, the rights are not understandable. Sometimes if it's an international instrument, it can stay in the cupboards for many years. But as soon as this law goes to the court, the court gives an interpretation. It breathes life. It makes that law something that people can relate with. And that is what we are trying to do currently with the data protection and privacy laws. For example, the first thing that people do not distinguish out there, lay people and many of our technocrats, is that data protection and privacy are totally different. Many people think data protection and privacy are the same. They are not. Before a judge knows that privacy is part of the human rights, but data protection and the protection of one's information is a fundamental right. If you look at the European Convention, this is Article 7, Article 8, and they are totally different. In our country, for example, in Tanzania, all data protection cases start with the commission, because it's a fundamental right that is protected administratively. But if you have a human right issue, you go direct to the High Court. You don't even go to the administrative procedures. You will, if a lower court recognizes that they have a case touching on fundamental human rights, they immediately ask you to go to the High Court. So at the moment, what I'm seeing throughout jurisdictions is that judges are defining concepts. Judges are clarifying concepts. Judges are laying down the foundations of integrating fundamental privacy and the data protection laws within the larger fabric. However, since breaches are done by the private sector, it is the private sector which manufactures these gadgets you are saying. But it is the role of the government to regulate them. The court stands there as an umpire to say, okay, the manufacturer is responsible for protecting privacy. When you release a headset or a computer or whatever gadget, it is upon the regulator to make sure
But how it is preserved, and even it is stored in digital form in zeros and ones. So what that means, there's a huge fundamental challenge in how we actually handle the digital evidence. The second issue is that it is very volatile, because if you either change the time when it is stored, if you move it from one point to another, it might actually alter the actual evidence that is attributed to that digital evidence. There are some specific areas that need to be considered. It also traverses boundaries, because you can carry digital evidence in a USB, you can carry it in a memory stick, you can carry it on any other device, and then move it from one jurisdiction to another. And that brings huge amount of challenges when it comes to the judgment, when it comes to how we have to handle that issue. So therefore, the collection of evidence, the processing of evidence, has to be based on the principles that have been agreed across jurisdictions. There is also the challenge of the dependency of digital evidence on technology. You will need a device, or at least something that will interpret what is referred to as digital evidence into a form that is admissible. And therefore, the authenticity that the judge talked about of that device being used to interpret that digital evidence becomes fundamental. And therefore, it is important that we understand that we are entering a very different realm of association and where we are going when it comes to the issues of evidence that is admissible in court. The other issue that we have to be cognizant of is that when you consider the digital evidence and when you look at how we need to make sure that we are able to admit it in court, then the preservation of that evidence becomes fundamental. And all these requires what we call expertise, some expertise in terms of processing digital evidence officers, and so forth. And then the last point that I wanted to point out is that we have a duty for those of us who work with the law courts, give evidence, and even for the government to ensure that the experts that we have who provide maybe expertise in courts, who provide what we call the forensic expertise within the judicial system are compensated well enough so that we can preserve that knowledge in this particular institution. So that's how I view the whole concept of digital evidence and how fundamental it is when it comes to having court cases that are very, very fundamental. Let me just give you an example just before I end of what happened in a country that I know of where there was evidence of a crime that had occurred in a specific room. And this evidence was actually on the screens of the computer. But because the collection was so rudimental, the police and other officers who went to collect this evidence simply plugged the cables from the wall and everything. And therefore, what was on the screen disappeared, which was critical for judgment within the law courts. So there's that bit. There's also the issue around when you issue a court order. In some cases, court orders are supposed to be issued in written form. So some laws are so arcane, they cannot accept any other form of court order unless it has been written and delivered to the individual person who is supposed to appear. So we have fundamental differences in how we need to update our courts, our judges, and also our legal framework. But we'll come to that issue at some point. Thank you.
Thank you, Dr. Koyabe. And I think now we are almost going to finish this first segment of the presentations from the speakers. And before we take the questions, I would like to ask Advocate Rachel, what steps can policymakers take to ensure people with disabilities and marginalized groups have equal access to digital tools and services?
All right. Thank you so much for that question. Here's what I'm going to say. A lot of frameworks and laws and regulations, subsidiary legislations have already been put in place. And whereas it is good to have a specific law that mentions a specific person or group of people, what I see as more beneficial is for policymakers to continuously remind and maybe even educate the implementers and the regulators to be very creative and deliberate in how they carry out the provisions of the law. Yes, because it is good to say that we would want a specific law on digital platforms and the digital innovation space to say this and this about people with disabilities or the elderly and this and that. But if you already have a law, for example, the People with Disabilities Act, yes, and it's very general, as with many.
Advocate Rachel, I think we lost you. Hello? Anyway, I think we can proceed. And did we lose her? Anyway, I think I will continue with Advocate Advocate Umar on is Rachel online? No? Okay.
I am back now. Can you hear me, sir?
Yes. We can hear
My
you.
sincere apologies. The Zoom link just threw me out, but I'm back now. Let me just quickly wrap up my submission on this. So what I was saying was that as long as you have laws that are already in place, the implementers and the regulators have to be very creative in knowing that, for example, I have a provision that says everyone needs to have access to clean and safe water. All right. You, as the implementer, as a regulator, are going to go to a place where you will have little children, you will have the elderly, you will have people with physical disabilities, maybe may not have people who may have visual impairment, hearing impairment, and things like that. You have to be very creative into looking at all of these different groups and seeing that in order for all of them to get clean water, this person is going to need this person is going to need that, this person will need extra assistance in this, but at the end of the day, all of them get water. So it is the very same with digital platforms and with the digital space. And we're already seeing a lot of these creative things come up once again, because what you are doing is, at the end of the day, the policymakers will get to say, we have created this law, and we're already seeing that when it is executed and implemented, that maybe young students or young girls or people with disabilities are all having their needs met, but in a different way as required for each of their different needs. So that's the biggest thing that I would say, Mr. Nazarias. I know Tanzania has already been working on a number of different legislation for the benefit of the members in the audience to know, and currently the Ministry of ICT is working on a national artificial intelligence framework and strategy. I do remember sitting down with them and with some development partners where we advised them that in as much as you are now, the ministry is now conducting different assessments and different needs assessment and impacts in the country, you have to make sure that this law and this framework that you are creating, first of all, aligns with all of the other ICT frameworks in the country, and especially with the Data Protection Act of Tanzania, but also make sure that it caters to every different group of people. So that is the feedback that I can give right now. And I know that once a regulator, once an implementer, the commission, a regional commission, district commissioner, once they are creative in how they carry out this law, it is actually also going to reduce the number of complaints and lawsuits that Dr. Laitaka gets and receives in court. It's going to reduce that a lot, because you will see that this implementer, this government official, has actually taken the time to understand and see what the policies have and what different groups of people need and how those different needs can be met. Thank you very much.
Thank you, Advocate, for bringing the pieces from the perspective of marginalized and groups and sections of the society. Now we are going to go to the audience, but before we go to the audience in the room, we'd like to have a question from Zoom. There is a person from Zoom. There is a question for the court, for the judge. So if
can you hear me?
Yes.
So we have a question for our Honorable Judge Eliamani. Nena is asking, what perspectives are there for the use of AI to support, refine, clarify, enhance, influence decisions for judges? This is a question from an operational point of view.
Judge, that comes to you.
Thank you very much for that brilliant question from our Zoom attendant. It is now an open secret that AI is used in the courtroom, including by judges and their assistants. However, there are no guidelines yet and there are no regulations. And there are very, very different perspectives on how jurisdictions are embracing artificial intelligence. Within the East African community, and I'm not going to mention countries here, there's in one country a high court judge was summoned by the disciplinary committee because a part of his judgment was allegedly written by ChatGPT. I think there were a 4 and a 0 that looked like ChatGPT 4, and some sentences which were not very legal. And he was called to answer, and many lawyers have been reprimanded, and they got scared. Within the same East African community, just across the board, our Chief Justice is saying, please embrace generative AI. Make use of them to clarify what presentations by lawyers, and at the end of the day, you are responsible in what you say, but use any tools. Now we are not sure what happens because these are countries sharing the border, sharing history of development of law from the British. However, luckily, we now have UNESCO. You talked yesterday when we were launching the guidelines for use of AI by judiciaries that is being pioneered by UNESCO. I hope that in the next few months or 2 years down the lane, we will have clear guidelines. To answer specifically, from my jurisdiction, we are using artificial intelligence in the court in Tanzania for at least 4 ways. One, scheduling. We no longer put our schedules manually. It is automated. There is electronic management system where I know the cases that will come to my chamber 2 weeks or next month because they are just automated. Secondly, is assigning cases. The judge in charge is no longer the only person who assigns cases. In the past, people would say, this boss is giving me very difficult cases with advocates who are so complainants. Nowadays, it is the artificial intelligence which just says judge 1, judge 2, judge 3. Cases are filed. The artificial intelligence says Laltaika, so and so, so and so. So you are sure that there is no bias. You handle your file very well. Thirdly, we use artificial intelligence in language translation. Our country uses Kiswahili, which is the national language, but the court language of the court is English. So if someone speaks, we already have we have deployed TTS, transcriber and translation systems, where you can transcribe what a person is writing and take back to. And thirdly, we use it intensively for research. And I said yesterday that when ChatGPT started in 2022, 2021, it was very inaccurate. You would get fake cases. It would come up with cases which are not anywhere in the law reports, but things have changed dramatically. Now you can be very sure that it provides you with cases that have been decided by the Court of Appeal of Tanzania, and only the judge at last to go and say this is relevant here, this is not. And thirdly, or to finalize that, we are actually using AI to predict weather and to get the simplified language of texts, including legislations or acts of parliament.
Thank you, Judge, for your critical intervention. And now I would like to open Q&A to the audience in the room. If you have any question to any of the panelists, you are welcome to do that. I see a hand. Please, if you can get a microphone to
You hear me?
Yeah, we can hear you.
Thank you so much. Thank you so much. Really appreciate it. This has been a very interesting conversation. I also attended the other session on AI in judiciary with Honorable Judge as well. I personally learned a lot, and thank you for the other panelists as well. I just wanted to comment because we tend to talk a lot about a specific context, but there are other countries that they have a different context, for example, in terms of their maturity to use technology. And I'm from obviously I'm from Iraq, and I wanted to talk about first the political will in the country to use technology, and the judiciary. I know that they're independent, but they are always affiliated somehow with the political, in line with the political will. Before going to the question, I wanted to comment what Honorable Judge also said, that it's unfortunate that we don't have many judges actually, or lawyers or legal practitioners, even in the room. You see that we are very few. So hopefully in the next year, we will have more judges and more lawyers and more legal practitioners in the room to share their experiences and views on that. My question will be for the Honorable Judge. Because we are advocating to bring all the stakeholders, like in my country, for example, to including the judiciary. For a judge who have been heavily depending on paper and not using technology, as you mentioned in the beginning of your speech, how would you convince someone who needs to change all this, who needs to spend more time to learn technology, to hire experts to the reserve evidence, for example, analyze evidence and things like that? What are the main three arguments, let's say, that you will be using when you advocate for that change? And the other question, do you think at the beginning judges will need, like in addition to investigators, will need someone who will be tech savvy, for example, to help with all these kind of evidence? Thank you so much.
A very, very loaded question, I might say. And I think, is it a consensus that we answer questions as they come, or we take questions first and then they answer? Which one should we take? As they come. Is that a consensus? Because I am a democratic
yes,
moderator.
it's okay. It's okay with me. Thank you.
Okay, thank you so much. Judge, if you can intervene, please.
Okay, very quickly, thank you very, very much for that question. Unfortunately, it is true that we are not in isolation. Judiciary, the old-fashioned way of saying separation of powers, it doesn't work. I am from the judiciary, my colleague is a minister, we work together. So I meet my minister and say, okay, look here, this is the law you are proposing. It doesn't work our way, so do this. That's what is happening in the UK. That's what is happening in the US. But if you follow a very strict kind of separation of powers, you will be left. So, and everyone has to start somewhere. Those judges who are so based on paper and writing and are slow can be encouraged to start small. In our country, it is mandatory for every judge to use a computer. It's you cannot avoid, because our Chief Justice is a former professor of law at the University of Dar es Salaam, is at least 10 times techier than me. You can confuse him with a computer scientist because he talks about data protection, everything, and he's the one who has brought Tanzania to that level of use of AI. And it is true, question two, we first got assistants who are young lawyers. Every judge has one legal research assistant who knows the computer and has been encouraging judges. So you can copy that model. And I welcome you to come to Tanzania to learn. We are welcoming many countries. We get at least 10 countries visiting the judiciary of Tanzania in a half a year. So you're welcome from Iraq to come and we'll deliberate how we can transfer the knowledge so far.
Yeah, thank you, Judge. I think
Mr. Nazarius?
Yes.
If I may, I had written on the chat section to add just a very quick response after the Honorable Judge, if that's okay.
Okay, go ahead.
Yes. Honorable Judge, thank you so much, as always, for your endless wisdom. And to answer this question to the gentleman who asked about what is the political will or the acceptance of these technologies, I do want to say a little something as well, if you may allow me. Of course, much with the context of Tanzania and different aspects of Africa. So because, and I'll be very honest, because there is already a fear of technology, and I'm looking at diverse groups of people. Yes, we are here sitting in this room and virtually, we are lawyers. I'm a lawyer. We have judges. We have different technology experts. But outside of us, there are so many people out there. We're looking at that digital divide. People in the rural areas, there are people with different levels even of education and access to education. But these are the same people who in one way or another may find themselves in courts for different matters and different reasons. And here you have the judiciary of Tanzania, for example, already using artificial intelligence. So how do you bridge that gap together? One of the things that I think really helps is also showing people the benefits and the good of AI. It has to be more of a narrative than what they are seeing online and on the internet or hearing from their neighbors, yes? Because if you're here and telling people or telling me that because of artificial intelligence, Honorable Judge Laitaka can now read large volumes of evidence in a shorter amount of time, that it can help him as he writes his judgments. That is already a good thing. In Tanzania, for example, one of the big benefits of AI that came in just a number of projects, one of them was from the Sokoine University of Agriculture, where a lecturer has been using artificial intelligence to quickly detect diseases in cash crops, in maize, in corn, and things like that. So if there's a language to use to already start communicating to lawyers, to court clerks, to judges, to many different members of society, that artificial intelligence can help you predict, floods that are coming in your country, can help you do this and that. I think that might be a good way, a good avenue to use to even start creating that political will for people to see and understand that artificial intelligence can be used to make life easier, and therefore frameworks to be established and this and that. So thank you so much. That was my additional contribution.
I saw a question there and over here. So you start with him and go to the gentleman over there.
Okay, thank you, moderator. I hope I'm loud enough. My question actually is it's a fallout from the Honorable Judge's response to the question from Zoom. Sorry to be putting you on the spot, but I enjoyed your response to that question. Maybe drawing from your experience in Tanzania, it is true really that from when ChatGPT started till now, there's been some level of accuracy, like you said. But even still in 2024, there is still instances drawing from experience where we find that the AI systems hallucinate and they tend to present what is not there. So then my first question is, how does the judiciary in Tanzania, take care of instances where facts are presented or authorities are presented and they do not really exist? Just a little bit of background. AI hallucination has given rise to talk about...
If you can keep your questions short,
yeah,
because of time.
Okay.
Yes.
AI hallucination has given rise to conversations around ensuring the human in and on the loop in the system. So what measures are there in the judiciary to correct, to ensure that materials presented by the AI systems are actually accurate? Then the second question, and it's going to be very short. The focus seems to be on judges from what you just said, but we also find that lawyers coming before the courts use ChatGPT for their briefs. What measures are there in place in the Tanzanian case to check that, to check accuracy in the briefs filed by lawyers in the court. Thank you.
Thank you. If we can also take to the gentleman, so these answers can be answered,
Okay, thank you. My name is Doran from the UNUE-Gov. Thank you for this very productive session and opening all these relevant questions about judiciary. I will just quickly say, because we mentioned the three branches of government, executive, legislative, and judiciary, there is common sense that the executive goes with full speed with these digitalization efforts, but judiciaries, there are some countries that catch the pace, but there are plenty of countries there it's kind of left behind. And this come where the independence is coming to place because judiciary is not strong enough to have to be financially independent from to take all the benefits from the digitalization. I will just briefly mention an example. We are teaching making courses for public prosecutors in one country, and it at the end the comments was, okay, experts, we know this is all good, data protection works, we know the rules, but the problem is we are 10 prosecutors, but we have only 3 computers. So we wait for one prosecutor to go to court, for the others to work and to write some of the things, which means that we can have access to his evidence and the other, and so much of the privacy. My question first is how we can push the executive power, the government, to understand that the judiciary needs to support the modernization, the capacity building of the judges, of the skills must be supported by the government financially, mostly. And my second one is more provocative one. How far you think we can go with the digitalization in the judiciary? I'm saying this on the service supply side. For example, can we allow people to leave their last will on using online service, or like concluding their last will or testament online? Can they conclude marriages online? How far you think, where we set the red line and we say, okay, because there is a reason why you can go and leave your last will in front of the judge and two witnesses to witness that is not under pressure. So how far you think we can go with this digitalization?
Thank you so much. If we can have the answers, and then we'll go, to the last segment of our session. We only have like 15 minutes left. So let us keep our, contribution short and intervention short as well. Thank you so much.
Okay, let me try and answer part of that question, but others I'll leave to the judge and my other panelists. I think the fundamental issue here is the starting point for many countries. And what we are seeing from Iraq and others is the need for having what we call robust frameworks, legal frameworks in the country. So for example, when you look at the case of Tanzania, for example, when they were developing their cybersecurity strategy, they were very keen that they must have those fundamental tools and instruments embedded within their strategy. So for Iraq, for example, I would urge that make sure that when you're developing your strategy and framework, you include specific areas of prescribing the type of cases that could arise, being proportionate in terms of the punishment that is allocated, and being able to have those fundamentals within that. The second thing is also to have what we call the human rights component in your framework. Things like freedom of speech, freedom of expression, being embedded within the framework and the structures of the country. And then lastly also is the area around capacity building. And capacity building, we can't argue. It is one of the key areas that we need to really look at. So what happens is you've got to have what we call the soft approach. So you take the judges, they don't like going to workshop, they want to go for retreats. So take them where they want to go to, so that you can be able to impact on the judges in a gradual manner. And take the judiciary, take the legislators, take the executive, and then train them within that concept, so that each of them can see an equitable contribution towards the functioning of what's supposed to happen. In terms of the budget, which I've heard here, there has to be a concerted effort politically to be able to support the judiciary to automate its systems. There are so many countries that have broken the backlog of cases. They are really efficient in terms of how they process issues. it brings also the benefit to the citizens because their cases can be heard quicker. There are also cases where platforms have moved. We are now having cases being done online. So the idea about budgetary allocation is critical. But let me also come to the technical people who describe these things to the executives. I think we have a duty as technical people in the room, how we describe and also how we explain problems. If you go to a politician doesn't want to hear man in the middle attack, I don't know what sort of sophistication. No, they just want to know, are we winning elections? Is there money? So there is a way of how you actually interpret these things to the people who make decisions. Like in your case, if you're trying to convince other people. Thank you.
Thank you, Judge. If you have anything to add.
Thank you very much. I really do, but I will be brief. The first question is from my brother. Hallucination is a new concept. Hallucination is a new concept in AI, generative AI, where the robot simply fails to understand what you're asking. You ask them, what are factual issues related to economic development in Tanzania? And they give you things from Mozambique. You have to tell it several times for it to come back. Hallucination is there to stay. But I want to be positive. Yeah, even in people, even among lawyers addressing judges, they can experience hallucination. And you are, counsel, did you really mean this? Anyway, on a serious matter, I want to be very positive on legal issues. That Gen AI depends on large data trained on it to become accurate. When it comes to court cases, they are massive, millions. In Tanzania, every single judgment must be uploaded online. If my principal judge gets a report that Judge Laltaika has decided 20 cases today, tomorrow he must see them online with my signature and the stamp of the court. So if you go to Tanzli, TANZLII, you will see every case I decided for the past 4 years. And AI is feeding on this to develop almost exact copy of cases of authorities I need. And that is what is happening in other countries because judgments are copyright free. The law in Tanzania says if you write anything as a judge, you cannot copyright it. It belongs to the public. That's the case in Pakistan, in Kenya, everywhere. So out of all other fields, law and AI go so well. In the next 10 years, it will be very easy to just generate something and you get almost what you would have written as a judge. However, and this brings me to the second question, it is upon you to be sure. And in Tanzania, we have 15,000 advocates. These are the guardians of law. If they see anything unusual written by a judge, they screenshot. It is sent all over. Look at this judge. What is he writing? So we are fearful. We are very afraid. So if I generate something from the internet, I will still read it so carefully to make sure that it goes there while it has gone through factual process. On the judiciary lagging behind, in Tanzania, we got out of this because we started with a strategic plan. We sat down and made a 5-year strategic plan. We identified what we need. We handed it over to the executive. The executive say, okay, now we know your needs. In the past, they didn't know exactly what we need. They would just simply give money this month, next month, but now they have a clear picture of what the judiciary needs in the next 10, 15 years. And lastly, this is a very, very difficult question to answer from my brother there on how far should we go with with digitization. If I were to decide, I would go digitization for everything. Because, for example, during COVID, many people were waiting to come and conduct their marriage or meet a judge, and the judge is afraid. I could just say, okay, raise your hand where you are. Say this solemnity. I declare you married. Then you go, you will send me a signed copy of your signature. Why should I see you? And there is a book by a professor of law from New Zealand, Australia, who has envisioned, is a visionary, is a futurologist of virtual courts. And he has written how courts will be in the next 50 years. Everything will be online. You will not need to have a lawyer come before you and you inspect them as if you are a police officer inspecting. No, you just need material. We'll be working on data, and that's how the world is moving. Thank you. I've tried to be.
Thank you, Judge. And now we go back to the last segment of our session. And Advocate Umar, I don't want to shortchange you in terms of questions. You have another question here. What challenges do judges face when handling cases about crimes, and how can they be addressed? Microphone.
So it's a very important question. Rapidly growing technology. Judges also have certain issues with the technology. In terms of the cases dealing to cyber security or cyber crime, judges are facing the complexity of the technology because judges are not well trained on the things. Like in Pakistan, if the judge sitting over here is lucky to be sitting in an area like this. In Pakistan, a judge cannot even sit in public. He is not meet the people in the public. So those who are judges in the high court are the judges from have graduated before 20,000, 1998, 1999, and 2000. So they even do not know about the internet. They do not about the AI. So there is a complexity of the technology. Along with that, the jurisdictional issues. Like if a person is sitting in Pakistan, has been harassed in somewhere outside of Pakistan, a case come before the judge, how will he trial that case? That is one of the biggest issues in the cyber cases. Along with that, the lack of precedent, like we in Pakistan have a Prevention of Electronics Crime Act, PECA, which was passed by the Parliament of Pakistan in 2016. So there are not so many cases for the judges to know that what actually. So this is the lack of the precedents. Along with that, the evidential challenges is like the cases, the evidence can be altered, can be tempered. So how will a judge look it up to it, the tempered and altered, the forensic? So in so many countries, like the brother has mentioned in Iraq, in the developing state, on the global south countries, there is issue of the technology along with the forensic. So there are certain issue according to that is the speed of the proceeding. Like in my country, in the whole district, there is one judge who is dealing the cases of cyber crime. So if a person is bold online, if he bring his case, it will take years. So it is very also an important factor to speed up, to make maximum number of judges for the cybercrime cases. Along with that, the awareness regarding the emerging threats. The technology is changing. Like 5 years ago, there was no AI. So if the laws were made according to the situation, now we have AI. After the 5 years, what will be the technology next? So the changing of the emerging threats for the judges. So I believe that the training for the judges, the curriculum for the judges, there should be regarding the cyber. Along with that, which is very important, that the students of law should be taught the technology, should be taught regarding the cyber law. Like in Pakistan, I have been graduated from a very renowned law college, but I have never taught the cyber law. as a minor subject, as a major subject. So when I came into the field, this is what I learning by myself. So I believe that the cyber law and the things related to the cyber or the technology should be included in the curriculum. So this is what my intervention from my side. Thank you.
So much, advocate, and I think we need some kind of like Dr. Martin Koyabe alluded to. I think we need frameworks. Is there a question from online? And then we'll go to that lady. As the panelist, please make your final 2 minutes, prepare your final 2 minutes contribution, because the session is about to wind up. Yes, there is a lady. If you can take the microphone. Take the microphone to the lady, please. Yes, go ahead.
Hello, good morning. Thank you so much for all the informative presentation that you've presented. My name is Hassan Tebi. I'm from Mawadda Association for Family Stability in Riyadh. I have actually not a question, but an input, if you allow it, please. Despite rapid advancement in digital laws and regulation addressing online rights, judicial system face significant challenge in adapting to fast evolving technologies. Gaps in current legal frameworks hinder the protection of digital rights, such as privacy and freedom of expression, especially in light of cross-border risk like data breach and discriminatory AI applications. Marginalized groups face heightened barriers to accessing digital justice due to the lack of.
Is that a question? Or
No. This is just an input. No, this is just an input. If it's
yeah,
okay.
if you can keep it short because of time.
Yeah.
Yes.
Okay,
please.
sure. So we call to develop comprehensive legal frameworks, draft laws aligned with the emerging challenge to safeguard digital rights while upholding principle of privacy and transparency, strengthen cross-border judicial collaboration, establish mechanism to coordinate judicial decision across countries for effective handling of cross-border digital issues, and engage multi-stakeholder.
Thank you so much. And we are going to go to the thank you for your intervention, and I think we will share.
I'll be happy to.
Yes, yeah, the copy of that. We'll share the copy extensively with the participants.
Okay, sure.
Because of time, I think I'm going to go back to the panel. If you can make your parting short, 2 minutes of summary of today's session, starting with Umar, please. Thank you.
So the first thing, I'm just loving it that for the first time, somebody and the legal fraternity has taken the responsibility to come. And it's my 4th IGF, but for the first time, I'm having a session on something from the judiciary. And we should understand that judiciary does not include only the judges. It includes the lawyers, it includes the prosecutors, it includes all. So I think the beauty of this panel is that we have it from academia, we have from the judges, we have from the lawyer, we have from the civil society. So I believe that this should continue, and I'm hopeful to collaborate with the judges and you guys for the next IGF. We might have judges from Pakistan. The honorable judge has talked about the visit to Tanzania. I would love to connect him to some judges who are here in Pakistan. So I believe that this should continue, and the judicial system should be empowered in terms of the technology. Thank you.
Thank you very much for this session. Let me just make 3 very important issues here. So the first one is that this initiative, which started in Kigali, and I'm very glad we're here, has actually got a lot of potential to make sure that we can do as my colleague Umar said, have inclusivity from different facets, whether it's from technology, judiciary, and other areas. So that's something that I think we need to bond from this particular conversation going forward. The other thing is stressing on the issues around the frameworks that exists within member countries. And let's try and look at also embedding into our frameworks some of the conventions, like the Budapest Convention and other conventions that are very, very straightforward, the Malabo Convention for Africa and so forth, that can enhance the way we are looking at judiciary and the laws. And then technology is here to stay. Let's remember one thing, that what technology gives, it can also take in equal measure. So as we move towards technology and embedding technology, let us also put mechanisms in place that can actually mitigate things that can go wrong. Because we have advisories out there, they can attack our systems, they can take over some of the decisions, and that can be very disastrous. So let's make sure that at every point, we do what we call privacy first, security first, as we implement some of these particular issues. Thank you.
Judge.
Thank you very much. Three issues. First, what the lady was reading is really fundamental, and I invite you and everyone else, just after this, at 12, we are at the parliamentary track room for another session where IGF is now planning to have judges included. You will hear now this dream taking place. So you can very much still share that. And if you don't get an opportunity, please give it a copy to me. I know how to work with it. What you are saying is very important. Secondly, let us all imagine we are like a person who has bought a house and they move in. They realize that the door doesn't work, the window is too old, the bed is too small. That is what we are doing in the second half quarter of the 21st century. We have to demolish a few walls to rebuild them to accommodate the digital world. I am meeting my Minister for Communication from Tanzania, and we will be discussing a few things. And I will ask him to sponsor a few lawyers next year if they are not sponsored by IGF. And Advocate Tumar, you'll be sure that next year you'll see your fellow advocates here, because I'm meeting the minister, and the first thing I'll tell him, please tell TCRI to sponsor lawyers to come here, because if there is a joke that they say, and I will finish with this, it's a joke, don't be offended, please. Are you allowing me to say this joke? Yes, yes, they say, if you are doing anything serious, and you are not including a lawyer, there are only two things involved. Either you are not serious or what you are doing is not serious. Thank you.
Thank you so much.
Brought 5 educates for the first time to this IGF.
Thank you so much for attending our session, and be sure that we continue to interact in the future. And for those who would like to follow us in terms of the global judiciary network on internet governance and school on internet governance for the judges, I think we can share contacts later on as we finish. And thank you for joining us, and thank you for your contribution. I know the time was not sufficient for everybody to be able to accumulate, to contribute as much as she or he would like. I think we'll take your paper and make part of our conversation. Thank you so much, and we look forward to collaborate with you guys.
We should have a group photo.
Yes, we should have a group photo. Thank you.
Getting one crowd in there.
Yeah,
So I invite you to the parliamentary track
I'm sorry?
Sonia Livingston.
Oh, yeah, and yes, she is. And
Only 16 Windows.
good morning. We are about to start in 1 minute. I don't hear anything.
Number 5.
Yes.
5.
Yeah, okay, I hear myself now. Hi, Jonathan. Can you do a quick voice check? And Sonia as well, please. Sonia, can you do a quick voice check? Oh, you cannot unmute.
Unmuted when it's your turn to speak. But you can.
Jonathan, you should be able to.
Oh, now I can. Yes, I am allowed to unmute. I can't turn on my camera, but at least I can speak.
Okay, that's excellent. Thank you. Sonia, I will check you too. Sonia, can you?
Hello, yes, I can speak now, thank you. And it would be lovely to have my camera on if that's possible.
We're checking.
Thank you.
Can they put on the camera for those speakers? Can they put on the camera for Sonia and Jonathan? Yeah. Oh, excellent.
Thank you.
And Jonathan Cave, right? And Jonathan Cave. Gentlemen, Jonathan Cave as well. So, Jonathan, you can now unmute your camera.
Yes, there I am. Great. Thank you.
Jonathan and Sonia, you can now mute and unmute yourself. So if you're not speaking, maybe best to mute yourself.
Okay, sounds good.
You're now both co-host. Shall we begin? Can we begin? Yeah. Okay, good morning, everybody. Welcome to the session from DC IoT and DC Crite, which is focused on Edge-aware IoT and better IoT. Can you hear me well in the room? Good. So this session will take us through the landscape of evolving technology and how it relates to how we deal with people socially in age, how we can make sure technology serves the people with a specific focus on age. So there's so many opportunities that make everyday life more convenient, safer, and more efficient. But there's also threats that come with that, and we want to get the best out of it. This is why dynamic coalitions throughout the year explore how to develop good practice in the best possible way and address risks such as unwanted data processing, provision of information that may be inappropriate or even harmful to individuals, or the initiation of processes that are based on false assumptions. And one of the ways to counter these risks is by categorizing the users. If the devices in the surroundings can categorize users, the Internet of Things can adequately adapt according to the needs and the specific measures to serve that user. So this is why Jutta and I discussed coming together with the two dynamic coalitions and focus on how this will look like. A little bit on the reasons for the DC IoT on CRITE. Can you share that, Jutta?
Yes, of course I can share that. And you gave me the perfect segue to that when you mentioned evolving technologies, because at the Dynamic Coalition on Children's Rights, we are talking about the evolving capacities of children, which is one of the general principles of the UN Convention of the Rights of the Child. And I do think both dynamic coalitions started their work very early in the process of the Internet Governance from Children's Rights, then was called the Dynamic Coalition on Child Online Safety. And that started in 27. I do think IoT started the same year as well.
28.
28. So very long-standing collaboration between these two dynamic coalitions in a certain way. And several years later, when the General Command number 25 came out, which is dedicated to children's rights in the online environment, we renamed the Dynamic Coalition to Children's Rights, or CREED, like Martin has already said. And we we found some similarities in the work that we are doing, and also in the objectives that we want to achieve, because we know that children are the early adopters of new technology, of emerging technologies, and that's always the case where we have to look whether their rights are ensured and whether they can benefit from these technologies. And IoT is one area that is very important, that can help people, that can help children to benefit from digital environment. And that's, having said that, I hand over to you, Martin, again.
Thank you so much. So basically the DC IoT 2008, Hyderabad was the first time, has been talking over time. So how can IoT serve people? What global good guidelines, which should be a good global good practice guidelines should be adopted by people around the world, because this technology is from around the world and is used everywhere. So like the Internet of Things doesn't stop at the border. Very practically, because products come from all over the world, but also because, for instance, the more mobile IoT devices, like in cars, in planes, or what you're carrying with you when you travel, crosses borders all the time as well. So an understanding of global good practice would also help governments to take it into account when they develop legislation, being more aware of what consequences could be, what to think of. It could take global business could take it into account in their development, design and development of devices and systems. And by doing that from the outset, innovation can be guided by some insights, even when it's not laws yet. So the Internet of Things good practice aims at developing IoT systems, products, and services, taking ethical considerations into account from the outset. Development phase, deployment phase, use phase, and waste phase of the life cycle, and to find an ethical, sustainable way forward. It's using IoT to help to create a free, secure, and enabling rights-based environment with a minimal ecological footprint, and that for future we want for us and future generations. And when we talk about an internet we want in which IoT, as we want, is to be developed, it's crucial that we really get that clear what that means for us, and that we do take action to make something happen there. because otherwise, still remembering very much what Vint Cerf, the chair of the high-level panel, said last year in Kobe. If we don't make the internet we want, we may get the internet we deserve, and we may not like that. So with that, I really look forward to discussions today, for which we have a number of excellent speakers in the room and online. And we will talk first about the data governance aspects that underline this. Then we go into labeling and certification of IoT devices, as that helps in transparency of these devices and what they can do, and empowers users to be more informed and in their choices. Every session so far, I think I've heard the word AI, so let me be the first one to mention it here. Of course, it has a fundamental impact of how AI, IoT environments work, and also how selections can be made to adapt that to abilities of people. And then last but not least, in all this, the kind of horizontal layer is, how do we develop capacity? Because IoT may be developed all over the world, but to apply it locally, you need to have local knowledge. So where does that come together? How can we work on that? I'm very, very happy to have also Sabrina here to talk more about that. So with that, I'd love to give the word to Jonathan Cave, who's a senior teaching fellow, who used to be a senior teaching fellow at economics in the University of Warwick, and a Turing fellow at the Alan Turing Institute, well known for its work on ethics in the digital space. And he was also a former economist member of the British Regulatory Policy Committee. Jonathan, can you dive in onto the data governance aspect and why this is so important and what we need to do about it? You will be followed by Sonia.
Yes, thank you, Martin, and thank you everyone for showing up. This is a very important topic, and I'm going to largely limit these first remarks to matters dealing with data. But one thing I want to point out is that this idea of evolving capacity applies not only to the technologies which are changing and collecting more and more data, but also applies to the evolving capacities of the individuals involved, in particular children.
Jonathan,
Yes?
Can you improve your microphone?
Not really. That's
okay. You're understandable, but just not great. If you don't have an easy trick, let's continue. Sorry about that.
Okay, let me just try.
It's better when he's closer to the device.
Closer to the device may help.
Okay, well, let me try.
Now that you're so close to the device, it's better if you just go close.
I know. I've actually, the device is attached to my ears, so there's no way of going closer without changing my face geometry. But I've switched to another microphone on my camera. Is that better?
Yes. Yes, it's much better.
Okay, thank you. One can never tell with these technologies. Yeah, so one of the things that I think is very interesting is that much of our laws and much of our policy prescriptions around child safety is predicated around the idea of chronological age, that people below a certain age should be kept safe and people above that age lose that protection. But of course, particularly as children have more and more experience of online environments, and the people making the rules have less and less experience of the new technologies, that static perspective of protecting people on the basis of age may not be the most appropriate, and we need to stay aware of that. But most of all, I think it's interesting to remember the data governance issues. One element of this is that the data themselves can be a source of either safety or risk and harm to young people. And the reason we care about that is both in terms of the immediate harm, but in terms of the collective, progressive, or ongoing harm that early exposure to inappropriate content, which includes manipulation of individuals by priming and profiling, can expose in people, which then change the way they think as individuals or as groups. Now, in that respect, the question becomes, which data should people have available to them? One particular element of this is that we have a lot of privacy laws, and many of these privacy laws set age limits for people's exposure to or ability to consent to certain kinds of data collection or processing. Mostly these are predicated around what we would consider sensitive data, but in the online environment, particularly social environments or gaming environments, many more data are collected whose implications we only dimly understand. And this is where AI comes in. It's not obvious which data may be harmful and which data are not. So instead of imposing rules and asking industry simply to comply with those rules, we may need, and increasingly in areas like online harms, we're moving in the direction of a sort of duty of care, where we make businesses and providers responsible for measurable improvements and not for following static codes. So it's like harm reduction rather than compliance. So there's the question about which data are collected. There's also a more minor issue, which is that young people are exempt from certain kinds of data collection, but those may be the same data needed to assess either what their true chronological age is or their level of digital maturity. So it may be that some of the rules we have in place make it difficult to do too many things that keep pace with the evolving technologies. Okay, I think probably rather than going on, I should turn over to Sonia at this point, and I'll make comments as and when things come back up.
Fantastic.
Okay, thank you. Yes, Sonia, please go on.
Okay, brilliant. Thank you very much. And thank you for the preceding remarks, which kind of set the scene. So I did want to begin by acknowledging what an interesting conversation this promises to be, because we're bringing together two constituencies, those concerned with the Internet of Things and those concerned with children's rights, that haven't historically talked together so much. And I think it is really valuable that we're having this conversation now. In a kind of Venn diagram of child rights and IoT experts, I think the overlap currently is relatively modest, and I hope we can widen the domain of mutual understanding. And I think it's even there in some of the, and age assurance is a brilliant topic to illustrate some of the both overlaps, but also differences in perspective on this problem. So I guess from a child rights perspective, a starting point is to say that it's very hard to respect children's rights online or in relation to IoT if the digital providers don't know which user is a child. And so having that knowledge seems a prerequisite to respecting children's rights. And yet, as some of us have been investigating so far, it is far from clear that age assurance technologies as they currently exist do themselves respect children's rights. So the fear on the side of many is that we might bring in a non-child rights respecting technology to solve a serious child rights problem. So and I think this is amplified, this challenge in relation to the Internet of Things, because now we're talking about technologies that are embedded, that are ambient, and that the users may not even know are operating or collecting their data, processing, enabling their opportunities, but also introducing risks. So a child rights landscape always seeks to be holistic. So privacy is key, as has already been said. Safety is key, as has already been said. But the concern about some of the age assurance solutions is that, as Jonathan just said, they introduce age limits. And so there are also costs potentially to children's rights as well as benefits. And it's that kind of holistic perspective that is crucial. So it's always important that we think about privacy, safety, as, if you like, hygiene factors. How do we stop the technologies introducing problems, but we need to think about those also in relation to the rest of children's rights. What am I thinking of? I'm thinking of consulting children in the design and making of both the technologies and also the policies that regulate them. I'm thinking of children's right to access information, right to participation, and to be part of the digital world, rather than excluded through age limits or perhaps through delegating the responsibility of children to parents, which means parents might exclude children. We're seeing a lot of this in various parts of the world at the moment. As Jutta said, I'm thinking about evolving capacities. This is not just a matter of age limits. Underneath, children are excluded, and above, they are placed at risk, as it were. This is a terrible binary, if that's where we're heading. But we're also thinking about age-appropriate provision for children who are users or may be impacted by technology. They may not be the named user, they may not be signed up to the profile or signed up to the service or paying for the service, but they may be in the room, in the car, in the street, in the workplace, in the school. You know, they may be impacted by the technology. And I'm thinking also about best interests, that overall the balance should always be in the child's best interests. That's what every state in the world, except America, has signed up to when it ratified the convention. And I'm thinking of child-friendly remedy, so that when something goes wrong, children themselves, not necessarily through adults, have access to remedy. So I think a child rights approach brings a broader perspective, but also one that is already embedded in and encoded in established laws, policies and obligations on institutions and states to ensure that these new areas of business respect children's rights during and as part of their innovative process. And so I'll end with the mention of child rights by design, if you like to give a broader focus to questions of privacy by design and safety by design. Thank you.
Response also appreciated your point about the need to include youth already in design phases of devices, even if they're not obviously directed at youth alone. With that, I'd like to open the floor for some questions here. And mind you, at the end of the session, we'll go deeper. So if you don't have questions here, not a problem. We have two more sections to really dive into. Any questions for now in the room? I see no, in the chat. My camera is disabled by the host. No, there's no comments. Torsten?
Yep, we have one comment in the chat. I would read it out.
Please.
As it was written by Godsway Kubi. I hope I pronounced it correctly. And Godsway Kubi wrote, 2 ways age-aware IoT can contribute to a better IoT ecosystem for children is by prioritizing privacy and safety in devices designed for children, such as smart toys and learning tools, and using age-appropriate interfaces and content filters to enhance usability and safety.
Okay. Thank you for that very appropriate remark. By the way, Sonia, the first togetherness on age was actually on children's toys in the IoTs 6 years ago. So
Okay,
we've been touching them before.
Fantastic. Good.
Jonathan, please.
Yeah, just a small follow-up. Those are extremely useful remarks. There's one thing I wanted to say about the use of technologies to identify children's ages, whether they're chronological or let's call them digital ages, which is that, of course, these, like all other age verification technologies, can be bypassed. And one particular concern we should have is that when these bypass approaches become generally used by children or by groups of children, there may be an adverse selection in the sense that those most likely to bypass those protections may be those most at risk, either as individuals or in the groups through which these practices disseminate. I remember when I was growing up, and our county was 21 for drinking alcohol, the neighboring county was 18, and fake IDs were in widespread circulation among certain social networks. And so there is this issue about whether, although the solution may be very good, the path to the solution may be more harmful than where we start up now. And so, yeah.
I think that's a very good point and one of the big dilemmas to tackle also later on. So with that, I would like to move on towards the second. Oh, Sonia, do you want to respond to that?
Well, I was just going to say, thank you. I was just going to say very briefly in response to Jonathan, and thinking of the a paper that I worked on as part of the EU consent project, also with Abalash. When we consult children and families, they actually value those kinds of workarounds. That it provides a little flexibility, and I might say I don't think a 5-year-old could get away with a fake ID to drink, but perhaps a 19-year-old could. And it's that little bit of flexibility around hard kind of age limits that many families and children say is important to them in providing just that bit of flexibility for where they know their child is a bit less mature or a bit more mature. And so encoding everything in legislation and technology can in itself take away some agency from families. And I think that's a challenge to consider.
I'd also say that it takes away some agency from the children themselves who have to learn how to navigate these environments. And there is this tension between asking whether the environment can be made safe, and if not, whether denying access, as for example in Australia, is the appropriate approach, or whether some more active form of engaged filtration that goes, but then you have to move away from the binary, of course.
Yeah.
Because you do have to not only gauge how mature children are, but to provide them with curated experiences, perhaps under parental or peer control, that enable them to become capable of safely navigating these environments.
So I think there's the legal hard, legal coded limits, and there's the practical limits. And I think online tools can be more useful with practical limits than with online code limits, unless you involve obligatory registration, including age. Jutta?
Yes, so far what we know, for example, from the GDPR is a hard set limit of it's between 13 or 16, but in every country in Europe it's a hard limit.
Either 13, 14, 15 or 16. And what the European Commission is now going to discuss is more about age brackets, which would mean a certain age range, saying between 13 and 15 or 16 to 18 or something like that, so that you have a diverse, a bit of a range. And there comes in the issue of maturity. So you might have a 13-year-old that is mature like a 15-year-old, and a 15-year-old that is only like someone who's 14 or 11 or 12, something like that. So when we are not talking about an exact age threshold, but about age brackets, we get some of this flexibility for the children as well as for the family, and it also pays into the concept of maturity, so that it makes it more flexible. Thank you.
Yes, thank you very much. And I see another comment from Dorothy about this, right? Comment of Dorothy, please.
Dorothy Gordon wrote in comment, it's repeating a little bit what Jonathan said. She wrote, denying access will always encourage teens to look at workarounds and often, as in the case of alcohol, engage in dangerous behavior because they have no guidance. Why do we not put more emphasis on media information literacy so that users understand how to protect themselves?
Yes, thanks for that. And also the brackets come into that as well. Please.
Yeah, so I want to speak on the point what Jutta made in terms of the maturity ratings. I think so we are also talking about one section of children over here who are able, and we try to put them into the bar of 13 to 16 because when we talk about maturity rating, when we talk about the maturity of children, for autistic children it might differ because 13 and a mature child will be different than an able child over there. So looking into all aspects of children over there is equally important over here, that when we're defining age on the accessibility of technology for children, what category of children that we're talking about, because it might just differ as per the point that, you know, their sense of understanding about technology and also their sense of understanding about using the technology.
Yes, thanks. And it was Pratishta Aurora. If you speak, please raise your hand. She will be speaking shortly on AI as well. Thank you for that. So how can we help to help ensure that parents, children, environments know how IoT devices can serve them? And that is the next topic we would like to dive into. So basically having all these goods from all over the world, having different capacities, and having found in the past that, for instance, the security of these devices was sometimes limited to none or to being set with default passwords like admin, is not useful. Also, we found that in the past some devices, for instance, sent data back to the factory or wherever to without users being aware of that or knowledgeable of that. Now, legislation asks for more of that clarity. At the same time, legislation is per country, and so how can we together get a good tool here that helps us to understand what we actually buy, what we actually start using. So from the IoT perspective, we had a big discussion last year in Kobe, where it was made clear that labeling of devices and of services is crucial, and this labeling needs to be even dynamic, because with upgrades of software and things, the label may change. So a label that can be linked to online repository would be crucial. And certification of that, of course, is important, because one could say anything there, and how do we know that it's true? So some certainty needs to be built in, and there's different certification schemes. This is not a session to go deeper, very deep into the differences of those. At this moment, these labeling and certification schemes are also discussed around the world and put in place. For instance, in the US, the NIST framework has been put in place that also identify this. In Singapore, action has been taken place, and in other places. What is now, and in Europe as well, of course, as part of the Digital Services Act. And what we see is that now the diplomatic go-around is beginning. These countries are talking towards each other about, so how can we do it in such a way that we can recognize each other's certifications, that the labels of other countries are useful for us as well. And this is the beginning, but we are not there yet. The deeper intent of labeling and certification, so labeling is what is it about, the certification is how do I know that this is correct, is basically that it empowers users to make smarter choices. So next to security, we discussed last year, it should be also about so data security, so where is data streams going? And I think what came up over the years since is more and more emphasis also, so how much energy does it use? like IEEE is already doing for electronic devices. So all this together is, I think, an enabler to make users more aware what IoT devices and systems can do and can offer. And I'm very interested to hear your perspective, Abhilash, on what this can do for age awareness and appropriateness.
Thank you. I want to talk a little bit about why age assurance matters from a legal perspective as a starting point. We've had laws for a very long time that require some form of age assurance for various content, services, and sale of goods online. And some of these laws have explicit requirements of age verification or age assurance. Some of them are implied. But in practice, there is very little out there. For decades, really, we've had laws that have not been enforced properly because they have not been complemented with appropriate age assurance tools. And the notable exception for that is probably online gambling, where the law seems to have worked in some jurisdictions. At least the UK is a good example under the Gambling Commission. But part of the reason why it was successful is because it's not just about age assurance, it's also about identity verification. So where people need to be identified so that they can be offered support against support for problem gambling, so on and so forth. For almost all of the cases, when we looked at the EU consent project that Sonia mentioned earlier, when we looked at all member states in the EU plus the UK, we found that there was very little out there in terms of AV tools, age verification tools, that can actually help implement legislation. And the content was the most problematic of all of that for a variety of reasons, not least because there are cultural variations even within Europe as to what is acceptable content, even for children, the sub-18 category of people. But there's also a wider problem there. There was a disconnect between the principle of self-regulation that the EU has advocated, especially for content for a period of time, on the one hand, with legislation that suggests the adoption of age assurance tools on the other. So that has not led to a happy situation that, the law on the one hand requires age assurance to protect children, but the practical reality is, there hasn't been any useful means of enforcing that legislation in practice. There is a legal principle which suggests that if a law cannot be enforced, as law is unenforceable, it's unlikely to succeed. It's unlikely to command the respect of people who are bound by that legislation. And you can see a good example in copyright infringement online. It's not because people don't understand infringing copyright is unlawful that people infringe copyrights, because they can do it without consequence. Unfortunately, that is the case with most laws that require age assurance, most notably with content, as I've already mentioned. So what I'm trying to say here is it's important that age assurance or effective age assurance complements legislation for the legislation to work, and that is a starting point. Jonathan already mentioned that we've got too many rules, too many laws. So the solution is not to have more legislation. The real starting point is to make sure that what we have is enforceable and practicable. Now, things are changing lately with more specific legislation coming to the books, especially specifically mandating age assurance and imposing specific obligations on platforms and websites for non-compliance. But it's not without problems. The problem with age assurance, in my view, the fundamental problem there is it's been a binary debate. Essentially, it has been a debate about children out and adults in. And that's not, that's not how it should be. Sonia has already talked about evolving capacities of children, and you cannot just classify everyone under the age of 18 into one category and use age assurance on them and have adults on the other side. But there's also the other binary debate between adults who feel strongly about privacy and their ability to access internet without any restrictions, without any hurdles to go through, and keeping children safe. That balance also has not been struck appropriately thus far. So, and there's also the other issue of, the age threshold for children for accessing content services or purchasing goods can also vary across nations, across cultures, even within the same country. There are different cultural variations in that. But the law does not always factor in the evolving capacities of children in that sense, and it fails children. To take the example of the EU Audiovisual Media Services Directive, which refers to a notion of risk of harm to be the basis for adopting appropriate safeguards and measures for age assurance, is a good example, because in principle, it recognizes the evolving capacities of children that every child, say, for example, an 11-year-old is very different to a 16-year-old. But not all legislation does that. I've already talked about the cultural variations as to age thresholds, even for what is generally perceived as harmful content for children, like pornography. Even within Europe, there are variations as to the age threshold for accessing porn, even under the sub-18 category. So, so that's where I stand on age assurance laws. I think we have toyed with the idea of self-regulation, especially in the online space, for more than 3 decades, and it hasn't worked. And I think we need, what I'm saying is we don't need new age assurance laws. We already have age assurance laws. What we need is workable, enforceable age assurance legislation. And like you said, labeling and certification it can be mandated by law, or it could be a voluntary thing. But they obviously have to go hand in hand and complement legislation, because I do believe that measures like certification and labeling gives more consumer choices, gives more parental or caregiver autonomy, also children more autonomy. But that cannot be a substitute for underlying legislation, is how I feel about it.
Thank you for that. Comments online on this subject, Thorsten?
There are discussions online, but it's
skip Jonathan and Sonia because they raised their hand. So other comments?
There are comments, but not to this
Specific.
current,
Okay,
specific
thank you very
topic.
much. In that case, Jonathan, please, your thoughts on this.
Okay, thank you. Thank you very much. And thanks for that.
I can't hear you right now.
Am I still inaudible?
No, we can't hear you.
One moment. Yes, Jonathan?
Yes.
No,
No, I'm still inaudible.
I see the technical section working at it. Yeah, I check, it will be the same issue for her because it's settings here in the room. Can you say something? Jonathan?
Something.
Yeah, you say something. We can't hear the online speakers. We can't hear the online speakers.
Okay.
One moment. Is
Yes. Yeah.
yes, we can hear you now. You're back.
Ah, right. Okay, I'll be very brief because of the technical delays. I think one of the things that we learned with age verification in relation to pornography is that the very existence of the single market or the global use of these technologies makes it very difficult to sustain differences. Even attempts to tackle the problem by regulating payment platforms because you couldn't regulate content users on the platforms sort of failed because the content was coming from outside the jurisdiction. And the fact that it was banned within the jurisdiction merely increased the profitability or the price of external supplies of this kind of potentially harmful content. Another thing is that I completely agree that some mixture of self and co-regulation and formal regulation backed by a concept of a duty of care or harm-based regulation or principles-based regulation, something more ex ante, is required to keep pace, not just with the evolution of technology and people's understanding, but with how it reacts to existing let's say, bans and protections and regulations. And the final point was to say that we should probably also be aware of the fact that certification schemes and other forms of high-profile regulation can convey a false sense of security, but by the same token, it may be the case that some of the harms against which we regulate are harms which are no longer truly harmful because people have evolved away from the point where they're vulnerable to them. And in that case, in that sense, I just point out that in relation to disinformation, misinformation, and malinformation, there's evidence that a lot of the younger generations, Gen Alpha, Gen Z in particular, are less vulnerable to these harms than their unrestricted, unregulated adult counterparts. And so that it may be that some of the harms we worry about cease to be harms or are no longer appropriate to be tackled by legal means. Okay, those are my comments.
Thank you for that, Jonathan. Sonia, please.
Thank you. I wanted to acknowledge the conversation in the Zoom chat for the meeting, identifying the range of stakeholders involved. And so, of course, and maybe we should have said at the very beginning that in facing this new challenge of age assurance in relation to IoT, a whole host of actors are crucial. They play a role, and there are difficult questions of balance which will vary by culture. So yes, we need to empower children and make sure that these services are child friendly. They speak to them, they're understandable by them. We need to address parents, we need to address educators, and involve media literacy initiatives in exactly this domain. But I wanted to make 2 points there. And one is in that we can only educate people, the public, in school and so forth, insofar as the technologies are legible, insofar as people can reasonably be expected to understand and learn what are the harms, where the harms might come from, and then what are the levers, what are the kind of available resources for the public, the users, to address those. And we're not there yet. And so on the question of balance, I think the spotlight for IoT is rightly on the industry and on the role of the state, as Abhilash said, in bringing legislation. And on that point, we've been doing some work trying to make the idea of child rights by design real and actionable. We've been doing some work with the industry, the stakeholder group that is kind of most active and innovative in this space. And so I just want to open up the black box of industry a little bit. And because what we're finding is that from the CEO through the legal department to the marketing department, the design department, the developers, the engineers, all the different professionals and all the different experts that make up the development of a technology, for the most part, most are not aware of the child user who may or may not be at the end of the process. Most of them have a different kind of user in mind, which is often an individual, not a family, that might share passwords and share technologies, and by and large is a relatively invulnerable or resilient user rather than one with the range of vulnerabilities, including children that we've thought about. So I think let's break up this, look into this notion of the industry and think about where our ethical principles, our duty of care, our legal requirements and our child rights expectations, where will they land within a company, whether it's a small startup that is completely hard pressed and just trying to get into the App Store and has no idea of these, all the way through to an enormous company that has, you know, a lot of kind of trust and safety focus at a relatively unheard level in the organization, and a lot of engineers and innovators who are pushing forward without the kind of knowledge and the kind of awareness that we're discussing today. So pointing to industry and governments regulating industry just, you know, opens up the next set of challenges about who and how is to be aware of all of these issues.
Very well said, and also an excellent segue towards our next sections, because basically this is about maybe education of the equipment through AI, and for sure the capacity building to parents, children, and environments, to which we will talk in the last session. I'd like to invite Patista Aurora to initiate explaining the role for AI that you see in this interaction, and after that we'll go to Jonathan Cave. Thank you.
Yes, thank you for that. I think so the impact of AI is kind of, you know, putting a lot of emphasis on children and their engagement on the devices. In terms of impact, I see both the positive and the negative. In terms of positive, because it's also a learning platform for many children who are maybe slow developers, you know, watching through videos and learning and learning and building their own capacities is a good platform for them. But on the contrary, when I talk about technology and the advancement of it and the impact on children, that is also laying big like, you know, a big challenge for them in terms of that children are being given all the rights to use that device without quote, one of the experiences that I observed is that how from a smart speaker children are using to call their parents, voice out what they feel like, engage with that device, which is also putting giving them that expression of freedom to learn on the aspect that, okay, the device is answering them back from the point that, you know, a child is asking a question, but there the speaker or the device is unable to understand that if what is the age of the child over there. So age assurance as a point over there, that if this is a 6-year-old child asking a question or a 13-year-old or a 15-year-old, so that that gap is not being identified as of now. So where I feel that, you know, these technological advancements is playing a very big role. I on the point that how it is leading to a negative impact is that, you know, there is over dependence on these technological tools as well, because for every small thing that we are going up to the technology, we're going up to the device and asking a problem to solve that problem, and that is also leading to somewhere the development of the skills in terms of the physical development of a child, the mental development of a child as well, because we are totally dependent upon what the device is responding to as. In terms of standards, I feel that, you know, we need to have more defined standards where children have access to devices and where the engagement of parents have a big role in terms of what Abhilash also talked about from the legislative point, and also from the point that we need to have other stakeholders involved from the industry perspective, that they follow these rules when any device is being designed from a child perspective, because developers, like what Sonia mentioned, that, you know, developers are not able to figure out that that, you know, this device has been designed from a child's perspective. So that thought to be ingrained to the point that any technology which is being designed needs to be child friendly as we are advancing with technology now. of course, reinforcing on the point again and again that safety by design is a key concept, and in the coming in the future of technology, we look into that point that all these aspects are taken into consideration, that any child and every child is looked upon, irrespective of the age, irrespective of their own skills and their own learning capabilities as well. Um, coming from India, I have experienced a varied range of observations of how technology is being used by children, and also how it is misleading them in terms of their own developments and the engagement in the online spaces as well. While it is in the space of online gaming, or it is in the space of social media interactions, because somewhere or the other, the Internet of Things or the devices, when we see that there is a development on one aspect with technology, there is the flip side of it on the misuse of technology. So we need to keep the right checks and balances. I think that's what has been coming again and again in the conversation as well, that we need to have the right checks and balances over there. Also, because Internet of Things is quite an alien term when we talk about it in India. It's sad, but yes, we need to, somewhere or the other, we need to also break down this concept of Internet of Things to people, to simplify the understanding of what exactly it means. Like when we talk about trust and safety, it is again an alien term. Somewhere we are advancing with the technology in the technological tools only with certain sector of people who are involved into this whole game of designing and developing tools. But for the larger, or for the masses, it is still an alien concept what Internet of Things is, how the standards needs to be defined. That is why I think that's the missing gap when we talk about child friendly or safety by design as a concept. Also now, because somewhere or the other, technology has been knocking everybody's door. So as a smart device, or a device in terms of a phone is in everybody's house, but in terms of having other gadgets is again more about what section of the society can afford it to engage. But larger is more about the difference in the economic backgrounds of the families, that it is more with the privileged section that, they are encountering this problem and challenge about devices, the engagement over there. While the phone, a smartphone, is in everybody's house, I feel there, this is also global attention that, that a phone device which is in a capacity that any child can use, because there has been an emphasis about that we need to have more child locked devices as well. So I think I'll stop there, and with the last point that, how data governance is playing a very big role over there, because whenever you're setting up any device and you're giving out the data, you're also ending up giving your child's data, right? So there, what is the governance about data, the privacy aspect of children's data over there?
Okay, thank you very much. Some good points made. Jonathan, I'll leave the floor to you.
Okay, thank you, and thank you for that discussion. I just have a few points that I think maybe slightly broader points I'd like to introduce. I'm an educator. One of the things that AI does is that it not only facilitates education and children's development in the ways that we normally understood it, but it also preempts or distorts it. It has an influence on the way people think. One of the aspects of this is that the AI devices that children use, learn about the child, but in the process, they also, as it were, to program the child, and they teach the child. Now, one of the things they teach them is to rely on the system for certain kinds of things. All of us have, to an extent, outsourced our memory to our AI devices, and we will ask for things that in the past we would have thought about. When a child searches for information online or asks a question, In the past, they would have had to read a book, for example. They would have read things that they weren't specifically looking for, and they would have to think about them to develop an answer to the question. If the AI gets very good at simply answering the question that was asked, the educational aspect of that is somewhat lost, and the nature of the dependence of the child on the device becomes, in a certain sense, deeper. The child becomes an interface that sets the device in motion. Now, this is something we have to deal with. We might say what we need to do is to prevent it. But my students say to me, with respect to the use of AI to write essays and so on, that it is a transferable skill, that the world into which they will grow will make use of these technologies. And to learn how to use the technologies may be more important than learning to use the technologies to do the things that we used to ask them to do. So there is a question here, a deep question, I think, about asking what kind of experience is best for children to help them become the kind of adults who can successfully work in this environment. And there are some technical things we can do along the way, like developing specific or stratified large language modules or even small language models for specific children to use, or to use synthetic data or digital twins to put a sandbox around children's experience of using the technologies. But I think that the general lesson is that these technologies used in this way to serve people, that if they're oriented towards solving past problems, and developers often tend to do that, they need to be required to think into the future about the consequences of what it is that they're doing. And that requires a continuous conversation involving children, developers, parents, and the rest of society that doesn't just stop when the device is released into use. And a final point on games. It's certainly true that games, particularly immersive online games, have a kind of reality or salience to a person that is even greater than the salience of real experience. It can cut through to the way in which we think in ways that normal mediated human-to-human contact doesn't always do that. We know that from neuroscience experiments as well as normal experience, which suggests that these games could be used actually to help people navigate this new world, to promote ethical development instead of sort of attenuating ethical and moral sensitivities among children. And then the final thing is that there is a difference, and this was very compellingly brought out by the experience from India, of the technologies which are designed for or used for elites, whether they are privileged elites in the sense of money or trained elites who can navigate, understand the risks and benefits, and those same technologies when used by the masses, when the costs drop, for example, and the uses become different, evolve away from those that the developers originally intended. So I think that is a fundamental issue that needs to be dealt with at the development and deployment level. So, then the final thing is to say that, of course, one of the things that AI can do is it can police the problems that AI creates. And so one of the things that one would expect a machine learning model, a deep neural net model to do, is to keep track of how these technologies are changing our children and to respond appropriately. So it's, I don't know, the solution to the problems created by AI is more AI. I would hesitate to actually endorse that because then we do give up our human agency. But those were sort of my concluding thoughts on AI in this respect.
Thank you very much for that. Yeah, that play that is ongoing and is forming us with a clear call for being aware of dependency that may grow with AI. The safety for design by kids, from the outset, right, by design. The warning for the digital divide and the human agency warning, like we may want to keep that in some way or another. Jonathan?
Yeah, the other thing I would just add to that is Piaget's dictum that play is a child's work, that sense of engaging with these technologies for play allows us to develop in ways that doing them in anger or for serious reasons do not. And there's some really interesting work going on at Oxford on the difference on play as a state of mind when we engage with technologies. Okay.
Thank you so much. Thorsten from the room.
No comment to the current block, but there was a discussion or an hint that it's not only necessary that children understand how IoT works, what's the functionality behind it, but also parents must know how it works and how it could influence their children. But maybe that's an aspect we can add to the next block too.
Yes, we'll come back to that in the end, because it's not only about children and parents, but also the environment, like teachers, babysitters, but also social environment. So we'll take that back to the end. Jutta, you want? Other specific questions on the AI impact. I mean, it's clear, right? We're all learning. We're learning with AI, we're learning from AI, but also AI is learning while we do it. And let's make sure that it learns it in the right ways, taking into account the values that we share around the world. And that may be not all values that you've been getting from your parents, but some values are shared, like the inclusiveness, the recognition and valuing of diversity, and human agency is and privacy. I think these are some of the clear examples of values that we share. And for new tools, new developments to be taken into account is one thing. Let's also keep in our mind, so what with all the old stuff that is already out there, and evolve that. Now on standards, we heard about legislation, we heard about industry practice, and in a way, if we look to, for instance, safety for electronic shocks, we've got the IEEE standards, it's global standards. For internet standards, we got the IETF standards that set certain rules, but they are voluntary, but they're industry standards and they're adopted and at least agreed and discussed around the world. And more of this is likely to come. Jutta, please.
Yes, if I may come in, since you got back to the standards, I was considering that Abeles was saying labeling certification schemes should be mandated by law. That would be the first step to go further with IoT when we have that mandatory certification scheme or labeling. But then it also needs to go into the to be accepted. And one example that we know for about 20 years now is Section 508 that at that time demanded or obliged the US States administration to have accessibility as a precondition in procurement. So from that time on, any product that was bought by administration in the United States needed to be accessible for people with disabilities. And that only caused the whole process of having a broad range of products that were certified to be accessible. And also it brought the prices down. The products got affordable because the administration was obliged to only buy those products that are accessible. And if we could come to that next stage, not only labeling and certification, but having it like a procurement precondition, that I do think would really help to bring forward the labeled IoT. Do you understand what I mean?
That's very, very
It just
much.
came to my mind that it's a really good example that we could follow up with.
Yes, I see Jonathan clap his hands because we talked a lot about this. And basically, we've got standards and we've got legislation. The problem about legislation is it's per jurisdiction. And then you can start to harmonize across jurisdictions and it takes time. But at least if there's principles that are globally recognized, you have something to go for. And organizations like IEEE, IETF, ISO and others play an important role in that. So very much, I know Jonathan is much more an expert in this than I am, and I see he raised his hands. Jonathan.
Yes, thank you very much. That's a brilliant point. The idea of using public procurement as a tool, as a sort of complement either to self-regulation or to formal regulation, is, I think, one that's worked in a number of areas. One of the things it can do, as Jutta mentioned, is to set a floor under the kind of capability that we wish to provide a stimulus, an economic stimulus to, that things have to be accessible, they have to have certain capabilities. But it can also create a kind of direction of competition. So when you specify a procurement, part of it is the requirements that you put in that the proposed solutions have to provide. The other part are the things on which you provide advanced scores. And so procurement tenders written appropriately can also stimulate innovation to come up with better and more effective solutions. So there's that part, the kind of launching customer aspect that puts money into developments that might not yet have a market home, that might not yet be profitable for people to provide, but which with certain development or certain economies of scale might become profitable. And you can do that without putting governments in the position of saying, this is what we need, because governments are particularly bad at picking winners and specifying solutions. But what they can do is to move the whole industry in the direction of providing these things. So that also happens, and the final point on this, when it comes to the adoption of standards within the procurement context. European standards, although not developed by the EU, are often incorporated into public procurement tenders, with the idea being that you have to show compliance with the standard or equivalent performance. And that introduces into this market-based alternative to regulation something which looks like an outcome-based or principles-based criterion as to what's acceptable and what isn't. So in other words, you either have to do the thing which is there in the code, you have to comply, or better still, you have to show that you can do better. And if you do that, you harness the innovation of industry and indeed give the customers some say in the matter, and not just a negotiation or a procurement officer within a government bureaucracy.
Thanks
So
for that.
I think it's really profitable.
Yes, no, a clear example on that is that, for instance, for internet security, there are standards that back up the flaws in the current system, like DNSSEC, like RPKI. These are standards that can be adopted by service. Now, these standards are, again, global, but they're voluntary. For instance, in the Netherlands, the Dutch administration does include it in its tendering for services. And with that, they ensure that there are service providers that I, as a citizen, can also go to for those services, because the services get the basis. So that's one of the examples. And yes, if government isn't sure, at least they can help with a direction. So Jutta, thanks for raising it. Jonathan, thanks for bringing it home. And you wanted to comment on that.
Yes, thank you. Just wanted to follow up on what Jutta said about laws mandating labeling and certification. I said laws could rather than, must always. But I recognize there are some instances where it's not possible. One other thing just to add to there is it might also help mitigate the literacy problem of parents or caregivers, because often policymakers assume that parents and caregivers are always educated and every child comes from a two-parent middle-class household, and that doesn't happen, especially in countries with varying literacy rates, let alone digital literacy rates. That kind of certification labeling might be an added protection for children, I think.
You gave the perfect segue to handing over to Sabrina, I would say. Shall she go on?
And yes, we also come with the remark from Dorothy online that says there's so many people who are not online yet. And how do we make sure that they don't miss the boat? So with the focus on, well, after what we can have technology do and develop with AI and standards, in the end, it's about the people. And how can we make sure that people use it well? Sabrina, please.
Yeah, thank you. Good afternoon, everyone. I kept quiet for the moment because I think it makes sense for me to come in at the very end just to complement on the various aspects that have been mentioned already, and also how we can indeed build this bridge of the information and the knowledge we have to the end users, which are, of course, in primary children and young people, but not exclusively, also parents, caregivers, teachers, but also not to forget other stakeholders, the policymakers in the industry. I want to come in with a concrete example representing the Better Internet for Kids initiative, which is funded by the European Commission under the Digital Europe program. The initiative aims to create a safer and more empowering online environment for children and young people. The goal is, in the European Union, we have the Better Internet for Kids Plus strategy that is based on 3 core pillars: child protection, child participation, and child empowerment. So also what was mentioned already, really to try to empower children and young people to become agents of change. But in order for them to do this, they need us adults, they need a safe and responsible space. And that, of course, is to promote, it's the goal of the Better Internet for Kids initiative, to promote responsible use of the internet, protecting minors from online risks such as harmful and inappropriate content, but also to provide resources for parents, for educators, and other stakeholders to better support on aspects such as online safety and digital literacy. And of course, Better Internet for Kids also addresses the very prominent topic of age assurance to ensure that children and young people engage with age-appropriate content and are protected from harmful content. And to give some concrete examples of materials that you will find on the Better Internet for Kids portal, just earlier this year, together with University of Leiden in the Netherlands, we published a mapping of age assurance typologies and requirements. It's a very comprehensive report that gives an overview of different approaches of age assurance and the associated legal, ethical, and also technical considerations that were picked up by my fellow panelists. And just to scratch on some key areas, first of all, a diverse approach to age assurance, really the approach of there is no one-size-fits-all solution, the crucial importance of privacy and data protection concerns that were also already highlighted by Jonathan, and the balance and act of effectiveness and also user experience. As said, this is a very comprehensive research report, and similar to what was already mentioned with existing laws and policies, we need to ensure that this knowledge, this information is translated in user-friendly guidance. So we also transmit this expertise and the knowledge we have to educators, to parents that are really, really crucial in this process. And also, how can we build capacity and make sure also this is properly implemented at a local and national level. And that's why also on the Better Internet for Kids portal that you can find on betterinternetforkids.europa.eu, we very much put age assurance in the spotlight. Specifically focusing on 2 stakeholder groups. First of all, the educators and families, really to provide resources to help proper awareness raising, but also knowledge sharing to foster digital literacy. I think this was also a comment that was meant, that was given in the chat earlier, really how can we ensure better and proper media literacy education. And that's why we developed an age assurance toolkit that includes age assurance explainers. And just to give you some examples of what users can find in the school toolkit, first of all, explaining what is age assurance in the first place. And I think it was also mentioned, other examples were given before. Age assurance might be a typology or a term that is not so accessible for many people. That's why we also in this toolkit provide concrete examples of when age assurance comes into place and why is it so important and how it actually can protect children. I think that's also important for carers and parents to understand why is this topic so important, how can it protect my child. And in addition to this, so this is a resource, and as I said, I have a printed copy here, so you can see it's a much lighter report. We also designed this together with children and young people. That's also what we really try to do in most of the work we're doing, to work on these resources also together with the end users, because ultimately it's for them. So it's also very important to involve them in this process. And I think it's always very eye-opening, because I think we are very much used to certain terminologies that is quite self-explanatory for us, but for some people, it is not so accessible. So that's also important to really follow this co-creation process. And then on the other hand, and Sonia touched up on the group already, on the black box of the industry, of course, the Better Internet for Kids initiative, we really try to bridge the conversation and also have industry and policymakers around the table when we discuss certain topics. So on the website, we also have resources aimed at digital services providers to check their own compliance. And this has been done in the form of a self-assessment tool manual and questionnaire that we also developed together with University of Leiden in the Netherlands. And really the aim is here for the service provider to critically reflect on their services and how these may intersect with the protection of children and young people. But what is important here to note is, of course, that it only provides guidance. So it's not a legal compliance mechanism. And here again, and it was mentioned also before, it's not a one size fits all. When we talk about online service providers, we talked about the gaming sector, social media, search engines. So I think we also need to acknowledge there the diversity. And then maybe just to conclude, also to highlight on behalf of the European Commission that of course a lot of focus and work is done here in the space. And this is also complemented by the work the European Commission is doing on age verification. For example, following a risk-based principles, the European Commission together with the EU member states is also developing a European approach to age verification. In the context, the European Commission is preparing for an EU-wide interoperable and privacy-preserving short-term age verification solution before the European Digital Identity Wallet is offered as of 2026 in the European Union. So I think conversations like today are really, really important, really trying to pull the different strings and bringing different stakeholders together to work together. And then hopefully in future settings of the IGF, we will also be able to have children and young people, but also educators participating in such conversations because we really need them. We really need to understand what are their needs, and for us then to act properly. And as I said, really build this bridge to share the knowledge we're having on the different aspects, and yeah, really make sure this is translated properly at a national and local level.
Thank you very much, Sabrina. And of course, the European Union is all diverse by definition because it's 29 member states that are all finding their way in this. Globally, this may be very good input. For me, experience that we have with capacity building in general is that we got examples from all over the world of good practice. We got legislatory examples, we got teaching examples, we got practical examples. But how to apply it best in your region is what the people in the region know best. So this is why capacity building isn't only on using the same guide around the world, but it's also about understanding the whys and the hows and make sure that it's applied for the Indian region, for the for the different regions in Africa. Africa isn't one region either, and Latin America, etc. So you can adapt to that and learn from that. Same with the relationship with children, with parents and institutions. It's different around the world, and we need to recognize that we can't set one standard for all, but we can have some principles that are valid for all. So with that, I see Jutta, you grabbed the microphone.
Yes, I grabbed the microphone because I saw a comment or a question in the chat that I would like to address. And that was the question, Sabrina mentioned the EU ID wallet that has to come into place in 24 months time. But already the European Commission has acknowledged that it might take a bit more time. And the EU ID wallet is an instrument for ID verification. So it's more than age verification. But the wallet is also foreseen to make possible age verification only. So it needs to have an option that you can use it only to verify your age, not to give away your identity. So, and that is very important in regard of the privacy aspects, the data protection aspect that were already mentioned by Jonathan Cave. The question was whether the Commission is developing their own age verification tool. I would not say the Commission will develop it, but they have issued a tender in October this year for the development of an age verification instrument that should be white labeled so that whatever age verification instrument is available in any country European-wide, but that might go global as well, should be possible. It should have an open interface to that white labeling tool that the Commission has issued a tender for. And they did so because they gave really priority to age assurance, and they would not wait these 24 months for the EU ID wallet to come. So that also shows how important and how topical the thing is that we are talking about here. Age awareness is very topical, not only for the Commission. We've heard several sessions talking about that already here at the Internet Governance Forum, and we are pretty sure that train is put on rails, I would say.
Yes, thank you very much for that. So with that, I think we've had a pretty good cycle, and I'd like to ask people also in the Zoom room if you have any final questions, or here in the room, if you have any final questions, raise it, and then we'll do a final round. Yes, I was looking at Dorothy's been very active in the chat, and Fabrice has been very active in the chat. Any of you wants to talk as well? Otherwise, we go to Sonia. As you're not raising your hand. Sonia, please.
Thank you. I just wanted to make a point that hasn't been made, and perhaps is a political point. I'm very struck by how much the industry innovates in relation to complex and challenging technologies, and then it introduces them into the marketplace. We're seeing this with AI now. Suddenly it pops up in all of our search and our social media in ways that were not necessarily asked for. And the same, of course, will happen with IoT. And then the worthy groups like us sit around and say, parents must do this, educators must do that. Of course, we want them to, but this is a major shift of innovation in commerce, placing an obligation on ordinary people and on the public sector. And it is, I think this is why the conversations about regulation, certification, standards and obligations on industry are really so crucial, because otherwise the burden of making a profit on one side really does fall on those who are already extremely hard pressed. So let's keep up the pressure on the industry without in any way undermining the argument that, of course, media literacy and public information and awareness are crucial.
Yes, thank you very much for that. Of course, regulatory innovation is also a point that is happening. We see it in the approaches within Europe. I'm European too, where the European Commission, for instance, with the AI Act, without immediately going to regulate, first invites the industry to come with, so what should we talk about? What should we regulate? How should good practice look like? And regulation doesn't only need to be from the countries, but it can also be from industry and self-regulation. But Jonathan, yes,
Yeah,
please. Oh, you know even more. I learned this from Jonathan. So please, Jonathan.
I just wanted to applaud Sonia's point, really, because a lot of these things in this whole kind of discussion, there is a transfer of responsibility from industry, well, from the developers of the tech part of the industry to the service providers and the comms providers and the others who are already regulated, and from them to us. And to a certain extent, society is being used as a kind of beta tester or alpha tester for these technologies. They're spat out, and the ones that succeed, succeed, and the ones that don't. Maybe they grow a regulatory structure around them to make them more robust. But the irreversible changes that take place will nonetheless have taken place and cannot be undone, even if we later come to regret them. And so some element of a precautionary principle, and B, an appropriate placement of responsibility should be important. And when I say appropriate placement, these things are uncertain. So where responsibility lies should be some mixture of being able to understand the uncertainties, being able to do something about them, and being able, in particular financially and politically, to survive the disruption involved in getting from where we are now to a solution that we can not only live with, but can sort of accept and understand. And I think simply provide and protect or responding to industry by shoring up the crash barriers and so on encourages industry to take less and less responsibility for the consequences of what it is that they do, or to define them in narrower and narrower and more technocratic terms, and to say, this is safe because in lab tests it works out safely. We saw this with medicine. This is why real-world evidence in the use of drugs is so important. They may survive a randomized clinical trial, but put them in the real world and they don't work like that. So there needs to be some way of joining this up so that industry at all levels, people and government are partners in something and not people sitting on a predefined responsibility. So anyway, I think that was a great point, Sonia. Thanks for making it political as it may have been.
Thank you very much for that. We got the lady. Can you introduce yourself in the room?
Thank you. And thank you for a very interesting session, which I unfortunately came a little late to. But nevertheless, I'm picking up on a few of
What is
those
your name,
points. My
please?
name's Helen Mason. I'm from Child Helpline International in the Netherlands. We work in 132 countries to provide child helpline services 24/7 to children and young people via a variety of channels. And I think 2 points really. I would say that we must include civil society and the first line responders in these kinds of discussions, because when things go wrong, they're the people that are actually talking to children and young people and dealing with reports of harms that have happened online. And building the capacity of those frontline responders is absolutely crucial in being able to respond adequately and report and know where to report to have proper alliances and referral protocols with law enforcement, for example, with regulators. So our work at Child Helpline International is really advancing this particular aspect to make sure that all of our members are well equipped to respond to all kinds of incidences that might occur online. And we have much data that shows an increase, for example, in areas like extortion, children and young people not knowing where they should report. Is there a crime committed? What should they do next? Should they delete the evidence, etc.? So having those frontline responders capacitated to be able to respond adequately is really vital for us. One more point I wanted to make as well is that the data that is generated by the child helplines themselves as a result of the conversations they have with children and young people is really a unique resource. So I would really encourage all stakeholders to have a look at that information that we collect. It's around prevalence, it's around help-seeking behavior, it's around trends around gender, for example, but also the case material we have has a lot of information about the actual experiences of children and young people. Of course, this is all done very safely and anonymized, and working together with people like Sonia, we can really use this information to feed back into policy. And I'd really encourage all of the stakeholders to take a look at the information that we're publishing online. Thank you.
Thank you so much for your remark. With that, please.
Thank you. Thanks for those comments. Very useful indeed. Thank you. I just wanted to follow up on what Sonia said about corporate liability or imposing obligations on the industry. We discussed this at a different panel yesterday. I wasn't on the panel, but there was discussions here about to what extent should that liability extend and who should be held accountable for. Should it just be financial penalties, or should executives be sent to prison for gross negligence and other lack of action? And I wondered if you had any thoughts on that, Sonia, because I don't think it is for want of obligations on websites or platforms or providers that things haven't worked so far. Financial penalties are sometimes too little, even if they sound like a lot of money for the average person on the street. For the large company, tech company in particular, it's not a lot of money. Would introducing criminal sanctions for corporate executives make a tangible difference? Is just a thought rather than a question, really. Yeah.
Yes, thank you for that. I think with this all, and this is one of the reasons I had several remarks throughout the session on companies will behave when they know it's paid attention to. I think I dare to hope, I'm an optimist, that some companies really care and do it from the outset. And I know there are companies who do. And I think these will be the companies from the long run, not from the short run profit so much. But accountability in that is key. What to be accountable for is the thing that we need to be clearer on. We're not going to mandate from this little group what a parent may or may not say to his child, what an industry may or may not put on the market, what a child may or may not do. But we can help by finding, making clear what are good practice standards, what to be taken into account, and the capacity development around the world is important in that. We discussed from early on that, well, if you protect children by not allowing them to use any of it, at some point they will be allowed to use, and then we dived in the dip. And this is the same problem we see, for instance, with internet access in Africa. The biggest challenge in Africa is to get online. But as soon as you're online, you're in trouble and have a lot of opportunities. So you need to be aware before that. Same is true for children. Capacity development is also for all stakeholders, legislators, administrations, let's companies. I mean, also for another example, there is what in Europe is called the Corporate Sustainability Reporting Directive. It's to make companies aware of the ecological footprint of what they do. And with that, move slowly towards more responsible behavior. This is something that here should be an obvious thing too. Third thing, last but not least, of course, there is legislation. You cannot harm children. Let's make sure that's understood what that means in the context of the new digital world as well. And last but not least, of course, it's also the ability to act is something that need to be brought in, and that need to be brought in together in reasonable ways. So this is, from the IoT perspective, also a very important part of how you deal with things, appropriate use for users, etc. But I really appreciate it to, again, after a couple of years, work together with Jutta and you all on something where this comes together, because in the end, technology is also for the people, and to serve the people is what I and my colleague Jonathan tend to believe. We go to Jutta and then to Jonathan and Sonia for the last remark. And Musa. Okay. And you're still last. So after my attempt to round off, we will now open up again, and then Jutta will round off. Musa, I'm unmuting you. Please go ahead. You can unmute.
Hello everyone. Are you listening?
Yes, we are listening and we're even hearing you.
Okay. My question is, sorry, I came very late to the forum. My question is regarding the how can defenders of free expression in these regions address the tension between the protecting cultural and religious value of holding the universal uh, holding, holding the universal rights and to free speech, particularly in deeply conservative societies. Are you listening?
Yes, I'm listening. I'm trying to comprehend the question that is behind this remark.
Okay. How can you get it?
Jonathan, you got it?
Yeah, I mean,
okay,
well,
then please answer and then continue with your final statement.
Okay, yes. If I understand the question well, there is a tension also between free speech rights, and in particular, the exercise of those rights by children, and the need to protect children not only in their own rights of self-expression, but from the harmful consequences of the self-expression of others, particularly in societies where freedom of speech is heavily restricted, that you have freedom of speech, but only in certain directions. And certainly in surveillance, I mean, take the right to be forgotten, for example. When I was very young, I said very many politically intemperate things. Later on in my life, I went through a period where I was very glad that those things had been forgotten. And then later on still, I came to a point where it was very important to me in my image of myself that it be remembered that I had said those things. But fortunately, the consequences for me were sort of non-existent or minimal. But we have seen that the consequences can be very great. And what that says to me is that when we talk about child safety and child protection, it is not just protection from the content that they see online, but from the social, legal, political, terrorist, whatever consequences of using those online platforms. And I think there is an issue there where the safety goes beyond the safety within the online environment. So I get that point. It's a hard question. I don't have an answer for it, of course. What I wanted to say by way of rounding off was really just on this last point about how we make corporations and actually governments pay serious and sustained attention to these issues. Now, I remember that in the antitrust environment, when the US passed the Sherman Antitrust Act, the liability on a company that broke competition or colluded was only on the company as an economic person. It was only with the Clayton Act, where personal liability was brought in, that the big trusts began to sit up and pay attention and change their behavior. So that personal liability does make a difference. In The Guardian today, there was a call for companies to be held responsible. This is the second aspect of this, not just for the harms that they have done in the past, but also for producing improvements into the future. And what we're seeing today with things like the Grenfell inquiry or the post office inquiry is that when something goes wrong, people are held to account. They're supposed to stand up and cry and abase themselves and say, we're sorry, we've learned lessons and so on, until the next thing comes along. This doesn't really help. It doesn't really help when the problems are systemic and when the problems cannot be remedied by somebody saying, I'm sorry, or paying an amount of money to somebody for something. We need something that is more continuously engaging. And finally, it is commonly the case, as we saw with Paula Vennels in the post office inquiry, that the people who are supposed to bear the responsibility evade that responsibility by saying it belonged to somebody else or that they didn't have the information. Now, in many criminal contexts, this concept of what I knew when I took the action is replaced by something which said, you were sitting in this position of responsibility, you had certain privileges, like a universal service obligation. This is what you knew or what you should have known. And if you're not aware of these things, that by itself is a black mark against you. And it's only the fact that these things went wrong that caused the light of day to shine upon that. So I think that we should take the issue more seriously. And with politicians, this happens. They come into office, they say things about children and the online risks, and then they move on to another office. And the box has been ticked as far as the newspapers are concerned, but it doesn't become part of the culture. That the safety of children doesn't become the kind of cultural value on which we act. It actually changes what we do when we have new decisions to make. Okay, so that's my call to arms, and now I'll shut up.
Okay, thank you very much. As a certified board director myself, I must say I've seen that ongoing trend, and I know I'm personally liable for not doing the right things, not asking the right questions, within reason, of course. If I exert my fiduciary duties in the right way, then I can make mistakes too. But I fully appreciate your point, and that attention, that's a crucial point. Also, a call for boards to be aware of what they tell their CEO to do. Make more money or make sure that you do it in the right way. So I see a lot of nodding heads here, and I even see Sonia smile. So Sonia, to you, and then the last word to Jutta, please.
Brilliant. Thank you very much. Lots of really great things said. I wanted to say something, come back to the question of children and their the way in which their rights can be heard and acknowledged. So users, the problem of the word user is a really problematic word. And I think if we talk about users, we can quickly forget there are children. So by and large, in relation to IoT and other innovations, by and large, children are not the customer. They don't pay. They don't always set up the profile, especially for IoT. They don't seek remedy unless we scaffold that. They don't bring lawsuits. They don't get to speak at the IGF. You know, they are kind of uniquely dispossessed in relation to these debates, and yet they are 1 in 3 of the world's internet users, 1 in 3 also of the world's population. And if I continue my statistics, you know, 1 in 3 of the users are children, 1 in 3 are women, and 1 in 3 are men. And we have to rethink who the user is and recognise their diversity. I think my last word might be to mention, as hasn't yet been mentioned, that in General Comment 25, the UN Committee on the Rights of the Child has set out how the Convention on the Rights of the Child applies to the digital environment, including to IoT, including to age assurance technologies, including to a whole range of digital innovations. And in so doing, it maps out and tries to look within the industry and all of those who provide the checks and balances around the industry, as well as speaking to the state. So I think what we're saying when we want companies to be aware, or board members to tell their CEO, or perhaps executives to get arrested when they land at Heathrow, wherever, I think we're trying to recognise that there are very many actors within this sector and very many agents who can be part of the process of making things better. And I would include those in the engineering schools who are training tomorrow's engineers, and the data scientists who think they're just processing anonymized data. It has nothing to do with them, and the marketers who are creating a certain vision of the user and how it might be used when they promote the technology, and so on and so on. You know, great that we've talked about procurement, which I think is a really critical lever, but there are many. And so I would like the next session at the IGF, if I may be so bold on this topic, to include representation and the voices of children and young people in the room. and to begin with a more disaggregated vision, both of children, but also of the actors who are shaping this technology of the future. Thank you.
Thank you for very beautifully said.
Thank you for giving me the last word. I don't think I need to do any more wrapping up because everything has already been said. Just to put really emphasis on what Sonia said at the beginning, that children are being impacted by Internet of Things, even though they might not be the users as we understand users so far. But if developers have that in mind, I do think that is very important. And to reflect on Jonathan saying what he was saying about the politicians, I just need to mention that yesterday we had, for the first time ever in 19 years of internet governance, the main stage for children's rights. We only have 5 high-level sessions set by the United Nations, and one of these 5 sessions was set for children's rights in the digital environment. So awareness is raised. We have come a long way, and we have a long way to go. But still, these are steps that are milestones, I do think, and people will remember that, and we will bring it forward to Norway next year. Thank you so much for being here, for listening, and for taking part. Thank you.
Yes, thank you very much. I just want to applaud this too. Thank you so much, everybody, for attending and for contributing in any way, shape, or form. And really appreciate the session, not only as a DC IoT person, but also as a father and even a grandfather. So see you around. Yeah, that was good. We can refer to it.
This will be the future of dynamic conditions. And of course, 35 next year, with all having
It's so difficult. Some really
Yeah. Yeah, yeah.
Are you going for lunch? I'm totally exhausted. Thank you for looking at it. You are made for, I'm sure. It's just,
Thanks, Thorsten. There was very little need for online interaction. But at least some.
Thank you.
The thing is, I mean, we care and we really put a good preparation together, and we played a major role in that because at the moment it's a lot. So without you, we would not have been able to pull it all together. I think the same goes for you, right?
yes, that's absolutely.
We care more than we put in time, and you help make things come together.
The end, we have to make the takeaways and the messages.
Oh,
but after lunch, maybe we can think about and then share with you.
Who has access to that document, the reporting document?
We have no one. We send it to via Celine. Celine put it on the page. No one of us put it via the document.
Okay, and it was explained in the message that came from the secretariat yesterday that for all sessions today and tomorrow it goes directly to them. And we had three key takeaways.
And two
call to action. We will be able to do that. We prepare something and then I don't think we have another session. What's the session today? I only have that preparations for the interview.
For me, the three lessons are legislatory, good practice, and standards are key to understand what to do from design. Second one is capacity development for all stakeholders to be aware, able to express it. And the third, accountability is key.
Yes.
And I think with these three, we've got the takeaways.
Yes.
Actions takes maybe a bit more time, but would you agree?
I would agree. Will you write it down?
I'll send it. Should we make a picture altogether?
Okay.
I'll send it to a little group of 4.
Don't come up and let me hide my arm behind you because you're tall.
I'm tall.
And nobody will see my rope. Thank you. Yes, I will share, of course. I will email.
Thank you.
Yeah.
I'll send it to the 4.
Yes. Second, then.
And we need to add action, right?
Yes.
It's good that you have more than 1.5 hours. Although we could have closed for another hour. We could go some extra time.
We have been looking for emailing everyone.
Write it down. I have an idea on the and wrote that down.
Okay. Yes.
I have no control over it. It makes my lunch.
For moderating that wonderful session. Yeah. Thank you, Jutta. Which way? Thank you. Yeah, thank you. We'll see you around.
Martin schreibt gerade die 3 Key Takeaways auf, die brauchen wir gar nicht mehr abzustimmen nachher.
Alles klar.
I think accountability is key. We become accountable for what we have the challenge that we don't know yet what is. So that may be one of the action points, right?
Yes.
So up to 3 action points.
Only 2 action points.
Okay.
One was from Jonathan, make governments to take serious considerations.
Sorry?
Make governments take serious considerations and stay continuously engaged.
Take serious consideration.
Yes. Not only saying blah, 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 but seriously considering and staying continuously engaged.
So involve governments, basically.
Yes. Oh, yes.
Because we can't make them.
No. Yeah. Force governments too.
in tracking the practice standards? Or
Yes, bring the standards and it's really good.
standards for children in the digital age or with IoT?
With IoT. It's an IoT session, so it's
Or English or IoT?
since it is also in the GDC, the child rights impact assessment obligation, it would fit into.
Okay, and what
You could make it in brackets because it could be part
of the serious considerations. The child rights impact assessment.
CRI.
including?
Yeah.
I will say
Yeah.
AG, but it should be including. Impact. The second one?
You don't need to have to. When you have something really pressing, we can put one. I don't think the procurement thing is ready for a call to action. It needs more explanation, and we can take that forward to Bergen, Norway next year.
Is there anything more we need to do towards other groups? Or is progress insights in something?
Maybe in the first third of the discussion was that there is no age assurance method around which is child-friendly, privacy preserving, protecting anonymity.
Then we could just call it an actionable point. Develop privacy preserving, user-friendly age assurance mechanisms.
Well, yeah, it's being aware of course of privacy, responsibility, and accountability. I mean, GDPR is sort of global, and that does require a minimum information provision.
The GDPR is not the best example, but on the one hand, it asks for parental consent for under 16-olds, but on the other hand, it asks for privacy preserving, and it nowhere says how this should be brought together, and that is what caused the European Commission to have issued that tender before the ID wallet comes in. So I do think when we want to have age-aware IoT, we need age assurance that is privacy preserving.
That's takeaway, right? So go back to takeaways, good practice, including age assurance, establishing of age.
Yeah, but it is a takeaway, but it's also an action point. So
it's because so far we don't
we recognize we don't have a child-friendly age assurance, so we have to develop for a need for. Otherwise, we will not reach an age-aware IoT to create
if no one developing
appropriate
and
identify good practice examples and approaches from around the world, including age, child-friendly age, including.
No, I would more say privacy preserving is more important than child-friendly, because that is relevant for all users.
Age identification.
Yes. Or say age verification, because identification people always consider it someone knowing your personality and It's not about identification, it's only about age verification.
Privacy preserving age identification.
Just don't use the word identification. It leads people into the wrong direction. Because then they think.
Do you do with age? Do you identify?
Verify. You verify.
Verification. Okay, verification. Okay. Okay, then we got two action points. Involve governments to design, development, and backing of good practice standards regarding children in and their use of IoT, including child rights practices. Identify good practice examples and approach from around the world, including privacy preserving age verification methods. We consider sharing lessons regarding children's rights.
Yes. And the three takeaways are fine with me.
We should be check this with Jonathan and Sonia as well, or
I think it's up to us to do so. I prefer to send it to them because then it has an opportunity to the secretariat right now because it has the option to go into the final messages of this IGF.
Yes.
And then we have a.
We can give them 2 hours, right?
Okay.
And you have time to post them after that, if, after 2 hours, if there's no comments.
Okay. Okay. Yeah, that's okay.
Again,
and I check then after 2 hours if there's a response.
And that we and we will need to have a more detailed report by January the 9th.
Drafts, take aways and actions for the IGF report. Please provide in the next 2 hours, after which posting will
We do. Great.
So we are still, yeah.
We've made it an obligation for ourselves to have a daily report on the IGF on our website. So that is where I will take the notes I've taken on paper for the website report. That is a bit different from the long version report for the IGF, but that we can take that as a starting point for that more elaborated session report. So we prepare first, send it as a draft, a rough draft to you. You can add something in that. The deadline is January 9th, so we have some time for the longer report.
Yeah, I mean, we don't need to agree everything with all the speakers. But
No.
It's nice if we have something final to check if there's anything we forgot. And Jonathan, I would like to keep in the first line because he was not in the room, but We do
He's brilliant.
things together. And
Yeah.
he's sharp, if you notice.
Yes.
He's not the only one who's sharp, actually.
Yes, you still have IGF 20.
Yeah.
Talk is so well.
I really enjoyed that one.
Yeah.
I remember I arrived in the middle of the night, very dark in my hotel. And the next morning I come out and the doors of the hotel open and I see the ocean in front of me. It was on the ocean road.
Yeah.
It was just the water. So
Well, Kosovo was really nice.
from that moment on, I loved the idea.
You have not been to Rio de Janeiro in 27, the second one?
27?
Yes, I was in Rio. The first was in Athens, 26.
26?
2006.
Oh yeah.
In
Oh,
Athens. And then
that's-
2007, it was in Rio de
I
Janeiro.
wasn't there.
It compared to what's here. We were in a hotel, somewhere at the outskirts of Rio de Janeiro. No wireless internet. No wireless internet. They had been running all these LAN cables on the floor. And then it was raining time. All carpets were wet. All the cables wet on the wet carpets. It was crazy.
I know that in ICANN, I'm in ICANN since 2008. First as a PIR, later on as director. And in the early years, everywhere we went, we sort of took over the Wi-Fi of the hotels that we contracted with to make sure it had adequate connectivity within the hotel, but also from the hotel towards the main hubs. Nowadays, it's often not necessary anymore. Also for IGF, we've been very instrumental in helping with the hybrid settings with the translation services.
Yes.
And I still recall the first after COVID hybrid meeting in Poland. They were not guided by us.
No.
I was in several sessions where porn was shown.
Really?
Yeah. They didn't know how to exploit that yet. And even today, there's flaws in the model because if you go to the scheme schedule, anybody can come in. No need to register.
Yes.
I like that. It also gives flexibility. Some of them, for instance, forgot to register in time, which should not have been a problem for online participation. Right? It should have been allowed even for people from Saudi Arabia who can't come in the room anymore.
Yes.
Participation, no reason to limit that.
There was a special link for late participation of speakers, which should have asked Secretariat. Because one of ours also missed the deadline. We didn't know that there was a deadline for registration. And on site, you could come.
لا في واحدة بس بريك لأن أنا ما خليت شوية في كانت بريك بس يمكن عشان تغطين مكاني لأني أنا بطلع بعد شوي بريك قصدا أنتي طلعتي بريك؟ بس كانت تنمي على إنه خلاص بيحطيها
Yeah. Yeah, no, we're looking at this. I thought the camera was there. Come on. You see? Take a look.
Hello, hello, hello.
Oh, that's the mic as well?
Yeah. And then if I don't, so you want me to use this? Use this. Perfect. I have a big ear. Yeah. Wow. So when I don't speak, you can hear me? I figured it out.
You're facing the screen. I know, I thought we were sitting on. Can you please begin?
Yes,
You've been doing it?
I have been, and I can't move more because of the connection. Ah, that is alone.
What is it about? How is it? How come timing? Yeah.
Hello, can you hear me?
Yes.
Yes, we can hear you, yeah.
But I think the people in the room cannot hear us because they're not reacting. Ah, camera, yes.
And you can also edit your name now. I
Very
figured
good.
out that it's
Very good. Thanks. But I'm not sure if the people in the room can see me or us. Can you see us?
Yes, we can see you.
cool.
Excellent.
Thanks.
Hi.
Hi.
How are
Can
you?
you hear me?
Good. And you?
Also good. Thanks. Yes, I can hear you.
Mine as well.
Yes.
Yeah.
I have this light directly above myself, but maybe it's
You're very bright.
very good. How is it going so far?
It's going well.
Yeah, it's good, but there is no audience. I think they're busy with the lunch time.
Ah, okay, everybody. We're competing with lunch. This is, of course, always difficult.
Especially the Arabic region, they have late lunch from 2 till 3.
Okay,
Not
so
like there.
precisely now.
Yeah, yeah.
Are we waiting for one more person in person though, right?
Yes. Nisha, that should be joining in person. But I can also text her. And Elena Perotti is joining online, but she already informed us that she will be 2 minutes late. Let me just text Nishat. Ah, it's already noon, yeah. It's room number 6, right?
Yes.
Thanks. Let's see.
Claire, will you also be moderating? Should I introduce you as well, since you're on screen?
I won't be moderating. I can also turn off my camera if it's more convenient.
No, I'll just introduce Julia, so I might introduce you as well from the OSCE team. Do you have a title you want to give me, or?
Project assistant.
Hello, hi. Here's our 4th speaker. Excellent. So we will have an interesting conversation among ourselves, it seems.
Some people might be online too, though. I'm not sure if they're let
Yes,
in
we
yet.
see there are 10 people at least. I don't know how many are still able to join.
How do I pronounce your name? Nijat?
Nigat.
Nigat?
Yes.
Dad.
Nigatat, yes.
Thank you.
Thank you. Sorry, I was late. I had a meeting with our parliamentarian.
Oh, that's okay. Okay. I mean, it's only 2 minutes past, right?
Yes, I think we can still maybe give it 2 more minutes, but then
Yeah.
I guess because we will have to finish also on time, there will be another session in the same room at 3 your time. So we probably shouldn't wait for too long. But it looks like a very nice menu. Did you join already a few good sessions, good discussions?
I was just saying that the venue is very nice, but you can't even see the ceiling. That's the real highlight. It's very beautiful, very decorated.
Okay,
It's a
okay.
palace.
It is a palace, yes.
Very nice. Okay.
Yeah.
Great. And I see we have a few people now in the audience, or I don't know if they're still getting or not.
I think they are working here.
Ah, okay. Well, maybe it will still be an interesting conversation.
I'm sure.
For sure.
Yeah.
No, I mean, for us, for sure, but I meant for them. But in any case, I think probably it would be good to start in a few minutes.
Yeah.
Yeah, and you said each person has like 3 minutes to kind of keep their answers relatively short.
Yes. I mean, I don't expect a lot of questions from the audience, from the ground, from the floor, but it would maybe be interesting, especially if we're such a small group, it would be nice to just have a conversation, and then maybe you can really do it these 2 rounds with kind of like first focusing a bit on challenges and way forward, but then maybe there's also really possibility for an interactive exchange, right?
See if anybody, yeah. And you guys can look on screen, right? I might see it here
Yes.
actually as well.
We should be able to see, yes, we see the screen.
So I might just ask each of you to introduce yourselves, because it's nice to hear from, so I'm not just talking for 2 minutes. So I'm going to turn over, maybe you can introduce just your name and title and where you're from is interesting. And then I'll kick it off after. So just a very quick name, title, and where you're from.
Okay, I'm happy to start. So my name is Isabel Lois. I work for the...
When we start the, have we started already? No, right?
Not yet.
Okay, so we can kick off, I think.
I think we can kick off.
Yeah.
Go ahead.
Please go ahead, Martin.
Hello, everyone. My name is Martin Semen. I'm with the United Nations Department of Global Communications. I will be moderating this session together with Julia Haas, who you see online, advisor to the representative on freedom of the media with the Organization for Security and Cooperation in Europe, or OSCE for short. A warm welcome to everyone. We are here in Riyadh for the 19th Internet Governance Forum. And this workshop is led by our fellows on the screen here, OSCE. This panel will focus on leveraging technology for healthy online information spaces. And with us today, we have a great panel. I'm going to ask you each to introduce yourself briefly, starting with you.
Yes. Hi, everyone. So my name is Isabel Lois. I am senior policy.
This is Sadi. I'm from Iraq, founder and president of Tech for Peace, and also IFCN Advisory Board member, which is the International Fact-Checking Network. We are working as Tech for Peace for the debunking misinformation and also in digital security and digital rights in the MENA region usually. Thank you.
Hi everyone, my name is Nigat Dad. I am an executive director of Digital Rights Foundation. We are based in Pakistan. We work on generally digital rights issues related to freedom of expression, right to privacy, tech-facilitated gender-based violence, have a very keen eye on regulatory frameworks as well, emerging from different jurisdictions. And I sit on Meta's oversight board as well, looking at the content moderation decisions of the company and holding them accountable.
Thank you so much, and welcome to the people online and those who have joined us here in the room. Today we'll hear about the main challenges of big tech in the information landscape, and we'll identify different stakeholders' role in addressing the many challenges that arise with this ever-evolving and quickly evolving technology. For nearly 2 decades, the IGF, the Internet Governance Platform, and at the forefront of tackling the digital opportunities and challenges that face our world. And as the United Nations' largest multi-stakeholder gathering, the IGF brings together governments, businesses, civil society, and the tech community so that we can all together shape a safer, more inclusive, and equitable digital future. So it's great to have you here at the Internet Governance Forum. I will now pass the floor to Julia online, and she's also joined by Claire Herring as part of the OSCE team. Thank you.
Thank you so much, Martin, for kicking it off and introducing. It's really great to join, at least online. It's a pity I cannot share the table with you, but it's great to really have this multi-stakeholderism that you referred to, Martin, I think also really reflected on this panel. It's great to see that we have people from civil society, from international organizations, from a state, the Meta Oversight Board, of course, also being a particular body that stands somewhere in between, right? But all fulfill a very important role. So I truly believe that this will be a very important conversation, even if many people will be at lunch. But in any case, I'm very excited to see you all here. And also to hear about this UN context and the importance of IGF, which of course the OSCE would also agree to that the challenges we're talking about can only be addressed in a multi-stakeholder manner. So we already briefly heard the title of this session at least, but just also to give a little bit more context that our intention with this session was really to discuss both kind of the impact of big tech on the information landscape and how state can limit any undue undue power or control that we see over the information space or the power concentration. But then also on the other side, what can be done in contexts where maybe states would not be so eager to intervene, or where maybe we don't have a lot of very strong democratic institutions or rule of law standards. So really, how can we find a way forward to address the challenges? And ideally then in the last step, so to speak, to also see whether and how technology can actually be leveraged for a healthy online information space, which is this overarching title of today's session. And that is also the name of a project that we are currently working on at the OSCE RFOM. And in the framework of this project, we are currently working on developing recommendations for states on media and big tech. So within, I mean, as you, Martin, already rightly referred to, of course, in the title of our organization, the representative freedom of the media has a particular role to play, which we also acknowledge in the information landscape. It is about freedom of expression, privacy, many words we already heard. But journalism and independent journalism has, of course, a particular role to play. So we are currently also exploring how media and big tech are intersecting, what are the particular challenges for journalists and how to address it. And in this context, we're particularly looking at media sustainability, the accessibility and availability of public interest information. So also questions of visibility by platforms and these kind of things, and journalistic protections. And I'm just mentioning this not for purposes of self-promotion, but just to indicate that the conversation we will be having now is really feeding into this process. This is a multi-month process, and we are currently holding several roundtables and discussions, including the conversation we are having today. And we really want to build on all of your knowledge and all of this expertise and experience as to feed into the guidance that we will be developing for states before summer next year. So having said that, I'm really very much looking forward to hearing from all of you and learning from you, and see how we can empower the information spaces and also actors that are particularly important for the information space, such as journalists in that case. But maybe before we dive into specifics or into the media question already, it would be very useful, I think, for all of us to get a little bit help for setting the scene. And if I may ask you, Nighat, to help us with this, to tell us from your experience. I mean, you, of course, already mentioned that you not only have great expertise from civil society perspective, from the organization you founded and are leading, but also have, of course, a lot of insights from the Meta Oversight Board. What are the key concerns? What are the challenges? So can you maybe, in the outside of this session, tell us what you consider from your expertise, from your experiences, are the main challenges of big tech power, so to speak, over the information spaces? Thank you.
Is this working? Okay, right. Yeah, no, thank you so much, Julia, for setting the scene. Yes, definitely. I wear another hat, which is like sitting on Meta's oversight board, which is now it's been 4 years, and I'm one of the founding members. And I think board is a very unique institution, like one of its, like first of its own kind, in terms of, you know, like the accountability and oversight mechanism when it comes to big tech platforms, but in our case, it's Meta. I think I come from a very unique perspective where, you know, the jurisdiction that I have come from, the rule of law is not really strong, right? So many of us who have been advocating for open, safe, online, accessible spaces, we have seen emergence of regulatory frameworks, and I think we need to keep one thing in mind, that all these regulatory frameworks emerging from different jurisdictions are not all the same, right? So we have a very good example of DSA, which many of us really look towards to, and looking forward to the enforcement of the regulatory framework from the Europe on the big
platforms. But when we look at our own examples, we are kind of concerned and worried in terms of there is not really meaningful consultations when it comes to multi-stakeholderism, right? So including civil society, when these frameworks are being designed or debated by the government or parties related to these regulatory frameworks, for instance, regulators in our case as well. And then you look at other mechanisms. So you're like, okay, we are in between two powerful actors. One is state, and then another one is tech giants, right? So what kind of other mechanism you have, especially when it comes to users, that you can use to hold tech companies accountable? And I think that's why I feel that oversight board is in a very unique position where it is independent. It is an oversight body. It's set out as a unique experience, and now it has become an institution. And I would encourage people to look into the cases that we have decided. We are a diverse group of people. We are not, from global north or folks from Silicon Valley. We are from different regions, diverse backgrounds, diverse experts. And we actually take up cases that sort of like appeals that are filed by the users, but also where company struggles. For instance, in some of the cases, we have looked into like journalist cases. For instance, on top of my head, this one particular case that we decided in the very beginning of our term, it was the word Taliban, which was kind of wrongfully removed, kind of over enforced on Meta platforms. And this is very jurisdiction, like this is very much related to South Asia, Afghanistan, and I don't think that many folks kind of know about this in global north. But we took up this because it was the over enforcement was putting hurdles into journalist reporting who were actually using these platforms. And we took this up, we deliberated on this case, and then we told Meta that there is an over enforcement of this word. So you really need to look into the terms that your community standards and the policies that you have in terms of, sort of regulating such kind of terms. But it was basically to make it easier for media and journalists, especially in South Asia. So this is just one example. But having said that, what I mean to say is that when we look into the role of states, governments, and the power of tech giants, we should also uh, uh, broaden our own ideas, that they are not just regulatory frameworks that we need to look into, but we need to look into other institutions as well, where like the jurisdictions where states are actually regulating on their own terms and not in a meaningful way. Then what are the other institutions who can come to help to the users when it comes to protecting users' rights on these platforms?
Thank you so much for giving us this oversight over the overboard work. No, but it's super interesting to hear the broad variety of the work. And I think what is really particularly useful also for the work of people in this field and for the digital rights community, so to speak, is really to also look at the guidance that is being developed. So it's not only about individual cases and individual protections, which are of course crucially important, as you rightly point out, but also to learn from that and to take it a step further and say, okay, how should policies be adopted, adapted, and what can be done in addition to it. Another thing that I found really extremely useful that you mentioned is really this point for the need for diversity and understanding local perspectives, because it's really different. And this is something that we see over and over again with technology being deployed globally. The impact is very different, especially if we don't have the same capacities or even language capacities, then it is a bit difficult, or the implications might be even worse. I see now that our fifth speaker has also joined, but couldn't yet turn on her camera. So maybe hopefully our technical colleagues can help us, because we already spoke about this aspect of understanding local context, where sometimes with specific words you might have and over enforcement or under enforcement, which are both problematic from a human rights perspective, the context is so crucially important. And this is something where I would like to bring in Avs. You mentioned this also when we had our preliminary conversation on this, that you have this experience that also in the context you work on, it's very different, the big tech challenges, because the context maybe less strong democratic institutions or less checks and balances, both from the state side as well as from the platforms who are very active in areas but don't deploy the same kind of resources and attention to the regions. Can you maybe build on this a little bit and tell us what your experience is, or the specific challenges you would see in this context?
Thank you for the question. In general, we are working in both languages, which is the Arabic and Kurdish. So in general, the tech companies or the platforms, they are not supporting Kurdish anything. Like there is no program as a third-party fact-checker with Meta or as a global fact-checking program with TikTok working in a fact-checking in Kurdish. So the last October that we had an election in the Iraq Kurdistan area, there is a lot of misinformation and even when we expose it, you cannot flag it because there is no program supporting this language. Even there is more than 60 languages in their program, but still they're not covering this area. And for the Arabic content, they have, for example, I give you an example, in Ukraine, they have an award, there is 9 organizations working as a third-party fact-checker. If you go to Spain, which is, there is no war, there is 5 organizations working as a third-party fact-checkers. But if you go with the whole MENA region, you just see 2 organizations only, which is one of them from France organization, which is the AFP, and the other one is for Fatabainu, which is the Jordanian. And even there is 7 organizations, which is they are signatory by the IFCN, because one of the rules that from Meta or TikTok, if they want to be as a partner for the fact-checking, you need to have to be as a signatory from the International Fact-Checking Network. There is 7 organizations from the Arabic region, they are signatory. And even no one from, just one of them, which is Fatabainu, they are as a third-party fact-checker. And the other side also for the gaps that we have, it's in the Arabic language, is after 7 October 2023. What's happened between Israel and Gaza, there is a lot of restriction on the Arabic content. Even as fact checkers, when we are exposing fake news, they flag our content that we are celebrate fake news. But in reality, it's because of the automation. They take the pictures that we are exposing it, and they flag it as a fake news. And the sources, the links that for the fake news is not flagged. So it's instead of fighting the fake news, they are flagging the organization in Arabic that's working to expose it. And because we are a trusted partner with Meta from 2019, so we send it to them like, look, we are exposing it, we are not publishing, and then they just restore the content, and even they didn't solve it completely for the Arabic content in the region. But if you have a relationships, like if you have connections with them, then they will restore your content. If you don't have it, you will appeal. I know a lot of organization and a lot of users, influencers, journalists, human rights defenders, their accounts like stopped because they taken down. And when they appeal, it's the automation who's reviewing it. There is no human person reviewing it, and then it's go again as a rejection. And the other things, which is the AI tools, as a technology, usually most of the AI tools you can find it started in English language and for the fact checking, but in general for the Arabic it's not supported. So this gap is difficult because if you want to build your own tools, you need funding, you need to work a lot with this technology issues, and it's difficult in that time. And also, I'm talking about the media literacy. We have it's really low media literacy in our region, and around 30% people inside the region, they are not connected to the internet. And I give you an example for Iraq. Most of the channels belong to the parties, and it's not independent. So if they have some kind of campaign misinformation, the people will believe it, and then in the election they will going to vote for them. And I will stop from here. There is a lot of points, but it's better to have more conversation from the other side. Thank you.
Thank you so much. It's really, I think you really greatly underlined the interconnectedness of it all, right? That you really say there are so many different layers to the challenges, but then technology is not necessarily helping, but might even perpetuate some of these challenges if there are biases or no language knowledge or attention or even fact-checking partners and trusted partners and all of that. So it's really important to see how different kind of what angles can be leveraged and how can then the entire ecosystem ideally benefit from it. Second point that I found really important that you mentioned is the necessity to have a human in the loop. This is really this kind of thing that has been called for by civil society and many actors for the entirety of the conversation around content moderation. But I think you pointed out to the fact that particularly in contexts where the language or the automation is less specific with regard, for example, to the Arabic language, it's a bit difficult, or it's even worse and more difficult. So thank you for outlining this. I wanted in this first round of better understanding the complexities of the issues when we speak about information spaces and big tech and technology, also really bring in the particular component or the particular aspects of journalists, because this is something that both of you touched upon already a little bit in the sense of how journalists are affected in your respective work in your respective areas. But we know also from the global media scene that big tech has challenge or provides challenges to journalism also on other levels because of these dependencies that have been created when we speak about the distribution, when we speak also increasingly about generation, as you all know. So I wanted to bring in Elena Perotti. We had a very brief introduction before you joined, so maybe you can also start with briefly saying who you are and what your role is at One IFRA, and also tell us this particular role or where you see from also because it's a global organization that you're working on, if there are some kind of like specific implications that you see big tech has on journalism, in addition to these overarching challenges that we discussed so far, or specific regional and language-specific challenges. Is there something you could help us to better understand what are the key kind of like overarching concerns by the current power that we see from big tech and the concentration of power that impacts journalists and journalism as such? Thanks.
Absolutely. Thank you so much, Julia. And I have to apologize towards everybody for being late. It was the train's fault, but again, I'm very sorry, very happy to manage to be here on time, kind of. Well, I'm Elena Perotti. I am Executive Director, Media Policy and Public Affairs at One IFRA, which is the World Association of News Publishers, which is, imagine, a trade association for publishers all around the world. Our main constituencies are the national associations of news media publishers, therefore the bodies that try to lobby their countries or the European Commission when they are European to obtain better conditions for the business of the publishers again. And my constituency in particular is exactly that, the one of directors of national associations. So I'm privileged enough to have a real global outlook on what the concerns are of the industry all around the world and how incredibly similar they became, particularly ever since the digital era starts, which I would place at the start of Google, so it is 2000, and then everything changed again, 2006 and 2007 when Facebook became mainstream. Well, you, Julia, asked specifically about journalism, whereas again, my expertise is with the publishing business, but I do, of course, have also journalists in my radar. And one very interesting point of view to remember is that at the very beginning, when publishers were already starting to get worried about this increasing power of big tech, journalists were generally not. They just weren't, because the interests did not align. Whereas for publishers, it was clear right away that big tech was about to eat away at most of the revenues of the industry. For the journalists still saw, and I'm speaking 15 years ago, even only 10 years ago, I would say, they were still seeing as much more relevant on scale the fact that Google or Facebook or the others who came afterwards would allow their content to be disseminated more widely. So the interest really of journalists and publishers did not align at that point. What I see now, ever since 3 or 4 years, is that now also the journalists realize the problem, which is, in a word, the problem is disintermediation. So big tech has the power of giving to the person who is not extremely interested in news enough news on their platforms so that they would not click through to go to the publishers' websites, and therefore the publishers will lose money directly, and therefore they will not have money enough to fund the journalism of professional journalists. That is the macro problem. The other macro problem, of course, is that in the last 15 years, the advertising revenues of publishers all around the world have halved, literally halved. I actually prepared a couple of data to fire out to you. Of course, I don't remember them by heart, so I'm reading. But in 2024, there will be 1 trillion in advertising that will be transacted in the year 2024. 1 trillion, which is an 80% increase compared to 2019 pre-pandemic. Of that, 1 trillion. Legacy media, so the professional publishers of news, will have about 30% of that ad spend, and 2/3 of the rest is going to go to Alphabet, Meta, Amazon, and so on. Not even to speak of the new advertising revenue, because every year new advertising revenue is created. Of that, and I'm not exaggerating, more than 80% goes to platforms. That is, I know I'm speaking only money, but by speaking money, I'm also speaking democracy and speaking professional journalism and ability to do investigative journalism. I also speak in security of journalists being sent in war zones, because all that cannot happen if the publishers are not sustainable. So there is really, I would say, Julia, to answer your question, that the main threat that big tech brings to journalism is the defunding, basically. That is what it is. And I don't know whether big tech is in the room. I have no idea. But they have tried to work with news around the world, with signing contracts, of course, and so on. They have given handouts sometimes, but that is just not enough. It is, I think, a democratic responsibility of governments, but also stakeholders like us, to find solutions so that the defunding of professional journalists does not happen, because that is dangerous for democracy. I don't know how much time I have, Julia. I could speak of this literally for hours. So just let me know.
No, excellent. This was a very good overview already. I mean, I think it's really important that you underlined how this question of sustainability or funding is not linked to the question of running a business of a media outlet, right? But it is really the question of what kind of information is available, what kind of investigations can take place from where, to what degree, so that it is really a democratic question, as you rightly pointed out. And if we want to discuss on how can we fight disinformation, as we heard before, or how can we avoid that people are attacked online, or how can we make sure that people have election integrity and have information available, all of this is linked to the availability of public interest information. So we can only speak about visibility and accessibility of such information if it is available, and it can only be available if there is sustainability and funding in the background. Yes.
I just want I just saw my note. You asked me whether there was any language specific concern, and just very local specific concern. Just extremely briefly, the main concern in small in societies that speak a very specific language, so of course, not English, but not even Italian, French or Spanish or German. I mean, Rohingya in particular, for example, of course, the problem is misinformation. That is, I would say, is really number one problem, because platforms do not invest enough at all in fact checking and in checking misinformation in small languages. Please pass me the term. 80% of Facebook's money for dismantling disinformation goes to English languages, and as a consequence, as we know, this can have deadly consequences literally to people, and that is where local news is even more important, because again, if you have to fight misinformation, you have to do it with professional journalism.
Yeah, absolutely. Thanks for this addition. It's also what we kind of started off with, I think, before you joined, about this whole question of how difficult it is to have fact checking if there are not sufficient trusted flaggers in specific languages or contexts. So you have all these different layers, how that add up to the challenges. And local journalism is, of course, also at the forefront of being not only under threat very often from different actors, but also the first ones who struggle with funding and with advertising and all of that. So it is, again, this interrelatedness. And when we speak about this interrelatedness, and also, Elena, you mentioned this democratic responsibility, which is a term maybe I would want to build on and hand over to our state representative in the room. Isabel, you coming from the Swiss context and the Federal Office of Communication, you do, of course, a lot of work in the Swiss context, right? And also on a more global level, Switzerland has been very engaged and constructively engaged in many also regional and global initiatives that try to work towards this healthy online information space that we're talking about, with this journalistic component, but also with regard to fact checking and fighting disinformation and user rights. I mean, all of the things really that we talked about. Is there something still before we move? I mean, I know we are now already maybe moving more into this direction of what can we do and what can states do also. But can you either already refer to that, or also say a few words still about how you see as a state really these challenges, and from the state perspective, how they're interlinked from this global perspective? What does it really mean from your point of view?
Absolutely. And thank you for this very interesting question and very interesting panel. I wanted to move a little bit away from the notion of big tech, because ultimately, I think when we're discussing these issues, they exist independently of how big the economic actors behind them are. And at the Ofcom, we work a lot with media. And so when we're looking at traditional media, what we want to promote is a diverse information landscape that will allow real debate in the public sphere. This is really the core aspect of having an important media. So the larger platforms today, they act as sort of gatekeepers, because they are controlling what information is amplified or suppressed. And this might not be by design, but it is something that we have seen happen. So this is not, the issue is here that there isn't enough transparency and accountability from bigger platforms of controlling or seeing how the information is flowing. So that means that the public who is reading and being online does not have the knowledge of how and why some information is put forward, why some posts are put forward and are viewed, and why others are not. And this gives these bigger platforms a sort of de facto agenda setting power. And this is where we can see the biggest issue. This new power of setting the agenda, of putting certain issues on the map, reshapes the public debate, because we are, of course, I guess, all connected and all using social media and other platforms. And so it will prioritize certain debates, certain issues, and hide others. And the engagement or the content that is often engaged the most with is polarizing content or misleading content, instead of having maybe informational content or educational ones. And this is where we see a sort of imbalance, and we need more scrutiny. So I think this is the main perspective that we try to come with as a government. And in Switzerland, we have identified that it is very important to work with the media sector, or the traditional media sector, if I want to put it this way, because there's, of course, and this was mentioned as well before, significant challenges as the business model sort of changes with big technology platforms dominating the market. We talked about advertising revenue that is diverted from certain platforms to others, and that media organizations are struggling to sustain themselves financially, and it can lead to a lot of problems. One of the things that we have seen in Switzerland is that there is a sort of consolidation of the media market. So many of the smaller or medium-sized media outlets will have been bought up by larger media structures, and it is difficult to keep the news that is very local alive. And so we try to do our best in this, but this is a complicated issue to deal with. But the major problem we're seeing here is really reducing the diversity and the availability of local news. It is also reducing the quality of the reporting, having less journalists who can work in it, or less money for investigative research. And this means that we have fewer in-depth stories being produced. So this is one of the points that we have identified, as well as online harassment that is getting bigger and bigger when we are getting to these polarizing conflicts, of course. I'm moderating a session tomorrow that is talking about safety of journalists online that will delve a little bit more on this point. So I'm going to stop here on that part, but I just wanted to highlight the importance of media pluralism and the importance of having it as a fundamental part of democracy. Switzerland has done a study recently that I found very interesting and also quite shocking. It has shown that only half of the Swiss population believes that independent media is essential for democracy. So only half of the population believes that. The rest are sort of either thinking that it does not matter or that it has no connection. About 14%, I believe, thought that it was not essential. And so this is something that is quite scary to think about, because this detachment of understanding how important true media is, and as a pillar, as the fourth pillar, I would say, of democracy, if we don't see the importance of it, then we cannot safeguard it. And I think this is where we're working a lot on awareness raising, on capacity building. And I know capacity building is something that is discussed a lot at IGF in many different sectors, but I think capacity building on accessing and getting the information and understanding the information you're reading and why it's important to have a certain source or another, I think that is really a strong point we need to work on. And I'm happy to delve into some ways to address these challenges. I don't know if you want me to continue immediately or if you want to pass the word on to someone else. Julia, I'll let you decide.
No, thanks a lot. I do have a follow-up question, but I think it's really important that you point to this almost twofold notion of literacy, right? That it's not only about information literacy in the sense of understanding why something is shown, as you pointed out, but also really understanding the importance of media freedom and media pluralism. This is something that we are also trying to work on, and we try to connotate this terminology of media freedom literacy to really say the states, I mean, it's not only about individuals, as you say, but also states sometimes lack this understanding of how the link is between media freedom, independent media pluralism, and then the link to democracy, but also more broadly to stability, to peace, to safety and security. So this is a very important point indeed. Thanks for underlining it. And the second point I think that was also very important is that you pointed out this engaging factor, right? That currently like content is boosted and more shown if it's engaging, but we know people might be more engaging on polarizing content. And then if we speak about healthy information spaces and democratic deliberation, also in other contexts, we have obligations with regard to diversity and also regional diversity and all of that might not gain the same attraction if different contents are being provided, but that are crucial. And so I think it's really an important question to also ask whether we should have similar obligations in the digital context and in the online space, where we, and with we, I mean both democratic states, but also all stakeholders should just tell platforms that it's not acceptable to prioritize content just because it's engaging and drives more advertising. And this maybe is already the follow-up question, or the lead up to the follow-up question, where you see as a democratic state, or like coming from this perspective, how states can work in that direction, while acknowledging that, of course, Switzerland still remains a fairly small market from the media perspective, but big tech perspective and all of that. So what are the avenues and possibilities that states can take? And before I hand over back to you, sorry for that, I also just want to offer people, if there are people in the room who have a question or who have a comment or want to say anything, please indicate it to us. We also already put the same in the chat for the online participants because there was somebody mentioning. So please feel free to also think about questions after we hear from Isabel, please.
Thank you. It is a very challenging question to answer. How can states, or what should states do? And I think states definitely have a role to play in addressing the challenges posed by big tech, both at a national level, so what we could do in our own countries, and also at the international level through coordinated international efforts. I also believe that it's important to say, and IGF being a multi-stakeholder platform, I want to highlight that it is, I think, in collaboration with other stakeholders that we could do the best work. So this is the first point as just a general kind of view of what governments can do. I think we can do things, but we should not do it alone. So on the national level, sort of the Swiss perspective is that we have to protect the public's access to quality information and ensure some sort of accountability from platforms. And this can include, and this can be done through some sort of regulatory measures that really ensures transparency in the platform's operational system, clarify how and which obligations they have, and then also empower the users to make informed decisions. Because at the end of the day, I think the users are at the center of this. So state intervention is one of the ways to address the sort of power imbalance over information spaces, but it is not the only way, and it is not, it should be done in a very carefully balanced way to respect fundamental rights and freedoms. There is a lot of potential harm that can be done with a strong state control over which information is accessible and how it is done. So I think it is a very specific line and complicated line to navigate, and there has to be a lot of careful considerations brought in this. So in Switzerland, we have a sort of an approach of strengthening the users' rights and increasing the transparency of the platforms instead of moderating the content. So this would ensure that the state intervention does not compromise the freedom of expression or overstep any other fundamental rights that are essential for us. We are currently developing our own regulatory framework for large online platforms, and it is largely based and inspired by the European legislation, so the EU Digital Service Act, the DSA. But the law we are envisioning, and it is not yet in place, focuses on due diligence requirements while strengthening the transparency rules and the user rights. So it is not really about controlling from above, but sort of getting the users to have all of the information. So there are, I mean, I can get into more details on this if you're interested, but there are some significant differences maybe with the EU approach, where our scope is much narrower, whilst we only focus on very large online platforms and very large online search engines. And we are also limiting to only what we call communication platforms. And this is because we want to enable the public dissemination of information between users for the purpose of opinion forming, entertainment, and education. And we are excluding any marketplaces or booking platform sites or things like this that I know are included in the DSA. So our most important point is to protect the fundamental communication rights of the users online. And this can be made to ensure that we have a well-informed public, because and this goes to the main point that we have in Switzerland, where we're trying to give the tools to the users, to the public, and not control it from above. And I think this is where we could work more with other stakeholders, with the media agencies, with other countries, of not looking at it in a top-down way, but in a bottom-up way. And I will just say one more thing on this. We also have a Swiss National Action Plan for the Safety of Journalists that was published last year, where we have a whole set of different measures, most of them to address safety for the journalists, not only online, but mostly offline. But our main focus is to bring awareness on the importance of journalism for a functioning democracy. And so this is really where we can bring an added value. And we're also working very closely with the Council of Europe, who has a great campaign on the safety of journalists that I can only encourage you to look into. But yeah, this is a sort of the ways that we see that we can do something and that states could do something. Of course, if we are looking into regulation, we have to make it balanced. We have to make sure that we are empowering the public and not controlling what is put out there. And so this is where we are happy to discuss and engage with any stakeholders and in meetings like today to have a bit of the other ideas. Thank you.
Excellent. Thanks so much for this. I mean, I think there are already a lot of takeaways for sure with this. Empowering, not controlling is certainly a nice way of phrasing it. And I think this is also something that we as the OEC have been pushing for constantly, that we don't speak about individual pieces of content, but we speak about processes, right? I mean, it's the same when we speak about disinformation or fact checking. It's very much about how can we make sure that the processes work better, that we have, as you say, like transparency, accountability, and all of these things, multi-stakeholder engagement, and in a meaningful way. I think this is also something that we heard already today. But it's not if we want to address the undue power by big tech, it doesn't mean that we want to fill this with undue state power, right? Becomes particularly important in contexts where we don't have maybe the same democratic institutions. We only have 10 minutes left. So again, I want to ask if somebody in the audience would have a question. But if not, I would ask maybe first Elena, because now we had a few of these sentences also with regard to journalism, or also with the public sphere and pluralism. If you could build on that to say briefly what you think should be the role also of the media industry and to respond to the power of big tech over information spaces, and if you see there maybe also even an opportunity or possibility how technology can help in this regard.
Yes. Yes, thank you, Julia. And indeed, this question comes at such a good time, because I just had an idea for a new project for WANIFRA that is really about that. But first of all, I wanted to thank Isabel for her intervention. And I would like to add to what she just said, that indeed it is only states, I think, can have the responsibility to choose what stays online and what goes offline, because only democratic states only democratic states can have that responsibility. If we leave that responsibility to platforms, they're just going to take down anything that could be even potentially bring lawsuits and economic problems for them. So the role of the states is very important. We saw how important it was in all the battles for freedom of expression, of course, also for the sustainability of media, with all the laws and antitrust decisions that have been taken around the world, Australia, Canada, and so on. But I agree, Julia, that it is time for the media to do something on independently, also in addition to what states can do to help its sustainability, and and as a consequence, the democratic discourse, which is fostered by the professional media. What we believe within WANIFRA is that stakeholders should pull together the publishers, but also the advertisers, and also civil society, and so on, to try and sustain again a media environment which is safe, because it brings good information, good information to the public. What I mean is that in my first intervention, I spoke of how problematic it is for publishers that all these advertising revenues go to big tech instead than to advertisers, to news media. But it is true also for advertisers, which very often find their advertising being placed by bots alongside content that is not flattering for their brands at all. It is actually a disaster. So in the end, we have a double interest from both advertisers and publishers to ensure that good advertising, at least a good portion of good advertising, goes to good professional brands. So what I'm trying to foster and what I'm trying to work on is an alliance between big stakeholders, and which include professional media, not only the big professional media, in particular the local small media, and advertisers and people who can advise us, like OSC, for example, and so on, to find a way to make sure that at least a certain portion of advertising goes back to media done in a professional way. And in the brief that you gave me at the beginning of before this session, Julia, you also said, is there anything technical that should be explored as well? Well, yes, there is. It is really important. I just found out recently that local media, regional media, very often has websites that are not optimized to receive programmatic advertising. So even if we at OneInfra are successful in producing some sort of project which would drive more programmatic advertising, which is, I mean, I'm sure everybody knows what it is. But programmatic advertising is advertising that is automatically thrown onto websites which say, I'm waiting for advertising. That is basically what it is. So, but websites need to have some technical specifications to allow this to happen. So we're going to try and put in place in the next months, in the 18 months maximum, a process to ensure that more programmatic advertising goes to vetted professional media sources, also local, but we're also going to find a way to ensure that as many as possible of these websites are in the best conditions possible to receive technically this programmatic advertising.
Thank you very much. Yes. Yeah. No, it's first of all also already a call to action, which is very good, because this is also what we aim to come up with at the end. And it's important to also speak about advertisers, which is part of this multi-stakeholder approach, of course. So maybe in the last 5 minutes, I want to turn now to the question also of civil society, right? And I mean, both Nigel and also Abs, you in the beginning already explained what you're doing and the work. But can you also tell us what you think is the role of civil society, and then maybe also, Nigel, I know that you're also in the global UN advisory body on AI, so maybe also, I know it's not a lot of time left, but if you can close on this call to action, also maybe with this perspective and expertise. Maybe first I will give the floor to us on the more specific civil society experience or what you think should be done, and then Nigel, maybe you can close it with this more global AI component and a call to action in the last few minutes. Thank you so much.
So thank you for the question. Now we are working, we build an IFCN Arabic coalition from this 7 organization. So we will make some pressure on the tech companies and to be as a third-party fact checkers or to combine them as disinformation, because it's as one organization, usually they ignore it, especially it's come from the Arabic region. The other things that we are doing, raising awareness for people in different ways, like online, for example, last Tech for Peace, we have more than 2.3 million followers. We are the biggest fact-checking in the MENA region. So we're doing raising awareness. We have also MOOCs platform that we have different kind of levels of fact-checking, digital security, etc. And also we're doing webinars, some kind of raising awareness also on the ground, like with IDPs, which is the internally displaced people in camps. That's inside Iraq. And also we are building some new initiative, new organization to do fact checking. Like, for example, we did in Yemen, we did in Tunis, and also in Libya. And we are also, for the future, plan for the other countries. And also on the other side, we are building too. So there is a Tech for Peace application mobile that's not only depending on our articles for fact checking, also we are building this for people. So anyone can install this app in 3 languages, which is Arabic, English, and also Kurdish. You can do fact checking by pictures, videos, and also text. And the only application mobile you can do by videos in 3 languages, because most of the tools for fact checking for videos, you need computer to use it. So we developed these tools to use it by phone. And we have until now more than 100,000 downloads. And it's still growing up really, really fast. And yeah, I will stop from here. And
Yeah, no, thank you so much. Julia, I would, I'll talk about a little bit about the UN Secretary General, HLab, and the recommendations that we have given. But before that, I would also like to talk a little bit about the white paper on AI around content moderation that we released at the Oversight Board, and some of the really important things that our panelists have already highlighted. For instance, and we as a board look dwelled into so many cases. We engaged with so many stakeholders, including civil society around the world. So far, we have received 10,000 comments on our cases, and I would really encourage people to really look into those deliberations and the case decisions that we have released and the recommendations, because those recommendations actually go deeper insight into the tools and policies of the platform. So some of the key lessons that we learned as a board that actually civil society and other tech platforms can also learn when we talk about AI and content moderation are basically, automated moderation and curation system must be rigorously and continually evaluated on their performance for users who are most vulnerable and most at risk. Another one is global human rights, freedom of expression, and ethics experts should be consulted when designing and deploying new AI-powered content moderation tools early in the process. And then we always talk about that transparency is paramount. So giving access to third-party or researchers is something that we have been talking a lot in our recommendations as well to the Meta. Now coming to the high level thing, which is UN Secretary General's HLab. So we gave several recommendations, and two of our recommendations actually, after negotiated by 193 states, became part of GDC Global Digital Compact. One was setting up AI scientific panel, and another one was establishing global governance dialogue on AI. And I think it's so important now for civil society to actually keep watching this space, because especially setting up this dialogue like COP or IGF, it will be designed like that. And civil society will have like a lot of space to actually engage with other stakeholders like government or tech companies or AI companies to actually design from the beginning in terms of the global governance of AI, be it the global governance or at the nation state level. I'll stop here. Thank you.
Thank you so much. I acknowledge that there's no time left, so we were really on spot, and there's really such a rich conversation with so many takeaways. We will now certainly go through our notes and take out the calls to actions that we took from your crucial input and also report it back to the IGF, so we can live up to what you said, like learning lessons from one another, right? Learning from one another experiences. It will also feed into our work. I just want to thank you at this stage, all of you, for your insights and your crucial contributions, and also Martin for doing the local moderation, even if there were not so many questions also in the floor. I don't know if you still want to have some closing sentence, but in any case, thank you all very, very much from our side. Very crucial input, and will be very useful for our continued work on this topic. Thank you very much.
Thank you, Julia, for your
Thank you, Julia.
moderation.
Thank
That
you,
was a
everybody.
really great conversation, and thanks to the panelists and the people in the room.
Thank you
Thank
all,
you.
and enjoy the rest of IGF.
Bye.
Bye.
Nice to meet you. Thank you so much for being part of this. Yeah.
Nice to meet you. So about the journalist protections.
Yes.
Which region? You offer like a bootcamp of like let's say.
All right. I don't. Right? I think we're gonna get started. I see Jacqueline is joining us online. Hi, Jacqueline. I'll wait a sec. I see we have some people joining us online. I think you do have to wear the headset to be able to hear the people online. Yeah. So, and it will be channel 5. 5. So welcome everyone. We are here in this session on defending voice and expression in Africa and the Middle East. I think we are gonna get started. We have some people joining us online. It's pretty busy in the venue, but not here, unfortunately, but we hope some more people will be joining us soon. For those of you who don't know me, I am Annelies Riesebos. I'm a senior policy officer at the Dutch Ministry of Foreign Affairs, and I'm in the Department of Multilateral Affairs and Human Rights. So I work on issues related to freedom of expression online, and this includes content moderation, the response to disinformation online, and the promotion of information integrity. So I'm really happy that GPD invited us to moderate this session today. And I think we've had good discussions already at the Internet Governance Forum here in Riyadh on the future of the Internet. And for the Netherlands, this is also a key priority that we believe in an open, worldwide free and secure and inclusive Internet. And the Internet is essential and can be foundational for achieving the Sustainable Development Goals. And also freedom of expression, which this session is about, is one of our priorities in our foreign human rights policy, and freedom of expression should be upheld online and offline. So multi-stakeholder approach is also essential in this, and I'm really glad that we have a panel right now where we are joined by our colleagues from civil society. And also within the Freedom Online Coalition, we have made sure to seek coordination among countries and to include firm human rights safeguards online. Also, for instance, this year with the Global Digital Compact, which we negotiated. And here we are here together to speak about the opportunities that the online space provides for the freedom of expression worldwide, but also the challenges that arise from several legislative reforms that have been taken by some countries. And I'm really glad that GPD, together with Article 19, has done extensive research on this topic, because there might be legislation that is not in line with human rights standards, which cracks down on vulnerable groups, human rights defenders, journalists, LGBTIQ+ individuals, or other marginalized groups. And this is incompatible with international human rights law. So in this session, I'm really glad that we will be focusing on these kinds of legislative measures, specifically in the MENA region. And my panel today, we have Jacqueline Rao with Global Partners Digital, Ayman Zagdouri, who is joining us now. You're on the screen now as well. Welcome. You're with Access Now. And then we have Boye Adegoke, who's here with me in the room, who is with Paradigm Initiative. And our objective here is to foster in-depth understanding of the trends in the region, and to really delve into the misuse of online content restrictive legislation. But I'm really hopeful that we can also discuss some methods of how we can work together to have cybercrime legislation that is actually rights respective. I hope that together we will identify a path towards the much needed regulation of the online space, which is essential, but in such a way that it doesn't infringe on the potential on the online human rights enjoyment. We will have to do this all in only 60 minutes, so take it away right away with, I'll give the word to Jacqueline, who will give us some more, an overview of the research that GPD and Article 19 did on this issue. And then the other panelists will also explain the trends they see in cybercrime legislation in the region, and we'll have a roundtable dialogue to discuss how we can work together. So Jacqueline, you are with GPD and you worked on the report An Ever Tightening Net, which is on this topic. And Jacqueline is a PhD student, and she works on designing responsible natural language processing at the University of Edinburgh, and has worked with GPD on platform regulation, content governance, and policies surrounding hate speech and disinformation. All right, Jacqueline, take it away.
Great, thank you, Annelies. I hope I can be heard by everyone. Great. Yeah, so thank you for your introductions. It's great to be with you all today remotely. As Annelies said, I was involved in the writing of this report, and I thought I'd give just a very brief overview of what the report is, what it covers, and then talk about some of the key trends that we documented in that report. So the goal was to understand across Africa and the MENA region how restrictions on online content are impacting freedom of expression today. And so we looked, a lot of this work was looking at cybercrime legislation, particularly like content-based criminal restrictions on online expression, but we also looked at a range of other areas of kind of law and policy, including platform regulations, anti-terror legislation that applies in the online context, as well as kind of press and media regulations and disinformation legislation as well. So we were focusing kind of beyond just specific cybercrime regimes, but really trying to get a picture of where these different restrictions are found in countries' legislative kind of frameworks, and how specifically we were really interested in how are those restrictions being enforced in practice. So not just looking at the text of the law, but also looking at how they're being enforced and who they're being enforced against. So our focus within this work was, broadly speaking, do these restrictions and how they're being enforced align with international human rights law or not? And we were focusing primarily on kind of freedom of expression concerns, but there were a number of other human rights that are obviously also relevant to these discussions as well. So with our partners, with Article 19, who we were really pleased to work with on this project, we looked at over 150 different legal frameworks from countries all over the region, and tried to gather, as I said, concrete examples of how they're being enforced against different groups. We found that it's a very diverse region, the whole of Africa and the whole of the Middle East. There are diverse approaches taken to cybercrime and to what content should be criminalized online. Some of the regimes we looked at, some of the legislations were aligned, more or less with international human rights law and with the Budapest Convention, which is the kind of, I'm sure most people here will be aware, but the kind of global standard, the norm on rights respecting cybercrime legislation. And when I say that they were aligned, I mean that the criminal restrictions they placed on online expression were limited to very specific, narrowly defined categories of egregious online harms. So these are kind of child sexual abuse material, incitement to genocide or advocacy of genocide, hate speech which incites discrimination and violence, and incitement to terrorism. So kind of 4 very specific content categories that can permissibly be criminalized under international human rights law. So while some of the countries' kind of legislative packages that we looked at were more or less aligned with those restrictions, unfortunately a lot of them were not aligned and included content restrictions on much broader categories of online content and expression than would be considered permissible under international standards on freedom of expression. And within the report, what we tried to do was kind of group these areas of divergence from human rights standards into 4 main themes that we observed. So the first theme or trend that we looked at was a lot of governments in the region are using public safety concerns or public safety narratives to justify overbroad restrictions on online speech. So, for example, implementing a restriction on online terrorism or content which undermines national security, which is kind of using this language of being in the interests of public safety, but in reality, we saw that those restrictions were being enforced against, as you mentioned in your introduction, Annalise, journalists, human rights defenders, political opponents. The broad definitions used in those pieces of legislation, even though they sound like they're directed towards public safety, are in fact not being used to protect public safety at all. So this was the first trend that we looked at and we documented in the report. The second theme was the prevalence of criminal restrictions on disinformation. Over a third of the legal frameworks that we looked at included some kind of restriction on disinformation. And while disinformation is, of course, a legitimate concern and can pose human rights risks in itself, if allowed to spread, again, international human rights law is very clear that it should never be criminalized. And we saw in the report, we documented a lot of examples of how those restrictions are being used to censor political expression and other expression by vulnerable and marginalized groups. The third trend that we document in the report was online expression, restrictions on online expression, which we see as enforcing authoritarian value systems. So this might include prohibiting criticism of political figures, of religion or religious leaders. This might include bans on LGBT content or content which advocates for LGBT groups. As well as any kind of expression or advocacy for marginalized groups as well. And so these restrictions are very far from international standards on what can permissibly be restricted. And we saw that they had really disproportionate impacts on particularly vulnerable groups in practice. And the final trend that we look at in the report is the shifting away or adding to individual restrictions on what people can say online in criminal law towards more holistic platform regulation frameworks, which also apply criminal penalties to platforms for failing to take down these broad categories of illegal content as well. So those are the kind of trends we looked at in the report, and the main focus of the report was monitoring and reporting some of those risks and concerns, but we did also include various recommendations that we developed together with Article 19 as well, and I can get into those perhaps a bit later on. Thanks.
Thank you so much, Jacqueline, for that overview of the report. And it's really good that you made it and that you identified the 4 areas and that we see that there are so many trends where platform and cybercrime legislation is not aligned with IHRL. Ayman, I would like to give the word to you. Perhaps we can go even more in depth and add to the insights what Access Now has gained from investigating cybercrime in the region. Ayman is Access Now's MENA Senior Policy Counselor based in Tunisia. And he has previously actually worked at Article 19, I understood, where he researched ethics of journalism and the impact of digital development on freedom of expression in the MENA region. He's also an assistant professor at the Institute for Press and Information Sciences in Tunisia. Could you provide an overview of the specific cybercrime decrees that you've encountered and also the advocacy efforts that were employed to challenge these laws?
Thank you very much. I'm very glad to be here. Basically, the cybercrime decree law was issued by the President of the Republic in 2022. So 1 year after his coup and in the absence of the parliament. And apart from the content-based offenses, which I will come to them later, it contains several problematic provisions. So conscious of the time, I will mention just 2 examples. The first one is the obligation for ISPs to store all data related to communication traffic and other types of data, which is a big threat to the right of privacy. as you know, based on this data, authorities can have an idea about our daily behavior and conduct. The second example is related to the communication interception. So basically, whether in Tunisia or other cybercrime legislation within the region, we didn't see any safeguard when it comes to communications interception. But the most problematic provision is Article 24, of course, which contains content-based offenses, broad terms, and even the scope is very broad, criminalizing not only the publication of content online, but also or even sending, preparing, or even generating content that might be considered against the Article 24. It contains disproportionate sanctions from 5 to 10 years of prison for defamation, slander, disinformation, hate speech, but always, ill-defined terms, vague terms. So long story short, if we analyze this Article 24, which contains content-based offenses, under the three-part test, it won't be able even to pass the legality condition. So it's unclear. It was issued by the president without any public debate. The problem also that it contains crimes that are already criminalized based on other pieces of legislation, like the press law, the criminal law, the telecommunication law, etc. And now we do have journalists, lawyers, judges, politicians, students, human rights defenders, and many others either in the prison or prosecuted for criticizing the government.
So much. And lastly, I would like to give the floor to our in-person panelist, Adeboye Adegoke. Boye is a leading civil society voice in the internet governance space in Africa, a senior program manager at Paradigm Initiative, and a member of the G20 think tank on the governance of artificial intelligence, as well as a member of the advisory network of the Freedom Online Coalition. So really glad to have you here. Boye, you have many years of global, regional, national experience with digital rights advocacy. Could you go into depth a bit about the trends you're seeing in Africa, and also how we can move forward to combat the threats that we see to freedom of speech there?
All right, thank you very much, Annalise, and thanks, Jacqueline and Ahmed Godi. I hope I got the pronunciation of your name right, but please pardon me if I didn't. It's a pleasure to be on the panel with you and also to listen to the research that you had worked on and the findings from the research. I do think that the narrative are similar, whether you're looking at Africa or Middle East or the MENA region generally. I think within the Africa or sub-Saharan African context is similar, or the similarities that we have seen is in cyber laws that were enacted primarily for the objective of addressing cyber crimes concerns. They often come with provisions that are vague, especially touching on cyber defamation, cyber stalking, similar names like that. And what we have seen is that these provisions have become a tool of targeting, a tool used to target human rights defenders, civil society actors, activists, and also people belonging to minority or marginalized groups. If you pick a random African country, I can tell you for a fact that somebody has been arrested because of something they said online, or because they belong to an opposition political parties, or because they work for a human rights organization, relying on provisions of cybercrime laws. So it becomes very, very challenging for people who are working in this context, because then there is a tool that has been legalized in law that can be used against you if you dare have an opposing view to the narrative that the government is probably interested in pushing. And in specific example, in Nigeria, for example, I'm from Nigeria, so I'm even more familiar with the happenings in Nigeria. We've tracked hundreds of cases of people who got arrested using the provision of such law. And what the context I also need to bring into this is that the law itself has become a tool, and even the people who use the law, they know exactly that it is a tool of oppression. And why do I say this? That there is a case we are currently working on in Nigeria of a lawyer who had written a book where he exposed corruption in the judiciary and how some senior lawyers corrupted the judiciary so that they can always get judgment in their favor and all of that. So the lawyer was initially arrested on the basis of libel laws. And it turns out that the states in which the case emanated from had decriminalized libel. So when he was arrested, the police arrested him and they were justifying it on the basis of the libel law. And then when there was uproar and pushbacks, it turns out that people who are aware said that the libel law that you have used to arrest this guy is outdated. The amended version of the law stated clearly that libel is not a criminal law. So even if you have a case to pursue against this man, it has to be a civil case. You have to approach the court and all of that. The moment that information came out, then immediately the police released new charges under the Cyber Crimes Act. So you could see that it is all about just looking for a way to criminalize people that the authorities do not agree with. So that law at that point comes handy as a tool that could be used to criminalize the person. And the idea is not justice. The idea is when you use criminal laws to arrest somebody who is alleged to have committed maybe defamation or something like that, you have the leverage to put the person in handcuffs, in chains. You have the leverage to put the person behind bar because you say it's a criminal offense. So these are the ways in which this has played out, not just in Nigeria, in Zambia, in Malawi, in Cameroon, in Senegal. Literally every countries that we have worked in Africa, we have seen cases like this that have come up over time. But I think in terms of moving forward, what do we need to do to address these challenges? Nigeria has taken some steps positively. Some other countries in Anglophone West Africa, like Sierra Leone as well, I think Liberia as well, has also taken some steps to decriminalize cyber defamation, as they put it in some of the laws, or cyber stalking, as it's put in some of the laws. So in Nigeria, for example, there was an amendment to the Nigerian law on cybercrime just less than a year ago, and the amendment ensures that the blanket provision which allows just any powerful person to get other people arrested for things they said online was removed from the law. Although the law still exists, the provision still exists, but the implication has been strongly reduced to only affect issues that could lead to public unrest. It's still problematic because public unrest, public interest are also very problematic phrases which are not clearly defined. But there has been some progress. That's the point I want to make. And the process leading to those progress is a lot of work by civil society organizations and human rights defenders who have challenged the provisions in the law. As a matter of fact, Paradigm Initiative went to court. We went to regional courts to challenge it, and the regional court gave us judgment to say that that provision is against the Constitution of the Federal Republic of Nigeria and is against international human rights law. And the regional court then ordered the Nigerian government to amend the provision of the law. So that litigation was very useful in forcing the hands of Nigerian parliament to amend the provision of that law. So it's going to be difficult for anyone in Nigeria right now to arrest somebody on the basis of those provisions. So that's just an example of what civil society organization can do to explore every advocacy measure, pushing the parliament to change the law, using the media, but also using regional courts, because I think as advocates, we cannot run away from litigation. It makes us look adversarial, but the kind of battle we have to deal with, that we have to fight, requires us to explore every possible avenue. And that's how we're able to change the law in Nigeria.
Thank you. Boy, that's nice, and it's good to hear how you're already showing. I think you said this cybercrime law became a tool that came in handy for suppression, and I'm glad to hear you mention already some of the options that civil society at least has advocate for progress and for change in that. I think I would also like to discuss a little bit more how we can work together as governments, international organizations, also the big companies that are hosting a lot of the platforms that we've been discussing. So we can maybe delve a little bit deeper into the collaboration that we can foster together. But I also wanted to ask you the effect that these kinds of legislative reforms have on local communities. I think you've showed clearly how there are cases of people who were unable to express themselves online because of the tool that came in handy, the cybercrime legislation. But could you share maybe, I'm not sure, maybe Boye or Ayman, a little bit more of your experience working with the communities? How have the restrictions actually affected the individual's ability to express themselves online? And what is maybe the effect that we see more broadly in the information space of these content legislation? I'm not sure. Do you want to take it or? Yeah, Boye can start. Thank you.
Yeah, thank you very much. I think that it's as from what we have seen, I think one of the dangers of such laws is that you end up having a system where people self-censor themselves, which has a direct chilling effect on the freedom of expression contest in jurisdiction where these are applicable. At some point, there becomes there is no clarity about what expression is safe and what expression is not safe. And just as I said in my previous intervention, that when the authorities use this law, they don't use it to pursue justice. They use it to oppress. They use it to encourage a climate of fear where people are scared to oppose the government, where people are scared to express how they feel about how they are being governed, how they feel about government policies, etc. That is the real challenge. The real challenge is that it creates a climate of fear whereby even when people see that things are going wrong, they don't want to speak because they feel like if they speak up, they might be criminalized for speaking up. And I think that is the general effect of when you criminalize speech. It creates a climate of fear in the ecosystem whereby people don't even want to speak. And when there is a climate of fear, that is self-censorship, whereby even before, while we deal with issue of censorship generally in our region, we also have to worry about the fact that even people are now self-censoring themselves by refusing to weigh in, in how they are being governed. And most of the countries in these regions are democratic countries, and expression is key in any democracy. If there is no freedom of expression, we can't reasonably say that democracy is at play. So what is the essence of democracy when people cannot speak their mind? So that is what happens. So it touches not just on individual ability to speak, but also in the essence of democracy itself. Democracy is defined as the government of the people, by the people, for the people. So the element of by the people gets taken away when people can't have an opinion, when people can't speak on issues. And this also gets heightened during election period. In fact, what we are also seeing is that there is more clampdown on speech around the election, because during election, people get more active about debating governance issues, debating candidates and assessing the incumbents, etc. So that itself, the role that freedom of expression needs to play in the democratic context, it is directly affected. And that way, we see a situation whereby this country retrogress in their democratic index. And if you look at maybe reports like the Freedom on the Net report, you can also see this clearly demonstrated about how a lot of countries continue to retrogress because they continue to enact laws that makes it difficult to experience democracy, to experience freedom in such jurisdiction.
Thank you. Yeah, I think it's really good that you link this issue directly to democracy. Ayman, do you have something to add to this about the local communities and the effect this, also the legal uncertainty and the arbitrariness of the legislation has?
Yeah, sure. Thanks. I agree with what Boya said. This legislation are really scaring, and when I say scary, I'm not exaggerating, because, for example, when I take Tunisia as example, we have seen a huge shift once the cybercrime law in Tunisia was enacted by the president. For example, more and more we see censorship. And when we say censorship, we don't talk only about political censorship. Even people are afraid to share their sexual, for example, identity. They try to avoid expressing their opinion regarding public interest subject. Another example, at the moment, for example, political show in radio and TV are reduced almost to nothing, to zero, because also even independent expert, they tend to reject media interviews invitation because they're scared that they might be prosecuted based on the cybercrime legislation. I think also another example is the last presidential election 2 months ago in Tunisia. For example, the turnout used to be in Tunisia between 50% to 65% in 2014 and 2019. And in the last presidential elections, the turnout was about 28%. And this also show the level of involvement of the Tunisians when it comes to public debate. So, for example, 6 months before the last presidential election, we've seen journalists in jail based on cybercrime decree. Candidate to the presidency, to the election, also have been jailed, human rights defenders. So the impact is very clear, tangible. Also, for example, when we take the example of Saudi Arabia, for example, if we check social media in Saudi Arabia, almost you don't see any criticism to the government, and this because we have seen in the past years people have been jailed for 34 years of prison just for a post on Twitter or X to criticize the government. So the impact is tangible, and maybe later I will come to explain more what kind of tactics we can adopt to tackle this type of legislation.
Thank you so much. Yes, I would like to delve into the tactics actually of advocating against these types of legislation, but maybe also some of the recent trends that we've seen, for instance, with the UN Cybercrime Convention, that because we do need to have, I think, good frameworks for cybercrime to address cybercrime. I think, Jackie, you also mentioned how important it is that there is that, for instance, disinformation is addressed. So we do need some good legislations out there. And I think the report, the research that you did also goes a bit into what good legislation would look like. Could you reflect on that a bit more?
Yeah, certainly. And I think it's quite a kind of meaty question, right? Of this, like there is such a thing as online harms that should be illegal and that cause harm to people, and then there is also this misuse of the narrative about online harms to justify these censorship and really repressive approaches to managing cyberspace that we've seen time and time again. So I think the UN Cybercrime Convention is an interesting point where those views have been heavily contested, right? Like GPD has been involved in some of those negotiations, and my colleagues can perhaps speak more to that than I can. But I think it's clear that what regulatory system may work in a jurisdiction where you have an independent judiciary and an independent media regulator that has plenty of funding and is well established for decades is actually very different to what might work in a country where democracy is more fragile or non-existent. And so I think there's that need to keep in mind the importance of context. I think we've touched on it a little bit in the discussions, but I also think that the links between cybercrime legislation and platform regulation are also really important and really complex, because if a government says this type of content is illegal online, then it's only a matter of time before then they also begin to exert pressure on platforms to enforce that restriction beyond the reach of the government itself, right, or the Ministry of Digital, or whatever kind of regulatory body is tasked with enforcing that. And so I think, as well as the UN Cybercrime Convention, you also have, like UNESCO's initiative draft guidelines for regulating digital platforms, and you also have, at least for the Middle East region, like the League of Arab States has been developing this draft international strategy to regulate digital platforms or digital media companies. I can't remember the wording. And so there are also these quite influential moves to drag online platforms further into this debate as well. And of course, there are responsibilities that online platforms can and should carry, and I'm not by any means saying that they have acted responsibly, particularly in countries that have less market dominance and perhaps less kind of influence, where there's linguistic diversity, there's cultural diversity. Like we know that platforms have really neglected key safety issues in certain jurisdictions, but equally forcing platforms to just blanket enforce already very overbroad restrictions on online expression is also not the answer either. So kind of with all that complexity in mind, in the report we made 11 recommendations for kind of governments, I guess, or people looking to develop more rights respecting cybercrime regulations. I won't go into those all in detail, as people can check out the report, but the main one is that criminal restrictions on online expression must align with international guidance, with the guidance from the Special Rapporteur on freedom of expression, the three-part test for permissible restrictions, that nothing should be criminalized outside of those very narrow categories. And then the second kind of recommendation or key recommendation that I'd maybe want to just flag here is that the solution to harmful content is not necessarily criminalization, right? Like, there are some types of content which, as I just said, they do need to be criminalized, but for issues like disinformation, for issues like harassment or speech which is offensive but which isn't hate speech, like, yes, those content types are harmful and they do need a policy response, but that policy response must be much more, it's about a socio-technical system. We can't just criminalize this content and expect it to go away. There are social pressures, there's market pressures, there's advertising pressures that platforms, there's recommendation algorithms that are out of whack. There's all these other issues that feed into those harms and why they're harmful, and I think the points to address those harms is not at the level of the individual who's posting that content on their social media.
Thank you. Yes, that's a clear overview. I think, Ayman, I saw you put something in the chat that we can't see here in the room, so maybe you would like to address that and also go into the tactics for addressing these legislations that we do not want to see in relation to international human rights standards.
Yeah, thank you. So basically, before coming to the blog post on the impact of the UN Cybercrime Treaty on digital rights in the MENA region, I want to talk a bit about different tactics that we can use to tackle this sort of legislation. So whether Tunisia or Saudi Arabia or Libya, Jordan, Egypt, many other countries in the region, they have adopted the same approach. So it's an approach consisting of adding content-based offenses to the cybercrime law. And here I want to emphasize that content-based offenses are not cybercrimes. There is like a definition of cybercrimes, and then like regime or like governments in Africa or MENA are trying to always to include content-based offenses like defamation, slander, fake news in this category of legislation with harsher sanction compared, for example, to a similar crime under the criminal law or the press law. And when it comes to advocacy efforts, There are different tactics, of course, depending on the political context and opportunities we do have. Of course, if we have the opportunity to conduct dialogue with the parliament, that is like ideal for us, because then we can bring examples, try to convince them through arguments. So I will mention at least three different tactics based on Access Now experience. So first of all, and this we've tried this tactic when it comes to the UN Cybercrime Treaty, for example. So asking states with strong respect of the rule of law to reject any mutual cooperation requests when it comes to content-based offenses. And this can sometimes be successful, of course. And I say sometimes because we have seen in the past some regimes were not in need of this sort of cooperation, as they just can send criminals to their embassy and cut the journalists into pieces just because it happens that this journalist had criticized the government. The second tactics is to meet MPs and try to convince them either to reject the bill or to amend existing laws. And we have been using this strategy, for example, in Tunisia and Jordan. So just this morning, I participated in a conference or like workshop with Tunisian MPs, trying to convince them to adopt a sort of law proposal to amend Decree Law 54. And basically, we wanted to suppress Article 24 related to defamation, online defamation, and other type of content-based offenses. The third tactics, it's more like capacity building. And this also, we've been trying this path in Jordan and in Tunisia, even in Morocco, even though they don't have cybercrime, but they have other problem when it comes to freedom of expression in Morocco or Libya. So we conduct sort of trainings and workshops with judges and lawyers, and trying to equip them with sufficient materials and legal arguments so that they can better deal with freedom of expression cases.
And these are clear tactics that you're describing. So speaking with countries who have a strong rule of law, the work you do with MPs, and then the capacity building. I think you also mentioned, Boye, the work that you did on strategic litigation. Is there anything further that you could add on the tactics that Paradigm has taken to address and advocate for better cybercrime laws, or to take steps towards a better situation where the laws are not misused?
Yeah, I think there are many layers to the intervention that we have done at Paradigm Initiative for that any civil society organization can do. There is an aspect of trying to put out the fire when it's already out there, but there is also an aspect of trying to ensure that the fire never starts in the first place. So I'll give an example, especially with respect to platform regulation. We have been very keenly involved in Nigeria's efforts to at platform regulation. Nigeria has been having a conversation around coming up with some sort of laws around platform regulation or around online harms, right? And we've been in that conversation right from the get-go. I even worked as member of the steering committee. The conversation has not exactly gone 100% the way we wanted to go, but we kind of find ourselves in an advantage position that we got involved right from the beginning. What our involvement means is not just that we are going to be able to 100% influence the outcome of what the bill will look like, but it also means that we can use our privileged position to galvanize the entire civil society community, the human rights community, to let them know what because what typically happens traditionally is that you don't get to hear about the law until it is brought to the parliament, at which time it's already too late to engage or even influence. But because of this early engagement, we already know what the thinking of the government is, and we already also started thinking about strategy to ensure that it doesn't become another tool of oppression in the ecosystem. So I do think that one key thing that we have to think about is also about early engagements with processes, policy processes, to ensure that we are in a more strategic position to influence outcomes. But beyond this, what then happens when there is already a law and the law is doing a lot of harms to to the freedom community, to the human rights community and all of that. I do think, as I mentioned earlier,
Recording in progress.
All right, Jackie, we see you back on the screen. The rest I don't think is back yet. Seems like we've had an interesting disruption of this session. So we'll just wait to see if we can get the others back as well. I think our other speaker hasn't joined us back yet.
No, Ayman's not here yet, Maris. But maybe if we can move, maybe to give the floor to Jackie or
Yeah.
to
Yeah,
continue the
let's-
flux of the conversation. Yeah.
Yeah, exactly. Yes, thank you for everyone. That's Maria Paz, who is also with GPD. Thank you. Yeah, Jacqueline, maybe we still have a little bit of time. Let's continue and ignore the technical disruption for now. Because we wanted to touch upon a little bit the positive things that we can do, but also the moments we have in the coming period as well for collaboration between civil society and governments, and also international organizations. I think you mentioned UNESCO. We have the UN processes that are going on. Could you go into that a little bit? And at least in the room we're here and we can we're eager to learn.
Yes, sure, and hopefully you can hear me okay again. Yeah, well, I was also just reflecting a little bit as Ayman and Boye were talking about some of the kind of civil society initiatives and strategies that are being used in various different contexts, and I guess maybe this is also partly like a recommendation for funders, which includes national governments as well as international organizations that are funding this sort of work, and maybe just to highlight that it's very difficult to plan those interventions in advance because you know, it's not always predictable exactly when a government is going to release a new draft or a new consultation or a new proposal for a problematic piece of legislation. And so I think maybe there's a challenge also for funders to work out more flexible ways of supporting civil society in those initiatives as and when they're needed, which often might be at short notice or kind of in an ad hoc fashion, consultation fashion. So I was just thinking that may also be relevant as a consideration. In terms of collaboration, I think there's been some really exciting moments of collaboration between different civil society organizations in the negotiations of the UN Cybercrime Treaty, right? And we've seen large coalitions of not just civil society organizations, but also companies weighing in, as well as different kind of support by different governments for this pushback against broadening out the content-based offences that could be included in the UN Cybercrime Treaty. And so I think that's been quite a positive example CSO activism, people working together. Unfortunately, I mean, the draft treaty that we have is undoubtedly better than it was because of that kind of very tireless activism. But I know that there are many that would still argue that the treaty should not be signed, should not be passed. So there are perhaps limits even then, and that's a huge amount of effort and coordination that's taken place across all of those different CSOs to bring these issues to the agenda of the governments that are negotiating that treaty. I think also, as you mentioned earlier, Annalise, like platforms are a huge part of this conversation, and I do think a point that it's important to make is that as long as platforms continue to neglect their content moderation responsibilities, particularly in non-English speaking areas where there's linguistic diversity of different dialects, where they continue to moderate content poorly, content which should be taken down but which they don't have appropriate local content moderation expertise to deal with in a timely fashion, that only continues to give authoritarian governments more excuse to tighten up criminal restrictions on this sort of content. So I do think that there is a big responsibility on online platforms to have to invest more in online safety in all of the jurisdictions in which they operate, not just in the global north, the global majority. And I think that will also be quite a key part of if platforms can show governments we are dealing with these issues responsibly, we are investing money, these are the technical challenges, these are the policy challenges. I feel like that also is quite an important part of the puzzle, so that then we can have a more informed debate around where the gaps are and where regulation might need to fill some of those gaps.
Thank you so much. Yeah, that's an interesting perspective you take there. I'm not sure if we have Ayman back on board already. We don't see him here in the room. But Boye,
No.
maybe do you have anything to add about the action-oriented steps that we can take to talk about solutions together as civil society, as governments? I think the multi-stakeholder nature of the Internet Governance Forum itself is one of those places. So where can we continue that conversation as well?
All right. I think I'll just also use the opportunity to land on the point I was making previously. I think it's also about consolidating efforts as civil society organization. There are a lot of debates, processes that goes on in policy formulation processes at the national level, whether even at the regional or at the global level. For example, the UN Cyber Treaty. What I have seen is that for a lot of organizations from the global south, the capacity for participation is very limited. And that also informs how well they are able to engage or they are able to influence the outcome of some of these processes of negotiation, whether at the national, regional, or global level. So one of the things that we've done in Paradigm Initiative, for example, is that we have changed our strategy towards policy engagement or policy influence. But what we used to do was to engage process. The microphone is working, but the Zoom is off. We have
Anyone hear me? No? More later. And the reason we are doing this is that obviously we have seen in our work with kids that there has been basically a global problem in that tech has developed, ignoring children and ignoring their established rights that many people fought very, very hard for in the past century. And suddenly we have a new world order and these are being trampled upon. And it's a global problem because young kids are using the same technology all around the world and living very similar experiences and similar risks and similar harms. Luckily, there is a global solution. So global problem, global solution, and we are working towards global norms for tech design to ensure, as I said, that those established rights are taken into account in the digital environment. So today, AI. So what we see is something which is maybe not fundamentally new, but which is supercharging some of these harms and systemic problems that we have already been addressing. And we are looking indeed for, as I say, global standards and a way of addressing this. Luckily, there is clearly a rising understanding and convergence of what we need to do and political will, rising political will to address these issues, in particular for children based on their established rights. How are we going to do it? Well, I am very, very pleased to today be joined by a very distinguished panel of experts and also young people who can help us define some of the things that we need to take forward, in particular, as this event is an official preparatory event for the Paris AI Action Summit. And so we are looking for tangible, practical solutions to the issues we face. I am going with that to hand over for some opening words to our first speaker, Nidhi. Now, Nidhi is a Five Rights Youth Ambassador, 16 years old, from Malaysia, and there she is. Hello, Nidhi. It's lovely to see you with us today. Nidhi is a very passionate advocate for children's rights in the digital environment, has represented children and Five Rights around the world, including, I think, previously at an IGF. Nidhi, so this is your second time at the IGF. Welcome back. Nidhi is also an author. She hosts her own podcast and is also one of the hosts and the first host of the Five Rights Youth Voice podcast, Check This Out. So with that, Nidhi, over to you. Tell us from your perspective, what's happening and what needs to be done.
Hello, everyone, and thank you, Leanda, so much for such a kind introduction. I'll repeat, my name is Nidhi Ramesh, and as a child rights activist in the digital space, I'm so honored to be here today and to be able to share my views and opinions on how AI impacts young people like me all over the world and what I believe we can do to ensure its responsible use. Before I begin with my own experience, I think it's key to highlight that AI is on every single platform, mobile application, and website that we all use. When someone says AI, the first thing one might think of is about generative artificial intelligence, Gen AI, apps like ChatGPT, Copilot, Jasper AI, Replica, and many others. We live in a world where AI is everywhere, but most of us can't even tell when we're interacting with it. Whether it's through social media algorithms, voice assistants, or personalized learning tools, AI often works in the background, shaping our decisions and experiences. Many children don't realize that most of their interactions with the online world might actually be through various AI algorithms, making choices, recommendations, and even decisions for them. What's even more concerning is the misuse of AI by tech companies that put profit above children's safety and privacy, from recommending harmful and addictive content to collecting data without consent. Many AI systems operate without safeguards for young people. Most children don't even know they're being exposed to these algorithms, let alone how to protect themselves from potential harm. That said, I don't want to paint AI as the villain. AI, when implemented in platforms and used responsibly, has incredible potential. In education, for instance, it's transforming how we learn. AI-powered tools can provide personalized resources, making learning accessible and inclusive. For children with disabilities or those in remote areas, this is a real game changer. But while these benefits are real, so are the risks, and we can't afford to ignore them. One major concern is the erosion of originality. AI is flooding the internet with self-generated content, making it harder to find authentic human-created work. As someone who runs a podcast, I know firsthand how much effort goes into creating something original. My podcast aims to highlight social issues and children's rights in an attempt to spread awareness on topics that are important to me. This also means that I spend a long time researching topics, writing scripts, recording audio, editing, and more in order to publish a full episode. It's a process that takes time and effort. Yet in this day and age, with the click of a button, one can easily find AI algorithms that can use any topic you give it and generate a compelling script in seconds. As well as that, other Gen AI applications like iSpeech, Descript, Murph, etc. use imported clips of your voice to perfectly imitate what you sound like when you give it this AI-generated script. So in a way, these two AI programs can do what I spend hours and days working on in seconds. And while that might seem convenient, it undermines the value of creativity and hard work that we put in. And this isn't just about me, it's about every artist, writer, and musician who's at risk of being replaced by similar. I've also written and published 2 books, like Leanda said, but again, easy for AI to write or create something similar at just a simple command, undermining so many creators out there who want to share their work with people. Perhaps this example is more relevant to me as an individual. However, the risks and problems that arise for AI are still there and need to be addressed, especially the ones I mentioned at the start. So what do we do about this? How do we ensure that AI works for children and not against them? I believe policymakers and tech companies have a huge role to play. First and foremost, we need stronger laws and regulations around AI governance on social media platforms like Instagram, TikTok, and Snapchat. These systems must prioritize data protection and privacy, especially for children. Young people deserve to know when AI is being used and what information it's collecting. Transparency isn't optional, it's essential. We also need AI systems designed with children's well-being at their core. This means algorithms that promote safety and mental health rather than exploiting vulnerabilities for profit. Tech companies must be held accountable for the impact their systems have on young minds. Baroness Stephen Kidron and 5 Rights, the organization I have the huge honor of being a part of, is currently working on designing and bringing together more regulations on this, which I'm sure will be discussed later as the panel continues. So I'll leave it there. Thank you.
Thank you so much, Nidhi. I should have just let you go from the start because you say it so much better than I ever could. I hope you'll stay with us because I'm sure our audience in the room and online will have questions and would like to interact with you more afterwards. But we are going to move on to our second panelist, Dr. Jun Zhao, who's joining us from Oxford. Hi, Jun. Great to see you. Dr. Jun Zhao is a senior researcher in the Department of Computer Science at Oxford University. Her research focuses on investigating the impact of algorithm-based decision-making on our everyday lives, especially when it regards families and young children. For this, Jun takes a human-centric approach, focusing on understanding users' needs in order to design technologies that can make a real impact. Jun currently leads the Oxford Child-Centered AI Design Lab and a major research grant examining the challenges of supporting children's digital agency in the age of AI. So, Jun, thank you for joining us. Can you tell us what's the research telling us then about the impact of AI on children?
Well, thank you so much for the introduction, Liana. Can I just confirm that everyone can hear me all right? I presume that sounds all right.
Thumbs up, Jun.
All right. Okay, so I got some slides prepared. Can I project them? Can people see that? I'm also very happy just to talk about the research.
See them, Jun.
Right. Okay. Well, thank you very much for inviting me to be here. I wish I could be there in person, but I'm very much with you, all of you guys in spirit. It's shocking to hear Nidhi's talk and presentation and how much it resonates with our research evidence. As Nidhi said, AI is everywhere in children's life, from the moment they were born and to the education systems they would be using at home or at school. And we see a very similar number of wide adoption of these technologies if you look at the survey in any countries. And also, as Nidhi said, AI, the rise of AI, children are rapidly embracing these new technologies. Our recent survey in the UK shows that children are twice as likely to adopt these new technologies than adults. And an earlier survey by the Internet Matters also shows that there's such a huge proportion of children in the UK are using Gen AI technologies to help with their schoolwork. So it's really exciting. And, as Nidhi said, there's a lot of great, exciting opportunities, especially AI could be used to support children with their learning, children with special education needs, who needs actual support with their social emotional management. We also see some really exciting examples to see how AI could help children, providing them with better health opportunities, early diagnosis of autism, which is an issue in many countries in the world. But also, we must be cautious about how all these technologies may or may not have been designed with children's best interest in mind. So this is the slide showed a recent research we did last year, where we did a systematic review of about 200 pieces of work from the human-computer interaction research community, which is a community pride themselves in designing for human in the heart of the design process. And we try to analyze how AI has been used in different kind of application domains for children. It was quite interesting to see how education and healthcare has been the most dominant application areas, as well as interestingly keeping children safe online. And now we looked more closely into the range of personal data that's being used to feed all these algorithms. And we were quite surprised to see the diverse range of really sensitive data, like genetic data, like behavior data, could be routinely used by all these AI systems, but not necessarily with full consent or assent from children, or even necessary for the function of those applications. And it's also interesting when we did a review of all the current AI ethics principles out there last year, and we tried to do a mapping of all these recommended ethical principles to the actual implementations. And as everyone can see in this diagram, it's a very sparsely populated table. So even basic principles like privacy, like safety, like meeting children's developmental needs are rarely considered comprehensively in all these applications that are designed for children and often in a very critical area. So this is quite concerning to see how principles are applied in experimental settings. And it's even more concerning when we see practices taking place in real-world cases in commercial settings. So this is quite an old report from 2007 with the early rise of smart home devices, smart toys. Researchers have identified very quickly serious implications, the safety risks associated with these cute cuddly bears. But, 7 years on, many legislations have been developed since then, but it was quite interesting to see so has the rise of the variety of IoT devices and smart home devices. A recent study by us, as well as many other recent studies, have shown that children's data can be collected by all these devices, even when they are online or offline. As one recent privacy conference confessed, individual children probably won't experience negative consequences due to toys creating profiles about them. But nobody really knows that for sure. So here is another example to see, similar to the biases adults would be subject to, children can also be exposed to unfair decisions by AI systems, simply due to their race or socioeconomic status, but often probably with much more lasting effects in critical situations such as criminal decision making. Rapid development of AI is often associated with rapid deployment, but ironically, not always with sufficient safeguarding in the process of design. For example, when chatbot-like technologies were deployed by Snapchat last year, some serious risks were immediately reported, exposing children to inappropriate content and contact, even when they declared their only age of 13 or 15. So another thing that is quite interesting in our research is we found that although a lot of risks like privacy and safety have been extensively discussed in existing AI policies, the exploitative nature of AI algorithms has been rarely discussed. When we began our research with children's data privacy, we began with the experiment of analyzing third-party data tracking behaviors of over 1 million apps from Google Play Store. One of the most shocking discoveries we found from this study is the prevalence of data tracking existence with the cute apps used by children, often very, very young children, when they learn how to begin their handwriting, how to pop a balloon so that they can develop their fine motor skills. This is such a direct violation of children's basic rights and their vulnerabilities. So 7 years on since our initial research, what has happened, GDPR happened. We repeated our study. It was quite interesting to see that the tracking behavior did not change immediately at the enforcement of legislation. But what did happen is the App Store has made it extremely difficult for us to repeat and continue our data analysis. But what we haven't stopped is to continue asking the question, why all this tracking of children's data and how we can better protect them. It's interesting to see this recent study published earlier this year, where it provides even more firm evidence about the exploitation of children's data. The proportion of large social media platforms rely on children's attention for their advertisement revenue. So just like Nidhi said, these companies are not designing with children's best interest in heart, but their market gains. Several recent studies have made similar findings showing that recommendation systems can actively amplify and direct children to harmful content. For example, here the studies have shown that children identified with mental health issues could be more likely exposed to posts leading to more mental health risks. Harmful content is prioritized because it's more attention grabbing, invoking stronger emotions, and prolong children's engagement. So many of these studies are actually conducted through simulations because researchers do not access to the platform APIs or the code of the algorithms. But what happens when we talk to the children directly and ask them about their experiences? This is one of the studies that we conducted last year, and the message is consistent with many other research studies out there. Children found the experience very passive and disrespectful. And many of them find it unfair that systems can do this to their data and manipulate their experiences. And while such feelings of being exploited and disrespected can be hard to quantify, we must not neglect how these feelings are fundamentally disrespectful of children's rights in many ways, and how the same algorithmic practices could cause different degrees of harm for children of different developmental stages or vulnerabilities. And I'll just leave the evidence discussions here for now and for other speakers, because I think the fundamental phenomenons we have lots of evidence for the fundamental phenomenons, but it will be quite interesting to hear that how the recent EU AI Act could or could not provide the much needed protection that we need for children of this generation. Thank you very much, Liana.
Thank you so much, Jen. I am going to step over here, so I'm in frame. Thank you so much for that presentation of some of the overwhelming evidence. And I think if you had a little bit longer, you could have said an awful lot more. I'd like to also point people to some of the research done by Five Rights. I have Disrupted Childhood here, which sets out some of the basics of persuasive design, and also the pathways research using avatars shows very clearly how algorithms drive children to very specific harms. And of course, there's plenty of evidence from a number of court cases as well of children who to talk about the AI Act. And I am delighted to welcome the Honourable Member of the European Parliament. Maybe we're over here. Is that? No, apparently the camera needs to see you. So yes, so Mr. Brando Benifei, who was co-rapporteur of the AI Act in the European Parliament and currently chair of the Oversight Monitoring Group. So absolutely critical role to make sure that the AI Act delivers, and co-chair also of the Child Rights Intergroup in the European Parliament. We're absolutely delighted to have you here.
Yeah, I'm really happy I can be here for this opportunity. I'm sorry that due to the overlapping with another meeting, I have to attend because of the Parliament program. We have a good delegation here. I will need to leave soon after my intervention. Maybe if there is one question I can answer, but otherwise I will let the panel continue. But I want to thank Five Rights Foundation also for the extremely useful contributions that were given during the drafting process of the AI Act. The original text from the European Commission was unfortunately lacking completely the dimension of child protection. It was not there at all. So we had to bring it in with amendments from the European Parliament, with our drafting work and the negotiations that followed. So we have some specific dimension of child protection inside the AI Act, not as much as we wanted, but there are also some more general provisions that can be applied effectively, if we want to apply them effectively, on the cases that we just heard of. That's why it's important that now the Parliament, in the new mandate that just started just a few months ago, both confirmed the existence of the child intergroup, children's rights intergroup. As I said, I'm now I will be the vice chair for that. It starts its work now in the new mandate, and it's important because it's a very important forum to bring together all the MEPs that from different perspectives, all the parliamentarians that want to work on children's rights. And we confirmed a monitoring group of the AI Act. So after approving the text, now we are following step by step its application. It will be crucial because some of the issues that you have been already talking about with the previous speakers are to be checked in the way they are applied. For example, in February 2025 already, we will see the full mandatoriness, the full application of the prohibitions. That is a very important aspect of the AI Act. And among the prohibited uses, there are also emotion recognition in the study places. We wanted to avoid that, to in fact enter into a form of pressure and intrusion on children in schools. So this is one aspect, for example. But then also predictive policing that can target minors from certain minorities will be prohibited. And also we prohibit the indiscriminate use of AI-powered biometric cameras in live action in a way that will prevent forms of surveillance that can also infringe the privacy and the protection of children. And we, for example, prohibit also the facial scraping on the internet. So that's something that is used to in fact, prepare generative AI or chatbots to commit some of the abuses that we have seen. And we are trying to protect this data. But also, apart from the prohibitions that will kick in soon, we have very important transparency provisions that will be quite important, looking at the generative AI. And for example, we demand specific protocols by the generative AI developers to contrast the capabilities of these systems to have this kind of inappropriate conversations that we have seen, that has been exemplified earlier, and the production of inappropriate content that can be offensive for children. This is something that needs to be entrenched in the way the system is trained, and it's limited and needs to be checked periodically. But also, we want to label AI-generated content. This is crucial to fight another issue that was not very much touched until now in this discussion, which I think it's very important, is fighting cyberbullying, cyber mistreatment of children, which is a very important source of mental disorders, of attacking mental health. And in fact, with the new systems of generative AI, you can have a totally new level of extremely damaging cyberbullying of all kinds. And this is something we also need to tackle by avoiding the production, but when the thing is there, at least it needs to be clear that this is not true, that is fake, and so people cannot be induced to think that a person is doing or saying things that will make them feel ashamed and have mental health problems. And also, finally, I want to underline that this work, I could make also more examples about how the AI interacts, but I want to concentrate on the fact that this interacts also with Digital Services Act and with the child sexual abuse material legislation that we have been developing, that has been pushed forward by the European Union, and we think that the ecosystem needs to work together. As I said, I'm the specialist of the AI Act. I've been working on that. But in fact, you put that together with Digital Services Act, with this new legislation on child sexual abuse, and you can build a proper framework of protection. And in fact, we want to continue a global dialogue. We are working on that. I am doing that with different governments and parliaments so that we can build a common framework of action. And that's why it's very important that civil society foundations, organizations can build links that are not only between the governments, but also in civil society. And I insist that the parliamentarians have to do their part. Here, it's important that we have the IGF parliamentary track that also dealt in one of the discussions about these topics, and we need to continue developing in this direction. We hope we can give some good practices by the application of this legislation, but clearly we need to continue learning from each other and building together an apparatus of actions and legislation, soft and hard laws that can protect our children online. Thank you very much.
Thank you so much, Brando. I know you have to leave. Do you still have time for another question or anything from the room? Okay. Does anyone have a burning question, Mr. Benifei? I would have lots of questions, but I'll have to keep them.
Well, my name is Peter Zanga Jackson Jr. I'm from Liberia, from the regulator. Firstly, thank you for the explanation you gave, but I want to ask you, because the child that we are talking about, they are from the family, and the family is the fundamental of that child. They are in some homes, there's no check when it comes to the child being on the internet. Some family, no monitoring. So don't you think there should be an awareness? Firstly, educate the families as to what they should do to limit their child or children to some extent before going to the next level of trying to detect giants that develop all of these AI into order. And so my concern is more on the family. What do you think the family can do as a father to protect their children, but to protect our children first? Protection of our children should start from us first. Yeah. Before we go outside to find solution. This is my question.
Is it working? You can hear? Okay. So just to answer very quickly on this, I think it's a very important topic because um, uh, we need families to be ready to do their part in this education because it's not only about laws, obviously, I concentrated on that, but it's also building a culture. And this means you need to give the instruments to the adults to be able to have a informed conversation with their children. So I don't think we will solve everything by giving instruments to the adult population. We need schools, we need the formal education targeted at children through the institutions. But obviously, if we have a more conscious population, also of the older age, that is not digital native, that needs to be trained, then they can also transmit to their children some basic foundational elements on how you can be healthy and protected and conscious and not be manipulated while you are using new technologies, AI, the internet. So yes, we also need the families to be on board. And we cannot solve everything with that, but at the same time, without investing also in the families, I think we are missing an important piece. I completely agree with you. Thank you.
Thank you. Thank you very much, Brando. We wish you the best of luck in overseeing the AI Act implementation. And we'll be telling you about what comes from this panel, which is relevant to that later. And I'd just like to say, our friend left the room, but I'd like to say that the European Parents Association was very much behind a lot of the work done on the AI Act. They have been big drivers of this. Now, over to our next speaker, Dr. Ansgar Kiner, who is AI Ethics and Public Policy Regulatory Lead at Ernst & Young. I probably made your title even longer than it actually is because it's already quite long. So Ansgar, we are delighted to have as a trustee of the Five Rights Foundation, is our vice chair of our board, and an absolute expert in AI and working a lot on the technical standards that are needed for, among others, the implementation and enforcement of the AI Act. So Ansgar, we're going to hear from you a little bit about the status quo in terms of what we have to get this kind of regulation and also things like the AI Convention and the framework that came from the UN a few months ago. So there are a few things, the AI Act being maybe one of the most powerful ones there. So a few words from you. What we'd like to hear about is indeed, what is the status quo in terms of actually making this real? What's missing? Where do we go from here?
Sure. Same check as everyone else. Can you hear me? Okay, good. So yes, we're definitely in a very interesting period with the introduction of new international charters like the Council of Europe's Charter on AI, legislation like the AI Act, but also various other initiatives in other jurisdictions that are pushing either through mandatory obligations around safeguards for AI or are putting on the table an expectation from the regulator that they're saying, we expect you to follow voluntary codes around responsible use of AI. And certainly we have seen, if we look at the types of organizations that you are with, that the introduction of these types of regulations has pushed forward the level of engagement, the level of resources also that are provided within organizations, be it public or private sector organizations, to actually and make sure that if we think especially about the way in which these types of regulations apply and have are got as they are AI. There is a large challenge for a lot of organizations. There is a large challenge for a lot of organizations, similar to what we've seen in the platform space, that the organizations are often not quite aware to what extent what they are doing actually impacts on children. Similar as what we've seen with social media platforms and other online platforms, that when they created the space, they were building the space not with children in mind, they were building the space with adults in mind, even though in reality we know that a huge proportion of the users of these platforms are children. They did not even conceive that this is something that they need to be building for. And a similar challenge is in the AI space, especially as in the AI space, as it is moving to a model where we have creators of the core AI models, LLMs being a prime example of that, being separate from the deployers of the AI models that then integrate them into their systems, that there is a disconnect between those who have the capacity to actually understand and do something about compliance, also compliance with regards to aspects regarding children, that they're different from the ones that are directly facing the users. And even often those that are directly facing the users are not sufficiently tracking and aware of who exactly their users are. So if the AI Act asks for, prohibits a subliminal manipulation of vulnerable groups, but the deployers and especially the providers are not even aware that young people as a vulnerable group are a user of the platform, then of course they are challenged in knowing whether or not they are subliminally manipulating them or if they are having a negative impact on them, and they don't even understand what does a negative impact on young people mean. This reflects then on some of the work that has been happening in the standardization space. So last year, the IEEE published a standard, which Five Rights was a prime contributor to, the IEEE 2089 standard on age-appropriate design. And one of the things that that standard actually asks for is that organizations, as they are engaging in the design and development of AI systems, that they have people within that development process who are subject matter experts with regards to the impacts that these systems can have on children. So that there is someone at least involved in the process that thinks about how could this kind of a system impact children? What are the potential challenges, the potential negative impacts that could arise if someone under 18, let alone someone under 10, is using these kinds of systems. However, the standardization space is also still very immature. It is a space that is still very much in flux, in development. If we think, for instance, around the standards that are meant to provide the clear operational guidance on how to become compliant with the AI Act, all of those standards are still in development. The European standards bodies, CEN and CENELEC, are rushing to try to meet the deadline that the AI Act has set to be able to provide these standards. And because they are rushing, they are focusing at the high level, horizontal level. There are very few contributors that can really add an understanding as to the particulars that are necessary to address concerns regarding children. Five Rights is participating in the process, but there are multiple standards being developed simultaneously. It is highly challenging to be contributing to all of these at the same time, to make sure that the risk management standard considers the risks to children at the same time as the trustworthiness standard considers what does accuracy, what does robustness with regards to how children might use an AI system actually mean. So the technical space around how do we move from a high level intended outcome, which the regulations have specified, into an operational, what do you need to do on the ground to make sure that the systems work to meet those requirements is still a space that needs a lot of support, it needs a lot of work. And as I've said, there is even the core challenge that organizations need to be aware that they even need to consider how children might be impacted by these systems as they're deploying something, a new chatbot, as they're deploying AI as part of a system for targeting advertising, as they're using AI as part of something like a fitness app or something like that. They're generally not building it with children in mind. And so it is a space that is dynamic. It is a space that is moving in the right direction to the extent that it has been integrated in the AI Act, for instance, as Brando mentioned. However, because there are so many new things, new compliance activities, new thinking about what does responsible AI actually mean, all happening at the same time, while there's also a huge rush to try to find new ways to actually get a return on investment on these, that there is a huge risk that the particular concerns around children will fall between the cracks if we do not raise enough awareness about this.
Thank you so much, Ansgar. I think we're going to have our last intervention and then engage in a discussion, if that is okay. This one's not working? Is it working? Okay, great. Thank you so much for that. Indeed, I think it's absolutely critical that, law is already something, but we need to get down into the weeds to get those technical frameworks in place, because otherwise companies can say things like, oh, well, we didn't know that we were exploiting children's vulnerabilities. We didn't know that children were there. We are not designing for children. Why do we need to cater for children? The reality, of course, I mean, I'm being a little bit provocative, but the reality, of course, is that many of the biggest companies, at the very least, are quite aware that children are a massive market. They are targeting children as their current market and their future market. So, of course, it's a little bit disingenuous, but until we get all of that detail in place, then that is a game that we will be playing. So, absolutely critical. Thank you so much for that. We have just our last intervention online from Baroness Biban Kidron, who is the chair of Five Rights Foundation. Baroness Kidron is a member of the House of Lords in the UK and was the architect of the age-appropriate design code. Baroness Kidron has been a long-term advocate of children's rights and is currently working on an AI code, which hopefully will feed in to some of the things that we've been speaking about. So Baroness Kidron, over to you.
Without having to stick heavy instruments on their paper-thin chests. Terre des Hommes, a fellow children's rights NGO, recently launched an AI chatbot to support children's access to justice. Or a few months ago, I met a wonderful group of 14-year-old girls who built an app to teach sign language to hearing classmates so that they could all communicate with their deaf peer. There is no doubt that AI holds immense potential. But like any technology, AI must be developed with children in mind. And I do want to emphasize that it's a design choice if recommender systems feed children alarming content promoting eating disorders or self-harm. It's a design choice if AI-powered chatbots encourage emotional attachments, which may, in some cases, have led to children taking their own lives. It's a design choice if cynically some of those chatbots revive deceased children through the creation of AI bots imitating their personalities, re-traumatizing their families and friends, and creating a loop in which self-harm or suicide is valorized. As children point out to us repeatedly, we are all increasingly interacting with AI systems without even being aware of it. It occurs across all domains of life, from education to healthcare, picking the ripest tomatoes for baked beans. Few would argue against the efficiencies or learning from AI and big data, but putting systems into the wild in a gold rush for AI dominance, or where governments using AI to streamline public services is not instead of meeting the needs of children, it must be as well. For example, if making welfare decisions based on the understanding of AI results in children going hungry because of bias in the system, that is unacceptable. And while that seems obvious, that has already happened in 2 countries, to my knowledge, and may well have happened in many more. Thinking ahead, designing systems that consider children by design and default is how AI, just like any other sector or business, must be developed. The perverse incentive structure in which companies have responsibilities to shareholders but not their users is reflective of similar battles about technology in the 19th and 20th century. What is happening now is regressive and harmful to children. As the IGF's agenda clearly shows, AI is a highly topical issue today and will continue to be so into 2025. So before continuing, I want to dispel some of the pervasive myths. First, AI is not new. The first mathematical model for neural networks dates back to the 1940s. The term artificial intelligence was coined in the 50s. AI systems are a continuation of algorithmic and automated systems, which we have some experience of. This also means that AI is not too complicated to understand, and it is not too complicated to regulate. Secondly, not all AI is equal. Generative AI systems are different from those based solely on machine learning, and artificial general intelligence, though still theoretical for now, is wholly different again. This is important because we're increasingly seeing generative AI deployed in situations where it's either unnecessary or could be harmful, tackling tasks that could be automated through other specialist AI or even non-AI approaches that are more accurate and energy efficient. The choice of model should be based on necessity and proportionality, and we must be clear in our use of language to make sure AI remains understandable. Thirdly, AI is not the problem. Technology is generally speaking neutral, but business models and business practice is not. If tech companies seek to maximize their profit without our insisting on their observing children's rights and well-being, then they privatize the wealth and outsource the societal cost onto the shoulders of children. And I must say here that although when we say the word children, very often the image of a teenager umbilically attached to their phone comes to mind, but the children who are paying the cost are from the very youngest, pre-verbal ages, whose language and development is hindered by over-reliance on digital products. Good morning. Who increasingly I regret not being able to be with you in person at the Internet Governance Forum today. The children. This session is officially accredited as a preparatory event for the AI Action Summit, and I'm delighted that today's conversation will feed into those which will take place in Paris in February. Say that their lives are dominated as Nidhi and Yun will have shared, it's crucial that we develop artificial intelligence and other automated systems with one eye on how life will or loss of life at worst. Children. Finally, the possibilities and perhaps most infinite. I was very moved when I saw an AI system that in real time could monitor a preterm baby heartbeat without having to stick heavy instruments on their paper thin chest. Terre des Hommes, a fellow children's rights NGO, recently launched an AI chatbot to support children's access to justice. Or a few months ago, I met a wonderful group of 14-year-old girls who built an app to teach sign language to hearing classmates so that they could all communicate with their deaf peer. There is no doubt that AI holds immense potential. But like any technology, AI must be developed with children in mind. And I do want to emphasize that it's a design choice if recommender systems feed children alarming content promoting heating disorders or self-harm. It's a design choice if AI-powered chatbots encourage emotional attachments, which may, and connection, in some cases, have led to children taking their own lives. Earlier this year, I was delighted it's a design choice. The Alan Turing it's cynical that mapped some of those the current legislative revive deceased children through the creation of AI bots, imitating their personalities, re-traumatizing their families and friends, and creating a loop in which self-harm or suicide is valorized. Their work provides, as children point out to us repeatedly, one of the most important projects I've been involved with over the last year, which is to build on the global consensus that children deserve our consideration, and working hand in hand with global experts right across domains and fields, we have together developed a proposal for a code of conduct for AI systems that impact on children. We will be launching the code in the coming months, and it will provide a clear and practical path forward for designing.
Dear host, I don't know if you can hear me, but if you can allow me to share my screen again, I can restart the playback.
I'm so sorry. It seems to be either a choice between online people being able to see and hear and us being able to see and hear. Why don't we give that a moment? I think there were some questions, at least the ones from the room. I'm not sure about the ones online at the moment, but let's come to that and see if we can get the end of Baroness Kidron's intervention in a minute. Jutta, you had a question or a point to make.
Yes, Jutta Koll from the German Digital Opportunities Foundation. I had the honor to work with Five Rights Foundation in the working group on General Comment number 25. And I really appreciate what we heard from Biben, also what we heard from Ansgar. But at the same time, I'm a bit disillusioned because I think it's 10 to 12 years ago when we really talked to tech companies about the concept of safety by design. And that was, although we had artificial intelligence at that point of time, it was not in the hands of the children in the real way. So I would have expected that this principle would be in the standards, would be in the hands of developers to be adhered to and to take in consideration that children, it was obvious throughout all the developments. I would say when the internet came up, it was not designed for children. So it was, maybe we were then going behind that and say, okay, now we have this idea of safety by design, have in mind that children probably will be users of the services, of the devices, and so on. And now we end up several years ago with AI and the same situation that we had before with other technology, digital technology. Ansgar, maybe you have an answer to that, not to disillusion me?
I fear that my answer is not going to be something that will remove your disillusionment. The practice that we are seeing is a rush to compete, to bring things to the market. And in that rush, it remains the case that the so-called functional requirements, that is to say, the things that need to be there in order to produce the type of output that they want to create, get the prominent sort of the investment, and the so-called non-functional, this terminology is terrible, requirements such as making sure that there will not be negative consequences, especially to specific groups, are marginalized in the design process unless there is a significant factor behind it, such as the risk of a huge fine. That is why, even though we've seen discussions around responsible AI principles for many years, there was always a lack of investment to really get it implemented. There was often the case of technologists within the company saying this is something that we should be doing, but they were not being given the resources to actually do it. Until now, there is something like an AI Act where if you don't do it, you're going to face fines. Now suddenly there is an investment in doing it.
This is okay? It was your voice. Okay, maybe we'll get Baroness Kidron back and also our other speakers online. But in the meantime, oh, wonderful, we can hear. I hope that's current and not right from the beginning when they couldn't hear. But in the meantime, do we have any other questions or comments from the room? Otherwise, I will go to ones online too. And I have to say, Jutta, I totally agree with you. It's taking far too long. And as I said a bit before, it's a little bit disingenuous because we do know what the issues are and we've known for a long time. Let's go over to Lena.
Yeah, thanks so much. And it's just such good work that you're all doing.
For the AI Action Summit, and I'm delighted that today's conversation
How about this
will
one?
feed into those which
Because
will
the
take
video is
place
playing.
in Paris in February. As Nidhi and Yun will have shared, it's crucial that we develop artificial intelligence and other automated systems with one eye on how it will impact children.
Yeah. Okay. I mean, I also feel as though we've known the issues for a long time, and the only time that the tech companies have changed is when they face fines or penalties or litigation. And I'm just curious because there's people from other countries in the room as well, and I'm wondering, Five Rights has been doing some work globally. You know, are we seeing the same conclusions in terms of the ability of other countries to
can just talk without the microphone in the room.
Very convenient, but easily being handled. Where are you from? Originally I'm here, and actually I'm neuroscientist, neurocognitive brain science. Okay. We are a little bit diverted for new AI applications. Oh, great. Anyway, but this is a big because I'm more interested in the future, big.
Do you use the microphone there because otherwise they can't hear you online?
No, it's
I was no. No, I was just curious to hear if there was others in the room who were also finding similar issues. Is there a sense from other countries that they also need to get in line and have some really robust regulation, like we heard from the experience in Europe? It's just an invitation for others online or in the room. The work that I do is also aligned with Five Rights with the Council on Tech and Social Cohesion. It's trying to regulate the upstream design features that lead to these kinds of harms and also polarization.
Thank you so much, Lena. I'm so sorry because I was only half listening, and afterwards you're going to tell me that again because I think I want to know. Does anyone or else, we also have online our speakers, Jun and Nidhi. If you'd like to come back on anything that you have heard, please wave or put something in the chat, and then I will see it and bring you in. Otherwise, is there anything else from the room? I have a question online. Okay, so I have a question online from Dorothy Gordon from UNESCO, who's asking how involved are consumer rights organizations in working to get major tech companies to stop abusing children's rights in this way? I believe we need consumers to deliberately avoid using dangerous products. So that's public awareness and almost boycotting, I guess, or consumer organizations can do other things like submitting complaints and things. Ansgar, do you want to take that?
I'm afraid the only part that consumer rights organizations are doing in this space that I can really speak to is that, yes, we do have, at least in Europe when it comes to the standardization for the AI Act, we do have participation by the consumer rights organization, ANEC, in helping to make sure that consumer concerns are taken into consideration as these standards are being developed. And this is a very valuable contribution by a non-industry player. I'm not aware as to the activities that are being done regarding educating users as to the impact that these types of technologies may have on them, and therefore to try to help them make a informed choice as to whether they want to use these tools. Obviously, there are NGOs that are working on these types of things as well. Mozilla every year has before Christmas some activities around which digital tools may be spying on you, etc. But they will only reach a particular subsection of a population who are genuinely already interested in this space. I imagine this is a space where we also need support from public sector to do larger public interest campaigns to help people better understand this. Who has the resources to reach the whole population as opposed to only people who already are looking for this kind of information? I think that is going to be a big question.
Thank you, Ansgar. I'm going to take the liberty of going slightly lower tech and giving you some of Biban's remarks that I have here so that we don't miss everything and so that the people online can hear them too. I'm sorry it's not in her voice, which is far more eloquent than mine. I'm going to jump in a little bit halfway through. I think we all heard the beginning. But her main points. Firstly, AI is not new. The first mathematical model for neural networks dates back to 1943, and the term artificial intelligence was coined in 1955. AI systems are merely a continuation of algorithmic and automated systems which we all have experience with. This also means that AI is not too complicated to understand, and it is certainly not too complicated to regulate. Secondly, AI is not unitary. Generative AI systems are different from those based on machine learning and artificial general intelligence. Though still theoretical for now, is wholly different. Generative AI is currently deployed in situations where it is unnecessary, tackling tasks that could be automated through other specialized AI or even non-AI approaches which are more accurate and energy efficient. The choice of model should be based on necessity and proportionality. And we must be clear in our use of language to make sure AI remains understandable. Thirdly, AI is not the problem. As I've said before, technology carries opportunities and risks, and these risks can continue to exist because tech companies seek to maximize profit at the expense of children's rights and well-being. Trying again? Oh, wonderful. They have privatized the wealth of technology and outsourced the cost to society. I'm actually going to repeat that because I think it's such an important sentence. So tech companies have privatized the wealth of technology and outsourced the cost to society. Finally, and perhaps most importantly, all this shows that AI is not different from previous technologies. Industry lobbies seek to sow doubt and uncertainty to keep authorities from effectively legislating and to prevent citizens from demanding effective legislation. We must not tolerate AI exceptionalism, right? I think that's another very important point. AI is a business. This is businesses we're talking about. It's no secret that adults have so far failed to provide children with a rights-respecting online environment. As AI is not different from previous technologies, the same will happen if we do not act immediately. This is why, over the past year, building on global consensus and working hand in hand with global experts in the field, we have developed an AI code for children. Launching the code in the coming months will provide a clear and practical path forward for designing, deploying and governing AI systems, taking into account children's rights and needs. It's an important and necessary correction to the persistent failure to consider children, and a vital blueprint for delivering on the commitments to children in the Global Digital Compact and in regulatory advances such as the AI Act. We need from the outset to consider how to build the rights and needs of every child into the design and governance of AI systems. The code, which we will launch at Paris, hopefully, will be for anyone who designs, adapts, or deploys an AI system that impacts children. It is practical, actionable, adaptable, and applicable to all kinds of AI systems. It mandates certain expertise and actions and raises questions designed to reveal gaps and risks. It leaves a level of autonomy to find sufficient mitigation measures. It is intended to support existing regulatory initiatives and provide a standard for those jurisdictions that are considering introducing new legislation or regulation. In the Global Digital Compact, all governments agreed on the urgent need to assess and address the potential impact, opportunity, and risks of artificial intelligence systems on the well-being and rights of individuals. That's a quote. Children represent 1/3 of internet users and are early adopters of technology and have unique rights and vulnerabilities. They must be at the center of our discussions and considerations. I hope I didn't misquote any of that or that she didn't change it in the final version, but you can always quote me because I agree with all of that. I think putting children at the center of the conversation maybe means that in the last few minutes I'd like to go back to Nidhi, if that is okay with you. Nidhi, are you still with us? Could you bring Nidhi up, please? Okay, I don't think our tech people are listening to me again. Could you bring Nidhi, the speaker Nidhi? Nidhi, if you're with us, I'd love to hear your reflections. You talk to, hello again, not only your peers and colleagues all the time, but also our big group of child ambassadors within Five Rights. What are the conclusions that you draw from this, and what are maybe some of the things that you think that you and your colleagues would like to tell us and for us to take forward? can't hear you yet. Oh, Nidhi, can we hear you now?
Yes, hello, can you hear me? Thank you so much, Leanda. That's such an interesting question. And as Five Rights Youth Ambassadors, we often discuss the opportunities and the risks of AI, especially for children and young people. While we see its potential, there are often obviously some key concerns that stand out to us. So one major issue is education. AI can make tasks like research and homework quicker, but it risks taking away from essential learning skills. As one of my peers put it, it's making homework easier, but at what cost to our learning? And we worry a lot about losing creativity and critical thinking, skills we'll need later on in life. Another significant concern is privacy. AI systems can analyze so much about us, even from just a photo or a message. One ambassador shared how AI is amazing and how it can help us, but it's also scary how much it knows about us. Many of us feel uncomfortable with how much information we're unknowingly sharing, especially when we're not informed about how it's being used, like how I mentioned earlier during my first intervention. We've also talked a lot about the psychological risks of AI. Systems designed for companionship, for example, might seem helpful, but in the long term have a lot of consequences. As one of our ambassadors said, it's about more than just technology. It's kind of about our values. Relying on machines that mimic empathy could affect our real world social skills, especially for vulnerable young people. And of course, there's the growing threat of deepfakes. Marco, one of our youth ambassadors, summed it up well by saying that AI tools are developing and deepfakes are becoming scarier, and it can ruin people's online footprint. So to sum it up, while AI brings immense opportunities, it's these educational, ethical, and privacy-related risks that concern us the most. And it's crucial that AI systems are designed to protect young people with a lot of safeguards that prioritize our rights and well-being.
Thank you so much. Thank you so much, Nidhi. It's always wonderful to hear from you and from your fellow youth ambassadors. I hope that the code that we'll bring out is something that will serve you. But we are going to get your direct feedback, of course, on it very soon. We really hope that that you will find some of the elements there to address some of the things that you have that you have brought up. We have 2 minutes to go, and we have had a very eventful session, I would say. But I don't know, Jun, if you're online, if you want to come back with any closing words?
Hi, Liana. Can you still hear me all right?
We can.
Oh, fabulous. Fantastic. And what a fabulous session. I tried to come in a few times, and I think it got confused a few times when we were trying to manage the video and hybrid attention. And what I just want to really try to come in is about two things: the discussion about safety by design and parents' role in all of this safeguarding children. I think I agree with Ansgar's point. I think we are definitely moving towards the right positive direction, but it's a really challenging domain. I know there are a lot of Gen AI companies are embracing the safety by design principles and trying to integrate that really actively in their design and development process now, which is really encouraging to see that. It's especially they're taking that perspective from children. But it's very complex because the risks are quite diverse. I agree with what Aska said. Some of the companies may not be aware of some of the risks for children, but I think some of them do. But at the same time, there's a challenge because the diverse risks, some of them may not seem having direct impacts or immediate safety risks for children. Like some of the risks that Nadine raised, like exploitations, manipulations, they may not seem having any immediate harm, but they are harmful nevertheless. So it will be quite interesting to see in the next couple of years when the EU AI Act, as well as many other acts come into place, how all this understanding about various forms of risks and harms are going to fare out in the legislation enforcement, and how we can all work together to facilitate better awareness, better translation from policies into practical guidance, so we can create a better AI world for our children and our society as a whole. And I think that's all I got to say, Liana. I hope that way we can finish on a positive note and something exciting for us to look forward to in 2025.
Much, Jen. Indeed, there remain outstanding questions, but as you have said, there's still plenty going on. We do have 2025, lots of things that we can deliver on, and I think I would just like to reference maybe at the end that in the UN framework, and we're here under the UN's umbrella, governing AI for humanity, there was a very, very clear point, which is that AI must not be experimenting on children. AI might be, in some ways, some aspects of it, we might be using it in new and novel ways. But we can innovate all we want, but this is something where we know that our children are too precious and grow up too fast, and their education, as you said, Nidhi, even impacting your education. We're talking about, the generations on the future. We must not be experimenting on children, and this is what we will take to the Paris summit with all of this input. And we hope that all online and in the room, you will come behind us and have a look at this code and see how it can be bettered, improved, so that it can deliver on these issues for kids. Thank you so much. I'd like you all to join me in thanking our panelists for this very rich discussion. I'm very grateful for your patience in particular. Thanks so much.
Thank you so much for such an amazing session, Leanda.
Thank you, everyone.